Hey y'all, I'm Ada K. And I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Good morning. Good morning, everybody. Yes, hopefully the last day, at least of the trial phase of the Sarah Boone murder. Ooh, my hearing aids are hot. Ooh, that mowed better. Thank you very much. I'm coming on quickly, and we're going to go diving in right now because why? We have court documents. First of all, Ada Kate, thanks for joining me so much this morning. We are going to go straight into the Sarah Boone docs because, y'all, this is important. Very important. Okay, so let me get me off. Let me go. Oh, no, that ain't going to work, is it? That may. That'll have to work for the moment, but we're going to go ahead and read these documents real quick. While we do that, I hope that you guys are, there we go. That's not what I wanted. There we go. I hope you guys are having a great morning. We're going to hop on into this, and what we're going to do, I'm going to move this over here and hop that back up, is we're going to read and go through these, dag nabbit, I just lost them. We're going to go through these documents, and we're going to get those up and going. 3 and 4, there we go. Just trying to move things around so I can find you guys. Here we go. Back to the wheelhouse again. Got it. So what we're going to do is we're going to read these documents and go through them until trial starts. And then, camera hearing. Share. What the heck happened to my... Oh, there it is. Okay. Yay. I hope y'all can read this. The state requests for an in-camera hearing regarding financial arrangements between the defendants and the defense team. Here we go, guys. This is what I've been waiting for because there were financial arrangements and people keep saying, nah, there wasn't any financial. Everything's pro bono. Oh, no, it wasn't. So let's talk about this. Comes now the state of Florida, by which the undersigned assistant state attorney and the state alleges the follows. The defendant is indigent. She had several appointed lawyers prior to forfeiting her right to an appointed attorney. The defendant is receiving cost money from the JAC because of her indigency. Okay. Apparently, only investigator Billy Lane, is being paid with the JAC money. The defendant has secured the services of 4. So she's had 13 attorneys overall. Attorneys and a jury trial consultant makes 14, and perhaps more people that the state is unaware of at this time. The defense team is expecting a tremendous amount of costs, having traveled from Milton, Florida to Orlando, Florida for several weeks of trial. The team returned to Milton, Florida prior to the arrival of the Hurricane Milton in Central Florida and then traveled back after it passed, incurring additional costs. The state is concerned about the potential conflict of interest between the defendant and her team. Rules regulating the Florida bar. Oh, y'all. Okay. The only way for the court. Oh, come on. I have to do it. We will go through this. The only way for the court to know if there's an actual conflict of interest rather than potential conflict of interest is to review the financial arrangements between the defendant and her team. If there is an actual conflict, the defendant can waive the right with clear, unequivocal, and unambiguous language. For a waiver to be valid, the record must show that the defendant is aware of the conflict of interest, that the defendant realizes the conflict could affect the defense, and the defendant knew the right to obtain other counsel. The state is requesting the court to conduct an in-camera examination of the financial arrangements to assure that there is no no actual conflict of interest. And if there is an actual conflict of interest, the defendant vividly waived any conflict of interest. Oh, y'all. It's starting out early this morning, let me tell you. Motion for incurring costs for private investigator. The defendant is charged with the second. We all know that. The defense requires additional assistance of private investigator to assist in preparing the defense in this matter, including but not limited to interviews, locating witnesses, locating documents, performing background checks, researching factual issues, and establishing rate for the investigator is $50 an hour with a maximum of $3,750, 75 additional hours. The anticipated cost at this includes the several services of prison break investigator Billy Lane to assist with the investigation task associated with trial, blah, 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 blah. So they're asking for more money. Wow. The first document is the wowza. I'll be honest and tell you that one. Okay. The state requests for special jury instructions regarding the criminal standard jury instruction. We heard that yesterday. The defendant filed a motion to suppress statements which were denied prior to trial. A significant portion of the motion was devoted to whether or not the detectives asked something to the effect of, with these rights in mind, do you still wish to speak to us? He can't get off of that. This is not required by law. Thank you. Oh my gosh, you finally admitted it. However, it is proper for the jury to consider the totality of the circumstance in deciding whether her statements were voluntary or not. Watch the video. She couldn't shut up. Therefore, the defendant raises an issue with the in front of jury, the state requesting instruction to be added 3.9b defendant statement so that the jury understands that they are solely making a factual determination regarding the voluntariness, not a legal one. The comment that is suggested is this. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to the law enforcement after Miranda warnings are read to the suspect. This is, however, one of the factors you may consider in whether the defendant's statements are voluntarily made. 5. This is the correct statement of law that would require to ensure that the jury is not confused by inferring that it was legally required when it was not. Oh, okay. That was by the state, not the defense. So I think Mr. J is filing that because he knows the defense is making a big mess over it. Y'all. Uh, and here's another motion by the defense agreeing with the state. Okay. We will go through these, but the biggest one was the first one. about to make sure that the prosecution let me pull it up again. The state the motion in camera hearing regarding the financial agreement between the defendant and the defense team as to make sure that there is no conflict. Look at the behavior this morning. Now, the prosecution is talking back and forth and nodding their heads. Look how quiet he is. Look at him. He must have told Sarah Boone, "Don't talk to me. Don't look at me. Don't pay any attention to me. I'm in my zone. Leave me alone. I'm in the zone." Good morning, everybody. Thank you for joining. I'm going to have a sip of my fabulous Java. And while I do that, let's have our daily sponsor, my coffee company. Hey, y'all, please help me welcome the Hitchman Homestead Coffee. They are fabulous. They have many different blends of freshly roasted, freshly ground coffee. They have a monthly club where you get 4 bags for $40 or a Keurig option. Also, they just came out with a half and half. Oh my gosh, I absolutely love it. So do me a favor. Go down to the link below at hitchmanhomestead.com. Order you some coffee and show them some love. So with that, we are at the point right now that we're waiting for trial to start. Sorry, slathering on more makeup. Forgot to do my chin. So where are we at right now? Well, we're at hopefully the last day. Good morning, Miss Karen. You are so awesome. Thank you so much for joining. I had a document fairy drop this morning. Thank you, Miss Ronnie. Appreciate you. Sorry. Love and appreciate you this morning. It has been a week, y'all. I have some more news to read to you. There was a woman who had spent 43 years behind bar for a life sentence. And I saw a documentary about her. Her name is Sarah Hemme. And we got news today. A woman who had murder conviction overturned after spending 43 years behind bars is finally free. And she kept swearing she was innocent. Sandra Hemme had been in the longest held wrongfully incarcerated woman known in the U.S. history, according to her legal team, Innocent Project. Missouri's top prosecutor has now lost his latest effort to challenge a judge's decision to overturn the murder conviction for killing that her attorney argued was committed by a discredited police officer. In appellate court sided on Tuesday with Hemme, who was freed in July. Oh, good. This has been a while. The decision to overturn her conviction was reviewed at the insistence of Attorney General Andrew Bailey. Presiding Judge Cynthia Martin wrote in the statement 71 pages ruling that some arguments raised by Bailey's office bordered on the absurd and gave prosecutors 10 days to refile charges. It is time for this miscarriage of justice to end, Hemme's attorney stated. Hemme was being treated with heavy doses of antipsychotic drugs back 43 years ago. Now, if you know anything about the psychotic drugs back then, they were cray-cray and out of control. When she was first questioned in the 1980 murder of a 31-year-old library worker, Patricia Jinsky, in St. Joseph, one of Hemme's attorneys, Sean O'Brien, linked the drug to a chemical straitjacket, and a lot of them were, in an October ruling, and said that they raised questions about her ultimate confession. It makes her compliant. It makes her subject to susceptibility. So when you're under those heavy psychotic drugs, back in the 80s. And let me tell you, they were heavy and not as regulated and controlled as they are today. So, yeah, congratulations, Madame. Now sue the hell out of them. Good morning, Miss Karen. Good morning, Ronnie and Miss Morales. Oh my gosh, good morning. Y'all have missed it. The document fairy has dropped. And this, I'll read it quickly again. The state of Florida has made a motion that the defendant was indigent. The defendant is receiving cost money from Jack only because of her indigency. Apparently, only the investigator, Billy Land, is being paid with that money. The defendant secured services of 4 attorneys and a trial consultant, making that her 13th attorney and extra consultant. And perhaps more people than the state is even aware of at this time. The defense team is expending a tremendous amount of cost, having traveled from Milton, Florida to Orlando, Florida for several weeks of trial to return due to the hurricane and only to come back. I'm reading real fast. Basically, this is saying there's a conflict of interest that they believe is there and they want to find out where it is. Mm.
Good morning, ma'am. Could you state your name and date of birth for the record for me?
Morning, Toxic Man. We got some fairy drops on documents.
By her attorneys wearing a black suit and pink blouse. All members of our jury are
but the state is saying there's a conflict of interest and they want to see the documents.
Bring in our panel.
They want to see the documents that were brought, that the documents on camera view, because they want to make sure that Sarah Boone understood and signed a waiver for the conflict of interest between her and her current attorneys. Okay, I'll keep reading. The defense team, okay. The state is concerned about the potential conflict of interest between defendant and her team. Rules regarding Florida State Bar 4-1(8)D parentheses. The only way the court is to know is an actual conflict of interest rather than a potential conflict of interest is review the financial agreements between the defendants and her team. If this is an actual conflict, the defendant can waive her rights, clear, unequivocal, and anyway, the waiver is to be valid. Recorded must show that the defendant is aware of the conflict of interest. And the defendant realizes the conflict could affect the defense, and the defendant knew of the right to obtain other counsel.
And there may be additional motions to be addressed at that time. So yes.
Big deal. In my humble opinion, I'm not a lawyer yet.
I don't have a problem with that. If you want to rest now, subject to those being entered and published, and we can address any motions, the court has reviewed both of the no contact orders. And that way we don't have to do a in and out. And I can colloquy Ms. Boone at that point in time, and we can proceed with the state's
day 4 or day 5.
Case.
Subject to those introduction of those 2 exhibits just mentioned.
Day 5.
The defense will be resting our case at that juncture.
Okay. All right. Yes, ma'am. Okay. I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised. We'll use our time accordingly.
That one was 6.
I don't believe
so. No jury deliberation.
Give me a moment, I can check.
That will have to go to tomorrow. Dag nabbit. No jury deliberation. That will have to go till tomorrow. That stinks.
That is an alternate. It's alternate seat 4.
Thank you.
Oh, it is an alternate. Okay, so once they go to jury, it's okay.
Defense, do you have any motions?
Prosecution sure in the hell does.
Just out of abundance of caution, I would read new or motion for judgment of acquittal. Defense resting that one jury is still out. I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty. And there is sufficient evidence for that to be sent to the jury.
Okay, thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge in the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
No, the defense did not receive the red line copies that the court discussed yesterday. I don't know if those.
I do too.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment, and I'll get those out right now. Is there anyone else? The email correspondence that I have is Mr. Owens' email, Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that they need to be sent to from the defense side?
We'll pass them on.
Okay. All right. Very good. All right. Can we go ahead and bring in our panel? State.
Yes, Your Honor.
Defense?
Yes.
All right, let's stand and bring in our panel, please.
You may bring the jury.
Bring the jury. Thank you, Dawn, for that. Good morning, Adair. With someone like her who's gone through all the attorneys she's gone through, this is his way of protecting himself and the attorney team in the case of an appeal. I'm all like, man, I would be all over that like crazy, man. I have to say, I would be asking with her history, definitely. Oh. Oh. Good morning, everybody. Sorry, I gotta grease down my mic thing. Every time I move it, it squeaks. I gotta get a better one, actually. One I want to get, it's out of stock. So we have a motion for an in-camera review.
State, you recognize our jury.
Yes, Your Honor.
Agreement
Defense, you recognize our jury.
Yes, I do.
between
Thank you. You all can be
Boone
seated.
and her attorney.
Good morning, members of the
with
jury.
a suspected conflict
Welcome
of
back
interest.
to 12 Alpha in the Orange County Courthouse. If you could, just raise your hands to confirm that you complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning, and then we'll go from there. Okay? All right. Thank you very much. Mr. Owens, you may proceed, sir.
Oh,
Judge, at this time, I would move to introduce defense identification exhibit AB into evidence.
No objection to AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
Judge, at this time, I would like to move defense identification AC into evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
And Judge, I would like to publish these to the jury and allow them to take their time and pass these down to.
You may proceed.
these are the restraint. No, don't get the jury. Gave me a heart attack for a second. He just said, "Hey, camera dude." He's like, that's not my problem. Sarah Boone's looking a little rough this morning. Her hair isn't as good. She looked a little tired. Her worst part is over as far as her testimony and everything, which I thought she did pretty decent. I think everybody's real quiet this morning. Man, they're being quiet. Sorry. Okay. Oh, I got some info for you. I love having people who can help me out when I don't know what the heck I'm looking at. Okay, while they're doing this, guys, we got some more juicy stuff. Oh my gosh, y'all. I love it. I love it. I love it. Me so happy right
Thank you,
now.
members of the jury.
I knew he had a clause. This guy is good.
Mr. Romans, any other
Y'all.
additional witnesses, evidence, or testimony, sir?
No, sir, on behalf of Sarah Boone, the defense rep.
Thank you.
Y'all.
Or state, are you intending on putting on a rebuttal case?
Yes, Your Honor.
Hell
proceed, sir.
yeah.
Speak with Dr. Tanya Warner. Warner.
Who are they calling? Dr. Tanner Warner, she hasn't even been. Ooh, y'all, we got some good stuff to talk about. Big stuff. Oh, y'all, we've got some talking to do. And thanks, Jedi Jess, you're so freaking awesome.
You swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Doctor, good morning. Could you state and spell your name for the record for us?
My name is Tonya, T-O-N-I-A, Warner, W-E-R-N-E-R.
Thank you. You may be seated, ma'am.
Thank you.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry.
Oh, we got the
at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law. So anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school, where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And when did you begin your work as a forensic psychologist or psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut. While I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have.
Approximately how many?
Thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are.
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And,
Oh, snap.
Where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It does
would come
not.
under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
Hey, hey,
And
what do you
if
say?
a person
Zach is here
experiences
today.
an environmental stimuli, something happens to them, another person does or says something to them.
We got some
Is
good
their subjective
news.
reaction what is defined as whether
Interesting.
there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
Calls.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Not everybody is traumatized by the evidence or
Is it fair
witnessing
to
of
say
certain
that
behaviors.
an experience that a person has, whether or not that
Hola,
person is
Zach.
traumatic, is a subjective experience.
Yes, each individual is different. And so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase. And that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again, where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access to funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence and end up having the syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes.
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there wearing a dark suit and a pinkish top.
Did the record reflect she's identified the defendant?
Record will so reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida?
Yes, it was.
And subject to a court order?
Yes.
And where, who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information. So getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
And she is.
And then I transitioned from there into walking through the incident that happened with her.
All right. What did she indicate occurred on February 23rd, 2020 to you?
All right. Is it all right if I refer to my notes just
if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there and completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had
give the woman some water
because they were going to donate it. And sorry. And so she went downstairs and indicated that she had found him, and they were kind of laughing, and she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her, and she became angry.
Yes. I need her to get a cup of water. I need to give her water.
To my notes at this point.
Refresh your memory, just put them down and then tell us what you remember.
Pearls are always good. Used to have a fabulous set of pearls when they got stolen. Of course.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out and her son's baseball bat was sitting there and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on a human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5 and the DSM-5-TR. It's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to use a consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
Again, it can affect your memory. It can affect your reactions. It can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse?
Her attorney's going to come back
It
hard.
would depend on each individual again.
Generally
You know
speaking,
he's
it's
going to come back
important
heavy.
as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5-TR or battered spouse syndrome.
Yes.
In this
You
particular
guys,
case,
please share and invite
did you
people
require
over.
any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Yeah,
And
difference between 2
specifically
hours and
talking
9
about
visits.
Yes.
Yeah. Exactly. 9 visits, was it, for the other one? 9 visits. Really? I'll be right back. I'm back. Why didn't someone tell me my shirt was on inside out? That's what happens when you get dressed in the dark. Oh. Why are you so stressed out, Toxic? How little one? I wanted to see a picture, but I know I can't because, but I'm so sorry you're stressed out, babe. Sit down, have a cup of tea or coffee. Take a deep breath. We're here for you, babe. We are definitely here for you. I'm looking at things, guys. We have documentation we're going to go through on a break. Oh my gosh, y'all. This can throw a huge wrench in the trial. I don't know, maybe even a mistrial. Yeah. I got some tea. I got some big tea. But we have a Houston, we may have a problem. Yep, big time possible problem. Yepers. Hey guys, I have a question. Maybe you guys can answer it for me. Why can't we see all these comments when people watch my lives later? But on other channels, you can see all the comments, even on the replay crew. Just curious, because I can't see any of these comments once these lives go down. Once I'm no longer live, they go bye-bye. Anybody have any advice? Let me know. She does look a little more disheveled this morning. Her hair especially, but she does not look like a happy camper. And this is a big argument. By the way, I'm going to my settings and see what I can do. Y'all, we are one subscriber away from hitting 2,300. Come on, guys. I was hoping to hit a lot more by Halloween. I don't know where those settings are. Y'all need, I don't know where to find those settings. Oh my gosh, Zach. I was trying to get to 3,100 by Halloween, and that just doesn't look like it's going to happen. I'm looking. Customization. Okay, customization. I'm there. I'm looking for it. It does say live chat replay. But when I watched my live the other day, last night, I'm sorry. Okay, but thank you. I'll have to go back and look at all the older videos, but right now we're good with this. Thank you so much, Zach. You're so awesome. Appreciate you. Boy, this is a huge argument. Well, but when I went back to watch some of my other lives, it wasn't popping up. That's why I was asking. I'll have to go and look at some of the older lives. Yes, Miss Gabby, you were up early, my dear. We're in a very long deliberation. They are arguing over this. And I would hate to be her up on the stand. While they're doing this, I'm going to go turn the shop lights on. I'll be back.
Members of the jury, thank you so much for your patience. I have a matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure out what we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you.
This ought to be good.
Y'all be seated. Thank you. Mr. Rowan, see if you can find me that portion of the transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, and Judge, it applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then She also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page.
Yes,
still
I
on
know
page 38?
toxic, but I need
Line
to,
21, I need time to
because
go through my
sometimes there's
notes,
questions for me.
think about it, process it. But I had other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process on my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because
Yeah,
obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point if my opinions change after having reviewed further. And I referred to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. And I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on page line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay.
that addresses specifically opinions
I love you
as it
guys.
relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now. And that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to depose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Warner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Warner says absolutely. And then, do you want me to continue reading, or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, That's how she answered. She goes through a little bit of that. And then paraphrasing, she talks about the grandiose component or criteria that she met. And then on page 45, I asked her what other criteria, line 1, would tend to indicate that she was a narcissist. And the answer by Dr. Warner, I didn't say that she was. I said that she has narcissistic traits. And that was the examples.
Judge, excuse me for interrupting, but can we lasso this back into?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. At this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or diagnosis of narcissism. The question pertains to PTSD.
All right, page 46, line 1, question, okay. Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13 on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15. No. I would have to look back through my notes to see if she fully met the criteria. Question, line 17. Can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19. No, I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer. I may. Number 25, question. Okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes. That's specific to the post-traumatic stress disorder.
Okay.
So at the time of this deposition, when I asked her specifically.
So what's the legal objection? What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
What
I
are the
would be notified of any changes.
legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection? I understand the backdrop.
You don't have any legal
I don't
grounds.
know
You're
if there's
just
a legal
not
ground
happy.
Other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to.
Okay.
Because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well, then my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did.
Yep.
My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the
That's
question
correct.
was, and I may have to ask Madam Court reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a definitive no.
Attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion.
I object to your accuracy.
That's irrelevant with the purposes of this argument.
I object to your objection, to my objection, to his objection, to her objection.
As an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
Impeach her.
I don't know if we need to proffer the entire testimony of this.
Oh my God.
Opinions and diagnoses have apparently changed. I think
Ready?
I have the right to take a
One,
deposition
2,
before she testifies.
3. Objection.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
May I just proffer?
Yes.
All right, you've been present for all this hearing. Yes, doctor? Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
Number 3, you don't like it because it hurts your defendant.
What is the legal opinion?
That post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did. and that's what experts do.
I would like to have known that, and that was going to be her opinion before today.
Oh, yes.
That's not a change in testimony. That's
Where is that a change in the
So you're
deposition?
going to have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find where I asked her.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted.
That court
The state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of
He's getting his
the state's
heirs
motion
handed
prevent
to him on a
battered
silver
spouse from
platter
coming
right
into
now. He
evidence.
don't like
Judge,
it.
if you look at page 66,
He's losing.
line 20. Let me know when you're there, Judge.
Hang on. Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1. Yes, sir. Question. Then I go into fees. Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question. And you've been provided all the resources you need to rely on and express your opinions. Line 14,
I double
answer.
dog
I have
dare
based
you.
an opinion on the resources that I've been
Oh,
provided.
little
There's
boy.
other things out there to be provided that may or may not change my
That
opinion.
wasn't on my bingo card. Double dog.
I believe it's a discovery violation because I should have been notified if there was going to be a change in opinions here today. And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial.
You're not being ambushed.
What new opinions are
I gotta do
different
it.
based on what Mr. J proffered?
Watch
the
your
testimony
ears,
is going to
y'all.
be?
We're having a Boone moment.
Madam Clerk, or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely. Of course.
Where'd my little goatee go? My goatee. Oh, dear, he fell over. Oh, Mr. Owens, are we having a moment? Is that what we're doing? I wish you guys could hear my little soundboard for some reason. Can y'all hear this? Let me move it. No, it ain't moving. Oh, let me get it streamed. Did y'all hear that? Are you hearing that
Step off
music?
for a moment. While,
Probably not.
Madam Court Reporter is able to provide that readback.
Dang it. I don't know why. I need help with this. It's pissing me off. Maybe if I go into settings. Nope. How about now? I played music. Let's see if y'all heard that. Yay! Oh my gosh. So I figured it out. So I got to go and do all of this. Zach, I love it. So y'all hear this? Okay, I like this one. Well, this is the way I feel right now. Okay, I got to go through and change every single button output on this thing. You want to talk about a pain in the ears, but it works. Yay. So let me go and get all of this stuff. This is what I wanted to do. Let me just get all this stuff switched over. I have to go to each individual button. I got about 25 programmed. Oh, no, I got more than that. I got about 45 buttons programmed. What is this one?
All I ask is a chance to prove that money can't make me happy.
Oh, that would have been perfect for the Ferris trial, because that's all it's about. Here's Zach's favorite, because he's such a man. Oh gosh, y'all are hysterical. You want to know what this is called? Let's hear this one. What does that remind you of? I want to get the bells, the little bell plays that they did in the movie Grease. I want to get that sound clip so bad. And because it is so perfect sometimes. And I wish I could get the Jeopardy music, but I can't. It's copyrighted. It's copyrighted, which sucks because I want it. You don't know the Carlton dances? Oh my gosh. Google it. I haven't used a lot of these in so long. I need to remember. I need to play them all to remember what's what. Some of these are pretty cool. Okay, guys, let me get this done real quick because I'm in a rhythm and I don't want to lose where I'm at. But I got some fascinating tea. For those of you who were here at the beginning, I read where there was a motion for an open camera review of the contract between the, let me, it ain't got no gas in it. I love this. When some this is Mr. Owens right now. It ain't got no gas in it. Got no gas in his motion. Okay, I want to read something to y'all. Okay, guys, here's the deal. The thing is the Boone Shuffle. Okay, here's the thing. The thing is that the prosecution thinks that Sarah Boone has signed a document stating that Mr. Owens can put a lien on any and all money that she can make in the future. Well, part of that's a problem because she's been declared indigent. When you're declared indigent, that means you have nothing. If you are found guilty and you come into something, for example, then the state can come in and take a good chunk of that. A percentage of it goes to the victims advocacy program, a percentage goes to this, a percentage goes to that. So essentially, this is what the state is saying. Well, right now, he doesn't get paid anything. And the state is saying that he has hired 3 additional attorneys and a jury expert, and God knows how many support staff. And so at this point, he is racking up the bill, basically a huge bill. And right now, he is not getting paid. So here's the angle from an attorney. Sure, essentially, the state is saying that the defense has made an agreement with Sarah where they get paid for their representation off her by getting an ownership right in any media rights that Sarah has over her story about the case and crime. Under the rules, they cannot do that while representing her in the criminal case because it's a conflict. And what's the conflict? It determines how well they'll represent her, how vigorously they'll represent her. There's a small caveat to that, and that may be able to, after the trial, or to negotiate something like a book deal. Ultimately, if they do have such an agreement, they would be subject to discipline. If they do not, it's fine. We're not sure if it may cause a mistrial or anything, but it is serious. Very serious. Should this be should they have a deal? Because if you sign that agreement prior to your defense, in this kind of case, and I believe Miss Jules is right. If you're listening, Jules, we love you. I believe Jules is correct in that he knows there's going to be some deals coming out of this, Netflix, whatever. So he agreed to take the case only if she signed over the rights to any and all money made by the case or by the crime itself. So he's seeing big money on the back end. So he has hired 4 attorneys. Come on, quit it. He's hired 4 attorneys, including himself. That makes 13 attorneys she's had since day one. Why did everybody go bye-bye? Well, that's it. A percentage of the proceeds would go to his heirs. I think up to 25%. 25% will go somewhere else. I mean, there's a magical number. But no. She has signed a contract. Oh, yes, I agree 100%. A 100%. I know, but my numbers just did a plummet. I guess I did something I shouldn't have done. So the judge is on a short break. I bet he is looking at the law on this. The defense may have something. I don't know. Yep. To me, that's wrong. Exactly. Well, the thing is what they're asking is the state is asking for an open camera review of their contract. And maybe that's why Mr. Owens is in such a pissy mood today. I wonder, because he knows that's been filed. You guys, please share. What? Menendez brothers resentencing decision to be announced by the end of this week. I guess we knew that. We have a Halloween comment that should be visible tonight. Tarzan actor. Oh my God, I remember when he played Tarzan. Wow, was he hot. Died at 86 years old. Oh, I remember when he played Tarzan. My gosh, that Tarzan was the first movie I'd ever saw with boobies in it. Can't remember the name of the actress who went topless in it, but I was a young kid. Opening statement set to begin in the murder trial of former Columbia's Ohio police officer who shot Andrea Hill. That's happening today. Oh, Mija, rest in peace, dude. There's a lot of people dying. If you haven't noticed online, there's a lot of actresses. An investigation underway as to a helicopter crashes into Houston radio tower. For those of you who don't know, I had mentioned that crash happened and it was carrying civilians. It was a tour helicopter. Linda Abbs, veteran producer behind Sleepless in Seattle and How to Lose a Guy in 10 Days, died at the age of 74. She was a beautiful love. Brilliant. Celebrated Yellowstone grizzly bear is killed by car. The bear was 28 years old. SpaceX capsule is coming back to Earth. Woohoo! Full-scale replica of Anne Frank's annex. Oh, they're going to rebuild that for people to come see. Gustavo Gutierrez, a founder of libertarian theology, died at 96. Okay, back to the Menendez brothers. So we hit all the hot spots. Yeah, I know, right? I'm not me. Nope. Okay, here they come back. Woohoo! Yay!
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Castro on behalf of the state.
William J. for the state.
Defense.
James Owens for Ms. Boone.
Ms.
I bet
Boone
they're getting
is
tired of
seated
saying
at
that.
council's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony? Okay, you may proceed.
Oh, so the state won. Sorry.
Hi, Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes.
Oh, they didn't. I'm sorry.
Am I misrepresenting any of our conversations? Answer, no. Question? All right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case and the defendant relayed them to you, what would be your answer? Question? That it's not related to the incident as she reported it. Question? Okay. And
Sorry,
if I
guys.
ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question. If you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question. All right, that's it.
I don't think that's the very beginning before I objected.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked.
Oh, Jesus.
What was specifically asked was to the proffer, because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. The answer was supposed to be something different as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant
You're killing
reported.
precious time. Get
Those
off
are the
dead
opinions,
horse.
as I understand them, based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
Get off the dead horse. Bye. We'll have to look into that one. You've lost. Move on. I'm trying some sounds.
Bruh. Bruh.
Refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria.
Which was the
Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, answer no. I didn't say one way or the other. I would have to look back through my notes for that.
got a little spice to it, doesn't it?
Is that something that you may, in the future, give an opinion opinion about after some time reflecting and reviewing your notes. 24, on May. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. On 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering an, unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not.
Oh, God,
Sarah Boone suffers
really?
from post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back when it was first going on, when a question was asked, and I believe she rendered an opinion. And I, again, like that to be reread back. What the initial question was, what the response was, because it didn't. I know I objected. I can't even remember it now, but I know I objected because I knew it was inconsistent.
You asked to approach, and then you explained that the question was it was not something that was framed in the deposition.
Dude,
multiple times I asked you for a legal
lay
objection.
it down.
And it wasn't until right before or right after we sent the
You're
jury
just
out that you
pissing
provided
everybody off.
some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind.
She's not happy about this. I
Yes,
sure the hell wouldn't be.
Mr. J, question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if she could go back to the initial.
Wow, y'all. I would ask, Your Honor, while y'all doing this, can I have a little comfort break, please? Do I need to be here? She is not a happy woman, and I wouldn't be either. I think that's rude for them to keep her on the stand that long, but she may need to be in there for them to verify a question or an answer. So at that point, you kind of got to go. Oh, that's what's bothering me. I have one of those little strings. Thank you. No, Gabby, I think she's just looking down in disbelief like we all are. We're all in disbelief at this point. You're making me want to eat candy, sir. I want to go through my sounds. Let's see. I like this. It sounds like you're outside at night. That's going to be loud. This is what we need. How loud are those to you guys? If they're too loud, let me know.
Please, go ahead. Sorry. Pay no attention to me. Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Can you read that for me one more time, please? Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
May we please have the previous question as well?
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
Well, she's not mic'd.
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end, some general, if you have any new opinions or anything new that differs from what you've said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I ask that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That
Which means she was angry.
Violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about-
specifically asked you, Mr. Owens, to point out for me
I'm
what,
pointing out.
excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that I expressed.
Other than what you've already identified.
The ones that I expressed, and that just the understanding that we had that she, in the pages that I have talked about previously here today.
We're spicy.
That I referred to about our agreement that she was going to let me know if there were any opinions that she had in addition to the opinions that she gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J?
No, thank you.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243.
His legal assistants are amazing.
1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
None other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay. All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions.
What?
Based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial. Although the questions in the deposition as highlighted by the defense so far are do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
You lost your ear. Poor baby. Now we have an Emily D. Baker Van Gogh.
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then it's
I can glue it back on, baby.
today, so I'm going to want to rely on that question or that answer.
Okay. All right. Ms. Boone, have you been paying attention to the questions and answers?
You
and
bet
the
she
readbacks
has.
of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you. With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes. With regard to the proffered opinions.
I'll be right back, y'all.
And I believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warren.
Yes, sir.
Good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct. That my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay. And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct. That was my opinion. Correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right. And I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case.
Is this
Did you not?
Owens?
Your opinion
Yes.
is relating to a central issue in this case.
Correct.
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
He's throwing a temper
I told
tantrum.
you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
Woo! He didn't like that either. Oh my God, this woman can blow this case wide open.
This
Holy
is your
crap.
opportunity, Mr. Owens.
Because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware. You know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions.
Prince Harry filed for divorce. Holy
Dr. Warner, were you
shit.
given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases. And now I'm taking a deposition on
It's
the fly,
legit.
and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom.
Yes, sir.
And we're waiting on the jury on the trial of Sarah Boone. Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend to express here today?
It depends on what's asked of you, you
dumbass. On
dumbass.
trial for murder in the second degree.
I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions.
Be
that he may or may
specific.
not have.
You're a lawyer.
99 out of 100 attorneys would come in here and say, that's not how you do depositions with expert witnesses. You have to ask specific questions.
Specific.
Anytime you ask a question like
Quit
that,
throwing your
the
temper
expert is
tantrum.
Always going to say, please ask me a specific
Holy hell.
And that's what she did then. That's what she's doing now.
Sorry, Van Gogh. I know you're hurting, but we're going to do it anyway.
And vague to ask somebody, tell me every opinion you have.
Judge.
Yes, sir.
We're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here in the middle of a trial.
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
Do you believe she had PTSD? Do you believe she had depression disorder?
Dr. Warner.
Thank you.
Do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Sometimes you don't elicit specific questions because it can trigger false answer, you idiot.
You do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So narcissism, you did not find?
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder?
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder?
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome?
Alcohol use disorder.
Alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
You recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder.
That's correct.
And you've changed that opinion now?
I'm leaning towards the adjustment disorder secondary to her situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with Jorge Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
In your opinion, does she suffer from any form of psychosis?
No.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's possible?
Yes.
Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that, yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
So did he say yes or no to the battered spouse? I couldn't
Any other
hear.
arguments at this time?
No, Judge, just the one I want to make.
Jeez.
all right.
No morning
the court has
break.
conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions
Did
are
she
being
say yes or
offered
no to
were not
battered spouse?
inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
Oh, darn.
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can.
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
Does it need to be on the record or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying against this in court this morning.
They're still under defense subpoena.
I
We have
asked,
not,
I asked Mr. Henderson if you guys were calling Capsule again, and he said no.
and we're not in our defense, our direct defense. Is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek sir rebuttal and possibly through these witnesses? They're under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed her presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in rebuttal. But
That doesn't answer my question. What's the legal basis of a sir rebuttal?
Judicial discretion as to the fairness of the proceeding that the defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and then comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much. Anything else, Mr. Owens, we need to address?
No.
Anything else, state?
No, Your Honor.
All right, let's bring back in our jury. You can continue your inquiry, sir.
It's not a diagnosis. It's a cause for it's an extenuating circumstance or reason for the behavior in which you exhibited. Does not mean it's a diagnostic thing. It's not a diagnosis in the DSM. It is. You're admitting to committing the crime under extenuating circumstances. That is what battered spouse syndrome is. It is not a mental condition that is diagnosable under the DSM, like post-traumatic stress is, or schizophrenia. That's where the people are getting this wrong, and I hope they clarify it for the jury. And the problem is there was no threat to her life or safety when she zipped him in the freaking suitcase. So you cannot use battered spouse syndrome. He was not beating your ass. Oh, you think you won? You're getting a little smirky. We'll just wait till they wipe the floor with it. I'm getting irritated, and I apologize. I'm hungry. I'm hungry.
To recognize our jury.
Yes, Your Honor.
But
Next, we recognize our
I
jury.
am running this
Thank you.
number
Be
because I
seated.
believe it's the right thing to do.
Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could, please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
Shit, really? I've got toast going.
Your objection's overruled.
All right. Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the
This
facts of the
woman's ready to
case,
get the hell out of there.
does PTSD or BSS have any relation?
Objection, that's been asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, you know, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent, you know, there was an imminent risk of harm that she needed to protect herself.
Yes.
Finally! But there's an objection. God, I'm trying very hard to keep my cool. What? Owens. This is exactly what he does not want to hear. And he's going to throw his little temper tantrum. Owens, are you having a bad day, boo-boo? Boo-boo, honey. Honey, do you need to go in the corner and have a passy time to calm yourself down and get yourself under control? Clear your mind a little bit. If you didn't bring your passy with you, your thumb would be a good substitute. And in about 5-10 minutes after you feel like you've calmed down, you can come out of the corner and act like a freaking adult. Just saying. I never thought I would do this, but I'm doing it. Let's see if y'all can hear it. Is that about what it sounds like over in the corner for you, honey boo boo? Mr. Owens, he needs his passy. Yes, I'm getting ridiculous because this is absolutely off the charts. Ridiculous. That's a good baby cry, by the way. He's throwing one hell of a fit, isn't he? And it's a long one, so I can play it short or long. I like it. It's not. See, this, I think, is why.
Members of the jury, I have something I've got to discuss with counsel outside of y'all's presence. Same instruction. Please don't conduct any independent investigation or research on the person, places, thing, or charge involved.
Okay. One of the things that I believe that Mr. J did well is he could have done a lot of this earlier and could have come down on Sarah Boone and his cross, and we gave him hell for it. But guess what? I think well met, well played. Gotcha, babe, because his redirect is causing this much grief. It's only going to stick on the negative side for Owen.
Welcome, be seated. Thank you.
And this judge, I hope he hands his ass on the silver platter right now.
Madam Court Reporter, when you're ready.
His legal aid is on the money with the laws. I like this dude. Y'all. Who toxic? Y'all hit the bell so you know when we go live again. Do I have to put the spicy meter back up? Oh my gosh, here we go. I'll be back. I'm going to check on my toast.
Yes, ma'am. Just go from, read it from the question, answer, question, objection. Let's just have we can buttress it. Go ahead.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether Ms. Boone is suffering from PTSD or DSS, irrespective of that, based on your evaluation of this case, what she relayed to you about the facts of this case, does PTSD or DSS have any relation? Mr. Owens, objection, ask and answer. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek, they were having a good time, they were laughing.
I'm here, I'm just going to eat.
When she found him, they were enjoying themselves. She zipped him, they were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify, that you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
It's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time, despite his mental illness, because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, you know, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony. And it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony, Judge.
Any other argument, Mr. Owens?
That's totally wrong. He claims, the prosecutor claims Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976 Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case.
I love this
Dinkins,
judge.
the
He has his
psychologist's
crap
opinions were not
together.
legal
He's my
conclusions. The
ultimate
psychologist
judge.
did not opine on the
Kudos,
defendant's
Judge.
guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and answer, and then I have no further questions.
Okay, thank you.
I'm sorry.
He is going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Oh!
It was asked to
Overruled. There was a pending objection. And allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for mine.
That's your fault.
We're going to begin your cross-examination after we're done with after the state advises the jury in open court that there are no more questions. Let's go ahead and bring back in our panel.
That was your damn fault. You have wasted all this time. And this judge is like done.
Bring the jury.
Sorry about that.
You may bring the jury.
Owens, you're fighting vigorously. I get it. But then you can't complain about the time if you don't like how the trial's moving and you're causing the delay by all your BS objections. I think you're hurting your client far more than you're helping right now. Yeah, we have Owen PTSD. Oh, PTSD. I like it. We've got O PTSD. By the show of hands, how many of us have OPTSD?
State, to recognize our jury.
Yes, Your Honor.
Defense, to recognize our jury. You may be seated. Thank you. Members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
Owen. Oh, PTSD. What's C? Court? I'm saying Owen.
All right. Irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or ESS, irrespective of that based on your evaluation of Ms. Boone, What she relayed to you about the facts of this case, does PTSD and VSS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Oh, hell yes. He's like, oh, hell yes. Sorry, guys. I'm a little animated this morning.
What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
that's the 2-hour interrogation with Detective Lowen and Detective Copson.
It was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay.
And they can disagree.
Did you
And he
listen
doesn't like
to
it.
Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
You agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
She has other
You
clients.
said you considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Yes.
Ah, she's giving that. Oh, let's see this fun. I'm getting paid hundreds, if not thousands of dollars to sit here, so I'm good. Here's the thing. Some people don't believe that watching testimony of other experts and watching her testimony. First of all, this interview was prior to trial. And watching testimony in and of itself, to me, is kind of, I gotta open this up a little. There we go. So, first of all, her evaluations and everything happened prior to trial. So she's not required to watch any testimony before making her decision. She had an interview with Sarah Boone. And she saw some documentation.
Regarding these,
if she changed her opinion, he would have nailed her.
Opinion that you just expressed about the inapplicability of VSS or PTSD to the facts of this case.
No.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had.
Yes.
Holy, do you know what? This is really looking bad for the the defense. And she's going to say he has a right to ask those questions. And this is not going to bode well. It's not. I'm disappointed my goat lost its ear. I ought to get a new goat. See, they call EDB's goat Van Goat because it's missing an ear. But I can't do that because she's got a Van Goat. I could call it Van Goatette. Make it a girl. Van Goatette. Van Goaty. Oh, Van Goaty. Why don't we call her Van Goaty? I'll put a little skirt on her. Make her Van Goaty. What do you think? Van Goaty? That's EDB's. I can't take that name. But I can say Vincent Van Goaty. Make it a girl. Because it's missing an ear. Yeah. I'm already being accused of copying. Don't want to get in trouble. I want to say that how much I really admire and appreciate the fact that EDB is a woman with learning disabilities, neurodivergent, and has paved a path for all of us women who may be in the same boat, similar boat, maybe not a boat at all with her, but I really appreciate the fact that she's opened that door for us, and I admire her greatly. Of course. And it's his being vigorous in his defense. But you guys, some of you may not have heard, he may be in trouble with the board. Because if he signed an agreement prior to trial that he basically put a lien on Sarah Boone for all her potential future digital media, paper, books, movies, whatever, income that he would get the money, that could be a conflict because it affects his way of handling the case. He has gone well and above what most people would do for her case. 4 attorneys and a jury expert and a full team, probably about 10 people behind the scenes. That's $1 million team. Look at her. Yes. That's $1 million team. So with that, boy, geez. And if that's the case, he told us on an interview, he will be paid. Miss Boone will pay him basically one way or another. So she signed all of her rights away to him. Hold on, I got to answer this. So anyway, I'll read all that documentation to you in a minute. I got to answer this. Okay, guys, I'm going to say this very politely. If you are having a problem on somebody else's live, please don't contact another content creator. Get a hold of them to help you. They can't do anything for you. That's hard to read, y'all. She's talking sideways and smiling. Saying that, wrong something. It's too hard from the side, y'all. It's difficult. Okay, I'm going to be right back. You mean to tell me we're still on a break? Oh my gosh. This case is not going to finish today.
Objections overruled. You may proceed.
Dang
Ma'am, is it fair to say in your evaluation of Sarah Boone on October the 2nd of 2024 that you felt like the text messages that you received from the state attorney
Overruled.
are not relevant to your evaluation of Sarah Boone?
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes.
And we discussed that these were the phone records from Sarah Boone's phone.
Yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it. If you just refer me to the page.
Just a moment.
You got it?
I do.
Page 14.
Trying to light a candle ain't working.
My question is at line 3. Your answer begins at line 5.
Correct.
And you agree that any,
Let him finish.
Hi, Toxic.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5, approach.
Oh, Lord have mercy. Lord have mercy.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone? Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14. My question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's talk. First, you said no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence was no.
Who
my complete
is
answer.
I understand. I'm going to
questioning?
let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and it would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time, you expressed that they had a volatile relationship.
Does not
It's
mean.
not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship.
Correct.
And this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot for overdrafting her account.
Correct.
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, we need to object. We need to approach.
Y'all, we know they had a volatile relationship. Volatile does not mean necessarily abusive. Oh, Zach, she is so appropriate with her smirks. I think Owens has just lost a big chunk of credibility with this jury. So want Jules' input. I'm going to risk pissing her off and calling her. Y'all. She is being very professional because I don't think I could be with him. Honestly, I don't. I'd ream him up and down the other. He's being abusive. I would say, do you know what abusive is, sir? You're abusing me right now. And I don't tolerate that. I'm not here to be abused by you or anyone else. Ask me nicely. I will answer. But I do not tolerate being abused verbally by you. And the judge can strike it. They can hate it. But I don't care. I would. I'd sit there and I'd look at the judge and I would say, Your Honor, this is borderline abusive. Please ask the attorney to bring his tone down and address me appropriately. I'm not the enemy here. I would. I'm so upset my goat lost its ear. I haven't had you that long, Goaty. I'm so sorry, Goaty. Goaty. I like that. That's kind of cute. Goaty. It's not badgering yet, but I'm not liking it either. I'm not liking it at all. And I think the jury is going to have to be asked to leave yet again. What do you want to bet? The jury is going to go back out.
reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case.
They're
or the
taking a lunch
people
break.
and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again, bless you, that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we're going to be in recess till 1:30, and we'll pick up at that point in time. Thank you so much for your service.
And if I was a judge, I would tell him to get his shite in control. Get yourself under
Y'all may be
control.
seated. State,
I
anything
want to
else?
have.
Defense? All right, we'll see you at 1:30. Thank you very much. Court's in recess.
I would tell the attorneys on me right now, both of you. Both of you on me and now. Somebody asked if Sarah Boone was getting good food for lunch. The jail will send over her lunch. It's a bag lunch, a sandwich. Now, her attorneys can pay and have lunch brought to her if they wish. I don't know if they are. But they do send a sack lunch with them. So she is getting that at least. Oh, poor baby. Jail food sucks. I've had it. Not me. In relation to my ex. So, yeah. All right. Miss Jules. Can you hear me? There you are.
Hello?
Hey, how are you?
Driving.
Did you hear that?
I did. Every word of it.
Oh my. What is your humble opinion?
My humble opinion is Mr. Owens is scoring big points right now.
Why are you not?
I mean, what do you call it? Even the judge is ruling for him. And I thought it was amazing that after this whole thing with that witness, and then they start up, and I mean, the prosecution objects to their own witness and wants their own witness's answer stricken. I mean,
No, are you sure you're hearing it right?
I am. Mr. J got up after the judge ruled.
I may have been in the bathroom.
He got up and said, I'm objecting. He wanted it stricken, and then he requested a voir dire of his own witness. And the judge said no. The judge overruled him. You don't do that in the middle of to your own witness in the middle of a trial. You ask for a voir dire? Yeah. Mr. J really screwed up on this. Really screwed up. And I'm surprised. I'm shocked by it. I'm shocked because I really thought he was going to nail it today, and he shocked me. Yeah. Go back and listen. During your lunch break, go rewind that whole freaking fiasco. Oh my God, I wish I was in the courtroom.
I thought it was her attorney asking, I thought it was her attorney asking for the voir dire.
He did. No, yes, initially, and he got the voir dire. He got the voir dire outside of the presence of the jury. Then everybody comes back. The judge ruled, and he overruled Mr. Owens' objection to have her answer stricken. Jury comes back. Mr. Owens started his cross, and Mr. J stood up and objected to his own witness's answer and wanted it stricken. They went back to the bench, and the judge ruled against Mr. Owens. Mr. Owens wanted to then voir dire his own witness. The judge said no. The judge ruled against him. And I find that mind-blowing because I've never seen that happen before. Where in the middle of a freaking case, an attorney wants to strike his own witness's answer and voir dire his own witness.
Well, I haven't seen any of that mess before, so I don't think it looks good on either side.
It definitely does not look good for Jay at all. Not at all. Excuse me, I'm sorry.
You're okay. How far are you from home?
I still have 45 to go.
Okay. You doing all right? Everybody says hi.
Tell everyone I said hello.
They're hearing you.
Not to my home, I'm going to my son's tomorrow. I'm going to go to my son's today and just veg, and then at some point tomorrow head to my home, which is a additional 2 hours.
So this is 5 hours away from your home, a drive.
Yes. Yeah, if I had to drive from my house, to where I was, yeah. And the only reason why it was a 3-hour drive all these times is because the traffic on I-4, there was just a lot of stuff going on. But today, the traffic is good. There's been no holdups, nothing. So I'm doing it in 2. So, okay. And that should be the normal. Yeah. So.
Well, you have a safe journey home. Anything you want to share or talk about?
Let me see. Well, I did talk to Mr. Owens yesterday, and he is bound and determined to get this into the jury's hands today. However, I
don't think that's going to happen now.
I think it will.
I don't, because a juror has to leave at 5:30 today. There will be no jury delivery.
Yeah.
Nope. And after this, and he did send up, Your Honor, now we got an hour plus delayed. You know, he made that comment. And so I don't know.
Yeah, because now he feels because of what this expert has changed her initial opinion. He was going to need an extra hour. Moving along so quickly, we may not need it now. He may not need it now. He may not need that extra hour.
Well, you have gone super digital. We cannot even understand you, babe. We know you're traveling.
Oh, really?
Oh, there you are. There you are.
Okay. I can tell you that I did leave a source in the courtroom. Of course, I can't get his messages because I'm driving and I can't read and drive. I will not take that chance. But before I left this morning, he did let me know that 2 rows on the prosecution side has been roped off, and there's only one person sitting there, and that is the victim's advocate. So this is a safe bet to say the family will be coming in probably during closing arguments, and those 2 rows are set aside for them. No doubt in my mind.
Yep. I can see that.
Yeah, and Susan Constantine, the body language expert that I got to meet yesterday and have lunch with. I was so happy about that. I admire. I've admired her for years. In any case, she's back in the courtroom today, and my source happens to be sitting right next to her. And so she's there to observe. Just for her own, just like I do. You know what I'm saying? Just for herself. And what else? I'm trying to think what else he told me. The courtroom is packed with the exception of those 2 rows that have been cordoned off for the family. So there's a lot, and there's a lot going on. There's a lot going on.
Wow.
Oh, and I do. I can tell you the jurors that will be deliberating. There's a man. I'm gonna say I'm really bad when it comes to people's ages. So I may be wrong on these ages, but I'm gonna say in his 50s, maybe late 50s. And I have been observing him the whole time. He took a lot of notes. He was very stoic during, the entire trial. There really was no communicating between, like on breaks and sidebars and stuff like that. Sometimes they tend to talk with each other. There was nothing like that going on with him. Another gentleman, I'm guessing late 30s, maybe mid 40-ish. He will be deliberating as well. He took notes, but he was not an avid note taker. More towards the end did he pick up on his note taking. And then the balance of the jurors are females, I would say.
Speech that's reported ahead on I-4 West.
Sorry about that.
No, you're fine.
Are 4 women, I would say, ranging from early 30s, maybe late 40s, maybe, or they could be younger. I don't know, but it's 4 women. And yes, I know everybody's wanting to know this. Yes, it is the DV juror.
Well, it'll be interesting, that's for sure.
Yeah. I can see that first male. I could see him being the 4-person. My gut is telling me that they're going to have him be the 4-person. I did speak with Susan Constantine yesterday in regards to the DV juror, and in her opinion, and this is just opinion, she thinks that the DV juror could be very impactful during deliberations on both sides. She said it's hard to tell. As she was watching her yesterday, she said there were many times where she thought she was leaning towards the defense, but there were times where she was leaning towards the prosecution. So, you know, Susan said it could be a toss-up, number one. And if she is leaning towards the defense, depending on how persuasive she could be, she may not be aggressive because of the fact that she's a DV victim. So, you know, if others are more aggressive, she may retreat and not put forth, you know, not push the issue. So it's a toss-up. I have no idea. I have no idea how this is going to turn out. I have no idea.
Yeah, today has been wild.
It has been. It's been a roller coaster, and I love it.
Yeah, this is what we like. Well,
yeah.
Jules, you be safe. We again thank you from the bottom of our hearts for all that you have.
No, thank you. Thank you. Thank you because your community enabled me to stay longer than I actually anticipated. Unfortunately, I feel awful that I have not been able to see this through to the verdict. So, you know, but I had to, you know, heed my health, and but I appreciate that. I made some great contacts while I was out there, and you know, I feel as if, you know, because of that, I was able to bring some information out there prior to it becoming public knowledge. And yes, Sarah has a girl. Did I already tell you this? I don't remember.
What?
About Sarah has a girlfriend?
No! How did you hear that?
Oh,
what?
From the girlfriend. Yeah. Okay, I have to get off of this exit. All right. Yes, they met in jail, and the girl is, she was in there on some sort of drug charges. She did not go into specifics in regards to her charges, and I wasn't gonna, oh shit, I gotta get text lane. Lady, are you going to be nice and let me in? Thank you. What do you call it? But in any case, two friends, you know, special. I have to be careful with what I say. While incarcerated, obviously she's out. She's on probation. Currently looking for employment. She cannot, since she's been out, she cannot have any communication with Sarah because it is against the rules. So she came to court and, what do you call it? To see her. And then, you know, she wanted to know what our thoughts were if Sarah was gonna be found not guilty or not, because, you know, she loves her. And yeah, that was some discussion, I'll tell you that. And I said, I don't know if she's going to be found not guilty or not. This is a really hard one to call. And the other woman that I was with, when we were having this discussion, I don't remember the name of it, but she came all the way in from Tennessee, but she very bluntly said girlfriend, no, she's not going to be found not guilty. And the look on this woman's face was like sheer horror. Like she didn't want to hear that answer. So she got upset and she walked away. But she was in there. This was the day before the day before yesterday. And so there you have it. Guess that's all I can tell you. I guess they have a special bond with each other.
Wow.
Mm-hmm.
Interesting.
Yeah. Isn't it though? I found that very interesting myself. So yeah. That's about, I'm trying to think if there's anything else I need to, I already told you about the showdown between Owens and Jay in the courtroom off camera, right? Over the suitcase.
A very minimal. You just said they asked you to leave the room.
Yeah. Okay. So when they went on break, Owens said to, where am I going? 2 miles, right? I think it's the next one. Owens said to Jay, where is the paper clip that was on? Because the paper clip wasn't on the suitcase. And he's like, well, where is the paper clip? And so Mr. J, the box that the suitcase was in, he picked up the box and he shook it upside down, and the paper clip came out, and then he literally slammed the box on the floor and said, there's your evidence now. Are you satisfied?
Ooh, who said that?
Yeah.
Who said that, Jay?
Yes. And so everybody had we all went, because we were so shocked at that behavior, and then it was after he did that, that's when we were asked to leave the courtroom, and then they were going to finish examining the evidence outside of the public. But Jay's true disdain for being asked anything came out in front of all the media, all of it, everybody. Yeah, it was crazy. It was crazy, Ada. Freaking crazy. I mean, he was so angry. But Mr. Owens had a legitimate question because of the fact that, it was said that, there was a pink paper clip because the zip pull was broken, and it was a pink paper clip on there. And when they took the suitcase out of the box, the paper clip wasn't there. So, what do you call it? He wanted to know, well, Where is it? It's been in your custody this whole time. Where is it? And Mr. J got pissed that he was even asked that question. So, like I said, he picked up the box, turned it upside down, shook it, and the paper clip came flying out, hit the floor, and that's when he said, "There's your evidence now." And he just took the box and he threw it. He just slammed it on the floor and said, "Are you satisfied now?" And because of our response, which was natural, if somebody flipped out like that in front of you, you'd have that same freaking response. And then we were asked to leave. So they cleared the courtroom. Everybody had to go. So there was that. And then yesterday, I went to lunch with Joel from Surviving the Survivor and Susan Constantine. And who do we run into but Mr. J and Mr. Cacciatore? And I did find out I am pronouncing his name correctly. It is Cacciatore. Anyway, they were at the same place that we went to, but we elected to go to the complete opposite side of the restaurant because we didn't want any, to be accused of any impropriety or anything like that. So that's it. I think I got you pretty much caught up on everything.
Wow. Well, I appreciate that so much.
Yeah, I mean, if you could think of something else that I haven't covered that I might know.
Somebody asked, how many years is Boone subject to?
A minimum of 22 and a half years. That's the minimum to life. 22 and a half to life. She should have taken the deal. She should have taken the deal because then she would have been out in eight years. She really should have taken the deal because they offered her manslaughter with the minimum sentence with her time with her time served added to it. So she was dumb for not. She was really clearly dumb for not taking that deal. Because she gets found guilty, she's done.
Yeah, she that was a big risk, and I think that she's believing that she's going to get off from this.
I think she really is. And the reason why I think, and this is just speculation, this is pure speculation because I don't know. I think the reason why she thinks she's going to get found not guilty is because Mr. Owens and his team are doing a really good job, and they are including her in everything, and in all the decisions, even when they advise her against something. And I'm not going to say what it is. I happened to overhear it, and because of where I was sitting yesterday, I'm not going to repeat it because I don't want any trouble. But even when they advise her against something and she's like, no, this is what I want to do, they do it. It's like they don't push anything with her. And I think she's optimistic because they have included her in every aspect of what's going on in the last 45 days, where according to her, the 8 previous attorneys We're not keeping her up to date. We're not including her in anything. You know, and now, is she difficult to work with? In my opinion, from what I have seen, yeah. And so I could see why these attorneys were like, yeah, we're done. But I think a lot of these attorneys just wanted it to be done. So, but Mr. Owens and the entire team have, in my opinion, have taken great care to make sure she is included in everything. Like any little piece of paperwork they make, they submit it to her. So I think that's why she thinks she's going to be found not guilty. I really do believe that she believes she's going to be found not guilty. I do believe that. But I don't know, because we've all seen how, especially here in Florida, jurors are so unpredictable. We don't know what they're going to do. Yeah.
I don't know. I'm on the fence.
And this is why Judge Cranick, if you notice, every time they come back from break, he questions Sarah.
Oh, yes.
Every time. And that is so she can't. So if she's found if she's found guilty, she can't come back and say, well, this was her attorney's fault. She can't say, because now everything is on record. I mean, Judge Cranick is making sure all the T's are crossed, all the I's are dotted, because of what he has gone through with her for the last 4 years.
Oh, yeah. Yeah. He's definitely doing what he needs to be doing.
Yeah. And of course there's this buzz around the courthouse yesterday about, and we've discussed this before, how we've speculated that Owens and team will be paid money on the back end by media, documentary, book, whatever.
Did you hear what hit the fan?
Yes, and this was buzzing yesterday. Now, I have spoken with Mr. Owens numerous times, and he's been really cool with seeking me out to give me heads up on what was going to go on, and that buzz happened yesterday, and I was not going to ask him about it, and the reason why I decided not to, someone else did, but I did not. And the reason I didn't was I just felt that kind of a question would have alienated my position with him. Like you know what I mean? But someone else did ask, and the answer was Sarah Boone will be paying me in the end. And so he didn't answer it the way the question was posed to him. And the question was posed to him, have you negotiated some sort of deal, which they're not allowed to do. So he never directly answered it, but what his answer was, Sarah Boone will be paying me at the end. I don't know what it means. I have no idea.
How can she pay him? She has nothing.
I don't know. And like I said, I wasn't going to pursue it because I did not want to alienate him from me. Right? Not what was the question?
Oh no, we're talking about how you did not question him. You did not question him. And that was good that you didn't question him.
No, because I didn't want to alienate the relationship that I built with him over the last 2 weeks. I did not, and I want to make it really clear, I did not seek him out, okay? He sought me out. I don't know how or why or what the reason was, but he's the one who sought me out. And then there were times, most of the times he approached me, but there were times where I did go to him if I had, a question, and he was very accommodating, very, very accommodating. Mr. Henderson as well was very, very accommodating to me, as well as Mr. Beck was. So I was not, people were chomping at the bit to ask him about that, and I just wasn't going to go down that road. I wasn't going to do that.
Wow. Well,
so
love, have a safe journey home.
I will. Thank you very much. Like I said, I do have a source inside the courtroom that I left there, and they, in fact, I got messages since I've been driving, but I don't read and drive. So once I get to my son's,
pull over,
I'll look.
take a little stop if you need to rest for a minute, go to the bathroom and read them then. But love, keep us updated. We're here. We appreciate you.
I will.
And go be safe,
Thank
okay?
you.
Let me know you're safely there.
I will.
All right, love.
Thank you, and thank you again, everyone.
You're welcome.
Bye-bye.
Bye. Okay. Wow. Girlfriend? Zach, I am so... Yes, I got it. Okay, Ronnie, you posted the paperwork in the quorum of motion. Yes, but I hadn't had time to deal with it. And I had heard something coming down the pike, and I didn't want to go too soon. The reason is because something, I was waiting for it to be dealt with. Yeah, Zach, she doesn't need to read. I want to listen to these guys because I'm confused about something that Jules said. So let's listen to these guys. Okay, it is showing there. I'm big in it.
Lunchtime recap with Mert. I am Squeegee of Justice, also known as Chris, and this is Mert from
MertWitness1.com.
And
otherwise known as From the Desk of Mert Witness 1.
From the desk of, okay. And
I can't
Mert
understand
is,
him.
Up in the courtroom with us at the Sarah Boone trial here in Orlando, Florida. And we're happy that you could join us. We are not in our regular spot because there actually is a domestic violence rally going on right now.
Lovely.
Do you have that card you can show us?
Yeah.
Mert actually got a
this
card.
This guy, I was asking what was going on, and this guy gave me this card. And he does a podcast of...
no, it's backwards, I guess. Yeah.
Yeah, well, it'll correct itself on the...
Okay.
And what it does, and it's got this QR code. It may come through onto his thing. I'll get the QR code right up close. And it may read, it may not, because sometimes QR codes, if they're a little fussy, the phone won't pick them up. But
I find it interesting that here we are at Sarah Boone's murder trial, and there's a domestic violence rally going on. And the card says, I'm sorry, pull the card out again.
Yeah.
She has a hands-free phone.
The card says...
yeah, right, Zach.
The card says, the love of my
I'm
life.
going to buzz past the card because we may run out of time.
Get that reduced down to like 8 years,
okay.
Which ironically would have been what Sarah would have gotten if she had taken the domestic violence situation. She's gone, and the husband is only going to get 10 years in prison. And under
Oh,
Florida
that's why
law,
they're
you
there.
might get time off for good behavior and get that reduced down to like 8 years,
Okay.
which ironically would have been what Sarah would have gotten if she had taken the plea deal. She would have been out in 8 years.
Right.
But she chose to fight this, and now she's looking at 20 years.
Yeah. Well, a lot happened today, that is for sure, up in the court. Do you want to, let's see, just start from the beginning and walk us through it?
Well, we had witnesses today, and it was just a little bit more housekeeping. The highlight of this whole thing was this doctor that was brought in that evaluated her at the Orange County Jail. And what happened is she started testifying about her observations, what was said and everything. And all of a sudden, the defense objected right off the bat and started this unbelievably long argument about what she said in the original deposition and what she was saying in court. And they, to break it down, I guess, she said, and the very last question the prosecution asked, she said that she could not diagnose Sarah with anything because she didn't have enough information, and the defense is desperate to have something wrong with Sarah so he can argue that she was impaired,
right?
And try and get her off for a lesser included charge.
Right.
And the physician would not cooperate with her. She's saying, no, I had to have more information. And so we got into this thing, with the judge, and the judge kept asking him, I need a legal ground, of objection. There's a guide that all attorneys use that gives like 18 or 20 legal points you can use for objection, like irrelevant immaterial, badgering the witness, stuff like that. And those are the only things you just can't say, I object. You have to give a specific legal reason for it. And after all this debate with shuffling the jury out of the courtroom, the defense finally said, well, it's a discovery violation. We were not given this information in discovery.
Right.
And the judge kind of scratched his head, and I guess he finally said, well, it's something. And so we had what we call a Franklin hearing, and this is where if somebody is accused of making a discovery violation in the course of a trial, it's a Richardson hearing. And it's kind of it's just between the judge and the sides, and it's done right there. The jury goes away. And basically he said, yeah, the prosecution violated, but it was not intentional. And apparently what they're going to do is they're going to read to the jury a certain legal point about this, and then that's going to be the resolution. There's not going to be any, well, normally in a case like this, there's a sanction. And what the defense really wanted and didn't get is he wanted to strike the doctor's testimony. And the judge said, well, I am not going to strike. He made that clear. He said that doctor's testimony is going to be in there. He said you can go back on cross and correct what the prosecution did. And that's what she did. He came back and he started questioning the witness.
Giving like a deposition right there and then. Is that moment?
Yeah. He went through a deposition with the doctor, again, with the jury not present. And it got a little heated because he's trying to get her down on something. And he got into all the games, the texts, the phone calls, all the stuff, and she just would not budge.
Yeah.
And they were both getting pissed. I mean, she's getting aggravated, and he was getting aggravated because he you know, this woman was just not going to budge from her point. And so jury came back in and he went into questioning the doctor in front of the jury, and the same thing happened. You know, she was not going to budge, and this went back and forth, and we kept getting sidebars because either the prosecution or he would object, and then everybody had to go run into the sidebar.
Yeah.
And once again, the transcriptionist had to read back. Now, I forgot to point this out. And, you know, earlier in the process, we had a long break and all this because the judge wanted the transcriptionist to read back a certain portion of her transcripts, the proffer as they call it, and the defense wanted all 87 pages read. And the judge said, no, we're not doing that. He says, I am not holding the jury up to read a 87-page deposition. That's just not going to happen.
Right.
So he got his short thing in, which led to this on-trial deposition, which is something that's extremely rare. I've never heard of it.
I've never seen that either.
But it is done. But that we got that out of the way, you know, and like I said, came back and we went back and forth with her for about 5 or 10 minutes, and off to the sidebar he went, and it got to a point where the judge said, all right, it's 12 o'clock, we're going to lunch. So I don't know what's going to happen after lunch.
Right.
So that's what we're doing now. And I found out why we couldn't get anybody in there. We only had room for 10 people in the court. And it turns out all these students showed up, and it's the class that the judge teaches. And so we had a full class in there.
Well, we have seen the four altogether, two on either side of Judge Koenig.
Yeah, I think they are probably higher. These look like first-year law students, so it's a very young group. And I think probably those two, they're probably in their final year, or they're getting ready to take the bar and all that. So they came in and observed.
Yeah.
But these were probably his first-year law students, or that's what I gathered anyway, because they're all very familiar with the judge, and they were having a happy there in the middle of the floor when I left.
Right.
And they were getting together so they could have a class picture and stuff like that. So that was the interesting part of that.
Now, at one point, the Judge Koenig did allow intimate relation violence. Let me get this straight. So Owens was asking the expert, and I don't have my notes right in front of me.
All right. Well, what happened is that Owens started asking her yes and no answers to all different kinds of domestic or mental, prognosis to where he could find something exculpatory.
It was amazing.
To come back with and said, okay, she suffered from PTSD, she suffered from this, and this impaired her judgment, got into the drinking, and I think he got a win on a minor point. And I don't think the defense is going to win this one.
Yeah, it was battery spouse syndrome. She said maybe. But interpersonal or intimate personal violence, she said yes.
Yeah,
so he did get that in. He got
that's
that
a given in because they were beating the crap out of each other. I mean, so
and
it is a personal violence thing.
I think in the deposition the night before, right? Because she gave a deposition the night before, and he was being very vague and very wide open questions. And she's like, "Well, you didn't ask me those questions." And he's like, "So you have no opinion on that?" She's like, "Well, you didn't ask me specific questions."
Yeah.
And then Mr. J was like saying 99 out of 100 lawyers would come in and they would give specific, they would ask specific questions.
Yeah.
And then I think Owens finally got on board with it.
Yeah, he finally did a proper cross.
And he
was starting to ask her, because he went down through every possible thing that he could to try and pin on Sarah. And she just kept saying, no. And then we hit this one or 2 points, and she said, yeah. Said the drinking to some extent, but, but nothing that would have, justified this. Just, so the defense is really, and the jury's getting aggravated. They were swarming around, talking to each other, especially during the sidebar, because they were not happy.
Yeah, I was wondering what was the jury's reaction to all those sidebars.
Yeah,
and
because of what I could see, of them, they were kind of looking around, and they were taking notes during the thing. But while they're all sitting around waiting for the sidebar to get out of the way, they were squirming in their seats and stuff, because those seats aren't any more comfortable than where I was sitting. And here it is, 5 minutes to 12, and these people are getting hungry.
Yeah. Do you guys have any specific questions for Mert while we have him? He's going to scoot upstairs pretty quickly. Let me know if you have any specific questions for him while we continue on for a few more minutes. Let's see. Is there anything else you want to add? What else happened?
Well, no, that's basically it. This war wars between the doctor and Mr. Owen, and it's there were points in the sidebar where the judge was really getting animated. His hands were flailing, and him and Owen were going at it.
Yeah, he shut down Owens a couple times there.
Yeah.
Like, this is your moment, Mr. Owens. Ask your questions now. Ask your questions now. I'm not going to read through 86 or 87 pages of deposition right now. Yeah.
He was not a happy camper at all.
So Nessie says, how was the jury responding? You kind of touched on that, but overall.
Yeah, well, they were just, some of this took place without the jury, but the jury, during the back and forth between the doctor, were getting agitated. They were paying attention, but you could see a couple of them doing this. Oh, God, this chair's on.
Yeah. Was anybody taking notes or?
Oh yeah, they're always taking notes. That's the one good. They pay attention and they take notes. But you could start to see that they were getting a little impatient. And so finally at noon, the judge says, "Okay, lunch." And right before that, I said, it'd be nice to have lunch. And next thing you know, there he is.
Right.
So that was good timing. So now, this is definitely going to run over, and I'm looking at 6 o'clock before we're done tonight.
Okay.
Because they are running way behind. And I think what happened is the defense realized that this is going to go long. So 2 deputies that were going to be called either by the defense or by the prosecution were dismissed.
Yes.
They had been sitting.
Copsel, I heard her. Detective Copsel.
The judge brought them in and said, look, we're not going to need you. You're dismissed, not subject to recall.
Okay. Subject to recall still? Or?
No, they're not going to.
Oh, they're not. Okay.
They're not subject to recall. So they're done.
Right.
And he said, you're not to discuss blah, 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 blah.
Right.
And off they went.
All right. So you still, okay. So theoretically, they were supposed to be done today and get it to do closing arguments.
We were supposed to be done at noon.
Yeah.
And start giving jury instruction and going over a few things.
Right.
And that went out the window.
Yeah, that's how,
Because, because the funny thing is, I'm trying to think if the prosecution rested or not. Maybe somebody in the court think of time, because this thing got all.
I don't think so.
This thing got all screwed up. And I don't know if the prosecution is rested yet.
Yeah, you're kind of getting out of frame there, buddy.
Oh, sorry.
It's okay.
Yeah, because this is rebuttal going on. So, I'm not sure where we're at with the prosecution. So.
Yeah, they did not rest. I didn't think so.
Yeah, that's right. This is rebuttal. They wouldn't be resting.
Yeah, we did not hear they rested. Yeah.
But I'm going to be curious to see, what the prosecution has left after all this mess. Because now that I think about it, these are prosecution witnesses that came in that were dismissed.
Yeah.
So I think that the prosecution's trying to shorten this thing up.
Right.
So that so that they can get this thing on
get it to the
road.
jury. Yeah.
But it's anybody's guess now what's going to happen, because this is, we're going to be back at 1 o'clock, and he's got to finish up with this doctor, and I don't know how long he's going to keep this up.
Yeah. It does not seem like Brian Boone is going to be recalled or come up.
No,
I
got that figured. They answered that yesterday. Brian is not going to be recalled.
Yeah.
So that part's done.
Right.
But, I'm just going to be curious to see how the prosecution modifies what's left and how he modifies his close. Because now this is going to affect his closing as well as getting this rebuttal done.
Right.
And there's a lot of work to do because now you got to get the jury instructions done. You got to get the closing arguments done.
Mm-hmm.
Or prosecution, I believe, goes first, then the defense, then the prosecution comes back with a rebuttal,
mm-hmm.
and then it gets to the jury. And
right.
So all this has to be done. And we're looking at Friday. That's going to be packing in a lot.
Mm-hmm.
So I'm looking at late today, probably late tomorrow.
Mm-hmm.
And then what I am going to do is if the jury is given the case to deliberate, I'm going to set up a verdict watch here at the courthouse, and I will be live on my channel, but I'll be monitoring this channel as well. And so if the jury comes back while I'm in the courtroom tomorrow, I will chat in this room, plus I'll broadcast it on mine.
Yeah, a lot of times we do dual streaming chat. So if you want to have our channel open as well as Mert's channel open, you can talk with us. You can talk with Mert. We can cross-pollinate. Feel free to do that. And let's see, what other questions? You guys got any questions for Mert before I let him go? He's got to get upstairs in order to get a good seat. Drop a comment in. Let's see. Any questions for Mert specifically? We'll give another minute or two. Let's see what else. I don't know if I have. I think we pretty much covered everything.
Yeah, it looks like we covered it pretty much everything.
All right, everybody's saying go, go, go. All right. All
right, all we really got is I'm hoping all these law students go away.
Yeah.
We got all these darn.
There is a how's the sneezing going? Tammy and KS asks.
Be nice to the law student.
Well, I sneeze a little bit, and I do the. But to get rid of the coughing, I went out and I bought some antiseptic lozenges because the air is dry in the courtroom, and I get you get the itchy throat stuff.
Sure.
Because I know I was scaring Julian to death because of her situation, and I probably should have gotten a mask in case he showed up. But
Yeah, Jules, we hope you're okay. We'll text later. Interestingly enough, at the very beginning of this, I don't know if you guys saw, but there's a domestic violence rally going on, and I got some video, and I'll post that after we let Mert go. But if you see the camera shaking, that's because my arm is holding it, and I don't have anything to brace it on. So sorry for the shakiness. We're gonna let Mert go, guys. Check us out. Join us for the.
Okay, we're done with that. Okay. Oh my God. Y'all, this is freaking insane. Yeah. Here we have a really good, smooth, peaceful trial. Oh shit, it's the fan. Oh. This is interesting. I think my son just came in. I think overall the court has been amazing. I could not imagine how much more patient they can be. And I think what a lot of people are talking about right now is that Owens was not hitting his legal objections. You say objection, but you have to have legal standing. And he doesn't. He was just objecting to, I think, to buy time. I think there are like 17 legal objections you can make. Sorry, I've got something on my glasses. It's right in my eye view. I think this can possibly hurt the prosecution because the evidence the woman gave was so intermittently interrupted that what? I got something on my. It's like a film. Oh. So, give me a second, y'all.
Um,
Okay. My dog is so excited. She's sitting here holding her toy and banging her tail all over the place because my son showed up. This was this trial took a turn. I mean, this is the kind of crap that let me get the mic closer. There we go. This was the kind of crap that I expected to get from the moment we started this trial, and how we didn't, I don't know. We didn't get it. It is absolutely insane. Absolutely insane. Um, I am concerned that the testimony will get lost because of all the start and stops. I believe she ended well. I believe that expert deserves a gold star. What, Cincy? Well, come here. Up, 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 up. Come here. Come here. Come here. Oh, now she's running. She has her little donut in her mouth. I think that what frustrates me about Owens is when he objects, and I think that was frustrating the judge. What is your legal basis for your objection? And he was fishing for his legal reasons for objecting. Can y'all hear this? Why can't I hear it now? Why can't I hear her now? Why can't I hear it now? This sucks. I don't know what I did. There. Can you hear this? Good. So I'm believing that. Hold on. Okay. No sound. Can you hear me? You can hear me, right? Am I good? You hear me? I'm going to zoom back here and see if you can hear this. Okay, because it was not on. Okay, good. Wonderful. Okay. So one of the things that I hope that the jury understands and gets is this. And I think he said it. But whether they caught it, I don't know. And that's this. The diagnosis of PTSD, and by the way, I'm going to be very vulnerable here. I have extreme post-traumatic stress disorder. And for those of you who've been on my other live, the jail widow, which I got to get going again, you will know why. But I was disabled a long time ago, to the point I couldn't leave my home without people. It was horrible. And I was almost non-functioning person. It was that bad. But PTSD is not an excuse for unaliving anybody. Neither is battered spouse syndrome. It may be a factor. It may be a contributing factor. It may be something of that extent, but it doesn't negate the fact that you murdered somebody. And for me, I just realized I was 8 seconds behind when I answered data. It's okay. It is a lag. There is a delay for a reason. But I just hope and pray that the jury understands and sees through this and knows that, look, it doesn't, yes, there was violence, unhealthy relationship. They battered each other. Okay. That TV example, I think, fell flat for the defense. Why? Because number one, why would she sit there and record it and stay in that close of proximity to somebody with a baseball bat if she was in fear of her life? If I'm in fear of my life and someone has a baseball bat, do you think I'm going to be sitting within 4 or 5 feet of them while they destroy a TV? And you listen to them. She said somewhere, and I can't remember which, I can't pull it, but I remember her saying the TV was broken before he demolished it. And I think that was a drunken, let's destroy the TV. Because if you listen to his words, let me see if I can pull it up from my yesterday's live. If you listen to his words from yesterday, when he's destroying the TV, let's see if I can get it. This is when I wish I had mods that could pull things up and pop them into the Discord. I need a mod, not Discord, into my StreamYard. I need a mod who can operate or learn to operate my StreamYard and help pull up stuff while I'm live. If that's you, please let me know. Because while I'm talking, you can be doing this. Because I remember, where was it in her testimony? Okay. Trying to find it in this woman's testimony. I'll just do it this way. I think it's quicker. I'm trying to find it, y'all. I need to get a pin mouse. Where is it? But he said something about the TV. And if you look, there is something under it. It could be a rug. It could be something. But how many of us would sit there and watch our spouse, drunk or sober, bash a TV? And if you notice, there was one hole already in the TV. How do we know she didn't put it in the TV and then turn around? And I can't find it. If y'all can find it, But Zach, it's real super simple. It is so easy to run this back office. It's really easy. But anyway, we'll talk. But there was a hole in it already. How do we know she didn't take the first hit? How do we know she didn't take the first hit? That's what I want to know. And that's what I'm looking at. So that TV, I think that fell flat for them. I don't think that helped her as much as they thought it did. And today, definitely didn't. She looks disheveled. The team looks stressed. Everybody looks stressed, which is understandable. Why can't I find the video? Oh, frustration is hit. Was it with the dude? Was the video with the man or the woman? I can't tell you where oh, I just learned something today. Oh my gosh. If you pull up, when you got the arrow and you're scrolling and you pull up, it opens a thumbnail of oh wow. How is that helpful? Oh, that's awesome. I might be able to see it easier. There we go. Yeah, baby. We found it. Love the thumbnail. So I'm going to share this. Let me get over here and share. But I want you to see what I'm talking about. I got to get to it. There we go. Let me put it up on stage. Let me embiggen it. Okay. See, if you take it and pull up, I didn't know that would do that. Dagnabbit, and I just lost it. I wonder if I can move the bar or move this. Oh, I can. Oh my gosh, this is so cool. Y'all learned something new today. I love it when I learn new things. Let's find it. I wonder if I can. No. Come on. I know it's in here somewhere. I'm trying to prove a point, and you're not working with me. Okay, was it with her? I think we're a little further along than that. Does anybody know? Ronnie is an amazing mod. And I absolutely love Ronnie. I love all my mods, actually. Let's just start here and go back again. I love all my mods. I know this isn't professional, guys, but I'm doing the best I can. It was back in here somewhere. Oh, I'm disappointed, man, because I wanted to show you that, because that was, I think some people were thinking that was some very impactful. They thought it was super impactful, but I don't think it was as impactful. And if you pay attention to what he was saying, I think that it was less impactful. Oh, there's Zach's new girlfriend. Can somebody go back and find that and tell me the timestamp, please? This is driving me nuts. One of my mods, can you go and find the timestamp? It's in the first quarter. Oh, there it is. Never mind. We're on it. Whew! Finally, y'all. We're on it. All right. I want to play this. Volume up. Hopefully y'all can hear it. Why do we not have sound? Okay, let's play. Okay. This video. There we go. That's what I want right there. Pay attention to what he says. And there was a hole already there. How do we know she didn't put the hole in it and hand him the bat? And
you're gonna help me take this shit out. Real shit. You're gonna help me take it out.
You're gonna help me take it out. That
You're
wasn't.
Gonna help me take this shit out.
Looks like she already put a hole in it. I feel bad for the family having to see this, but did you see what he's saying? You're going to help me take this shit out. It was broken. What are your thoughts on this? I'm really, and everybody was going off about this video yesterday. And I'm like, I'm not. Look how close she is and that glass is flying. Why would she be sitting there if she felt threatened? He could barely hit it. He's so drunk. Why would she be there if she was threatened?
No good.
Exactly.
So why is she sitting there filming it?
Okay. So, in my humble opinion, as a juror, after hearing that first part, you're going to help me take this out? And he turns it towards her, and she's sitting there and calm. There's no yelling at her. He's pointing the bat at her like, yeah, let's have fun. You got the camera on? Yeah, there's no threats. Like, you see this? Whack, that's something to do to your head. Now, had he said something like that, I would be on a different game, but I'm not. What is in? Oh, it's that. Right. She helped him carry it out. So why are they sitting here? That to me was a wash yesterday. Humble opinion. Means not much, but that's my humble opinion. Now, as far as today is concerned, oh my gosh, look how gray I'm getting, guys. Oh, my son wants me to embrace my grays. But honestly, my heart wants to be that again. I want to be that again. Anyway. I don't see where there was a single incident that they proved that he walked up to her and whooped her butt. Everything that came in that I can remember, she also was involved in. It was a tit for tat. I will tell you, if I had beautiful gray hair, I'd rock it. I would rock it. I love gray silver hair. I think it's great. Oh, thank you, Toy. I really appreciate these, you guys. I really do. You have no idea how much I appreciate the super chats. It's greatly needed, and I love you for it. But anyway, Zach, when we're not in a trial date, I want to visit with you. I want to talk to you about something. No, y'all keep it clean. But yeah. Oh, Zach, my condolences, honey bun. You know, my heart goes out to you. It really, really does. Your cheesy white milky legs are taken by another woman. You got beat out by a woman, honey. Oh, thank you, Toy. Again? Oh, you meant Zach. Zach's gorgeous too. All of you are. So, we are in the next is a melody trial, and they actually are in actual testimony. No more recording. So we're going to hop over there for a little bit. This might seem, this was the most interesting thing yesterday. Now that's totally opposite. Let's go live here. Okay. We are live. Volume is up. Why are my things? Okay, guys, while we're sitting here, I need to readjust some things. Some of this stuff just ain't working. Yeah, I got some issues here. Oh, really? Okay. What does fire mean? Let's edit this one. I'm going to do an edit, guys. Please hang in there with me. Let me see how this does for the moment. Adair, that is your formatting, not mine.
Thank you, Art.
All
right, Sergeant
I am
Hayes,
on the opposite side because I saw you.
Instead of showing the picture of
but
you on the
it's
tractor,
your
I want to go
format.
back. I noticed something you said yesterday regarding, or maybe it was 2 days ago, lost track of time, but regarding the tractor. I believe you said, and that's why you were sitting on it because, you know, you and me aren't the tallest guys in the world, that it was in the furthest back position.
Yes.
How did y'all figure that out?
I was out there with some investigators from the district attorney's office at the time, and I believe they attempted to adjust the seat and determined it was all the way back.
Okay, and so y'all's method of kind of testing out whether anybody could touch the foot pedals that was short was they, you know, had you sit in it.
Correct.
But, I mean, you're taller than Melody.
I believe so, yes.
Okay, all right. Because you're what, did you say about 5'7", 5'8"?
5'6".
Okay. But still taller than 5'3", somewhere in there.
Correct.
All right. But y'all tested and verified. I mean, it was in the back position.
Correct.
All right. I want to go back to 2018 into 2019 and talk about, again, your follow-up investigation with Chris and Scott. I went back and counted your phone calls with Chris and Scott, and there was a number of times that they would reach out to you, yes?
Yes.
Right. And would it shock you if you had 6 phone calls with Chris Ferris in 2018, 2019?
It wouldn't shock me.
Right. And you had also were you aware that Scott called 911 about 6 times on Melody?
I knew there were some 911 calls involving the
Do you remember anything about those? Because it looked like a lot of those kind of got routed over to you.
I recall. I don't recall Scott calling 911 per se. I don't know if I was involved in those. I know there's some allegations that were made between the family that were routed to the sheriff's office, and given the situation, we routed them to another agency to investigate them.
And that was Woodstock, right?
Correct, Woodstock Police Department.
What were you seeing about the kind of the difficulties going on between Scott and Melody through 1819, and Chris for that matter?
There's definitely some contention.
What do you remember?
Tension between everyone, fingers still being pointed at each other. I'm pretty sure. Arguments.
Do you remember any specifics of these arguments? Do you remember that Scott was alleging that his mother was going through his stuff in his apartment? Do you remember any of that stuff?
I do recall that, but again, once we would get the allegations, we would try to stay out of it and let a third party investigate it due to the investigation we were currently running.
Right. But to your knowledge, Scott was, and then there was some threats that were alleged that Scott made against his mother.
Yes.
To your knowledge, Scott was never arrested, correct?
That's correct.
And you had a number of follow-up interviews. I kind of want to talk about, we talked yesterday that, you, for a while there, you're kind of on your own in this investigation. But as time went on, and after you applied for the warrant and the warrant was granted for Melody, there was kind of a second phase of the investigation. Would that be a fair assessment?
Yes.
All right. Could you explain that to the jury?
Once the warrants were taken, the district attorney's office became more involved. They started reviewing the case more heavily and coming up with tasks that needed to be completed.
Okay. And some of that was spending time with Scott and Chris, correct?
Yes.
All right. Tell me about the interview that you had with Scott on 9/20/2019. Do you remember that? You spent a number of hours with him at the sheriff's department.
I called him in for an interview. You said September the 20th?
Yes. And if you've got your report with you, please take your time, refresh your memory on that.
I like to do that to my hair. Isn't that cute? Girls.
You have a page number?
You'd appreciate it.
I'm sure it's sort of the back.
I don't know that song. Come on, baby, love my fire.
What do I remember about it?
Yeah, what do you remember about that interview?
I just, asked him to come back in for another interview.
All right. So do you remember that you spoke with him kind of at length? The first part of the interview would have been friendly. It sounded friendly. I think y'all even took a break together.
Sure.
You remember that?
Yes.
Let him go take a cigarette.
Yes.
All right. And but after that, you kind of started to hone in on him as to the issue of, you kind of looked at him and forthright said, all the bullets on this property are out in your barn. And he said something to the effect of,
yep,
that looks pretty bad. Do you remember that?
I don't recall it specifically, but I'm sure it's on the recording.
Okay. And do you remember that, you started to kind of press him on, the use of guns and being on the property? You've seen the videos that's been played for the jury about him out there with his buddies kind of doing tactical shooting. Do you kind of remember kind of asking those questions?
Yes.
And I believe after that, that's what led to y'all going out and actually scouring the property for these bullets. Is that correct?
Correct.
That would have been the search warrant where y'all went and did that.
Yes.
Right. And that would be the bullets that I believe were testified to that just came in much later.
Yes.
With the expert from the GBI. But you were on. You kind of shifted. You were doing a further investigation into Scott.
Yes.
Correct.
Correct.
All right. And then there was another interview that you didn't conduct with the GBI. You didn't have anything to do with that. But then you followed up again in May of 2020. Do you remember that? What about May 20th of 2020?
And there's supposed to be an emergency latch to get out. And for some reason, no one knows why, but other than the signs, the doors are closed by themselves, and an emergency latch.
You don't recall that one? I don't know that it's in any of your reports. It was a short interview.
You're like screaming, and like people won't.
Okay. And what you did in that interview, and see if I can refresh your memory so that we don't have to shut this whole thing down and play it for you.
Here's another one. Did you know that half of the
You actually kind of have a map, little dots that you were showing.
Yes.
And kind of saying to him, you know, your phone better not be one of these dots. Yes. You remember saying that?
I do.
Okay. And you were at that point asking more about any revolvers that he'd ever had.
You know what happened?
Revolvers,
The day after the
kind of digging further into his life. You were digging into the fact that he had been previously married. You never brought that up. You remember that?
Yes.
Okay. And you also had ascertained that he had a .357 Magnum that he had stolen from him in Columbus.
Yes.
And you've seen, and I can go get them back out, but you said, you know, you better be telling me the truth because I'm going to call Columbus. Did you ever call Columbus?
I don't recall if I did. I know one of the investigators with the district attorney's office at the time, we looked into it, and I think we came to the same conclusion.
All right, and the same conclusion being there was never a report made of stolen.
I want to try to go to Orlando.
I want to talk again about the Colyos. I mean, with the jury's listened to about three or four Colyos, but this was something every day for a year.
Yes.
I mean, just like you get a text message on your phone or a call, I mean, you just get an alert every time.
Yes.
How many do you think there were? I mean, realistically, my guesstimate would be about 1,000 or more.
Well, I would say thousands. Yeah, between text and phone calls. Yeah.
Okay. So, and you listen to all of them?
No.
Not possible. I know. I mean, and I'll be forthright with you. It's not. We tried. It's not possible. But there was thousands of phone calls.
Yes.
And out of those thousands of phone calls, there was never a confession, correct?
Correct.
All right. And the phone call that was played yesterday, that was from 8, I think it's up there somewhere. The phone call that was played yesterday was from 8/2 of, let me go back to my.
Oh, we're just watching the Melody Walker Ferris trial while we're on break, although we're getting ready to go back into court. There's people moving. And then while this is going, I'm going to be working on my homework.
Okay,
It's
so the
tomorrow.
list of Rusty interviews,
Hadn't started yet.
you guys had gone up on 8/2/2018, right?
Yes.
Okay. And on that day, that is the day that y'all had given him that warrant.
That's correct.
And so later on that day, that same day, that was the phone call that we heard,
Yes.
the jury heard?
Yes.
And in that phone call, so would you say that was the phone call where Rusty was really pushing her for an answer?
Yes.
Because it sounded that way to the jury.
Sure, it did.
And I was thinking of something yesterday, and I'm just going to say that everybody knows kind of the way I ask questions sometimes can be I don't know what the correct word for this is, but you know, it seemed like Rusty did a better job of interrogating her than you guys did. Would you agree with that?
Well, we never got to the point of interrogating her. It was early in the investigation when we interviewed her, and didn't after that. So.
All right. So, but he was pressing her.
Yes.
All right. And that was it within that same, hours of you literally putting a warrant in front of his face that had, was it conspiracy to commit murder?
Yes.
And the other one would have been concealing the death of another?
Correct.
Any other counts on that?
I believe that was it.
You just typed it up?
Yes, it was
Signed Hayes on the bottom?
No, it wasn't signed. It wasn't signed.
His tie doesn't bother me
spot
that
for the
much.
Affiant, which would have been me, was blank.
Seen
and
worse.
Where the judge would have been was blank.
Okay. Had you ever done that before?
No.
Okay. Whose idea was that?
It was a group. I don't recall exactly who it was. You know, that Monday morning, typically on Mondays, we would have meetings, briefings about the case, and it was a strategy that was mentioned.
So after you were kind of, I think circles have been you've used the word circle, but then you kind of widened the circle back again and went to Scott. Why did you ultimately move away from Scott in 2020 after you'd interviewed him multiple times?
We interviewed him multiple times throughout the investigation. His statements remained consistent. Scott didn't have motive. Even Miss Ferris, when we interviewed her, stated that Gary was his gravy train. Without Gary, Scott had nothing.
But by that same logic, wouldn't that have applied to Melody too?
Not necessarily.
Can you explain that?
Like you've stated multiple times in this trial, in Georgia, what's Gary's is Melody's and what's Melody's is Melody's. So even when there's a will in Georgia, it can be contested. So just because there's a will, leaving everything to everyone else. Throughout the investigation, we determined Melody was the beneficiary of all of Gary's life insurance policies.
But you would agree with me by that same logic. If she is falsely accused of murder, then the siblings take the rest of the assets, yes?
I don't know how it would be contested in court after the outcome of this.
But you would agree with me that if she's out of the way because of a murder conviction, then they would stand to inherit everything, yes?
It's possible, yes.
All right, so that's motive, right? Could be.
Yes,
Could be.
Could be.
Y'all, I need a necklace. I keep saying that. I don't have one. At least that small. I want something pretty and dainty.
You heard that phone call yesterday. There was this other attorney before we got in this case, Manny, and he went out and did an investigation. Did you do a follow-up investigation after his crew went out? Because you heard it in that phone call.
I don't believe we did, no.
All right. But it sounds to me like their investigation there was more that was looked into. They actually luminol things that you guys didn't luminol.
I never heard in the phone call him say that they luminol, but it sounded to me like they went out and looked what we did, and it was no longer glowing. Melody said at one point in that phone call that it should still be glowing if it's blood, which indicated to me they were looking at what we had done. And I know after a certain point, luminol flashes or blue star, even on blood, it doesn't last forever.
Detective Hayes, Sergeant Hayes, you're Detective Sergeant. I know you.
No!
And I know I hinted around at this yesterday.
That was a slap, y'all.
Stop talking to you, and this will be finally over.
You ass. That was a slap.
But I do want to know this. You have sat here and watched every bit of the people that were supposed to be helping you in this case. And does it not frustrate you? Just even if you could have, from your very perspective, checked off this box, that's done. Don't you wish that they would have done some better crime scene intake over at the barn?
Knowing what I know now, I wish I could go back and change some things. That's an accurate.
But not everybody's
Wish
perfect.
That, they could have luminol Scott's apartment. Yes?
Possibly, yes.
You just basically anywhere and everywhere, right? In the barn.
Ideally we would have had unlimited supply of Blue Star, which I believe is why the GBI was called in, because we ran out. We just didn't have a lot. To luminol or Blue Star everything.
If I could turn back time.
Yes.
If I could find a way.
More upstairs in the house and more downstairs.
Sorry.
I'd have covered the entire property.
Y'all got it going.
Absolutely.
It was your fault, not mine.
Hindsight is always 20/20.
Absolutely.
And I'll ask you this, because of the breadth of this investigation. I mean, it's almost like fighting a war on three fronts. It's almost impossible historically for any country has that hardly ever won a war on three fronts. You had a barn, you had a fire, you had a house, you had three different scenes on the same property, multiple individuals, but it was a three-front war, and that's never really been won until the United States in World War II, best I can tell. So it was a lot. It was a huge undertaking to try to process this case. Yes?
Yes.
Would it have not been beneficial to have all of the assets of the GBI come and take over this investigation?
I don't know if it would have been beneficial to have their help. Yes.
Okay. So hindsight being 2020, that probably would have been one of the easiest things you guys could have done to assist in this large investigation.
Oh my gosh.
Repeat your question. It could have been the easiest.
The solution that is designed essentially by the GBI to assist local agencies, that mechanism that they've created that's all over the state, that they go everywhere.
Mm-hmm.
That would have been the best thing that you guys could have done in that situation to process this crime scene.
We did call them in when we felt we needed help, and they came in and performed the task that we asked them to do, and then we felt like we had the rest of it covered.
So the answer is you wouldn't change anything?
There are things that I would change, but as far as the GBI specifically, I would not have called them in to take over now.
Your Honor, if I may have a moment.
Do you know what my problem, Toy, is? I can sing, but I can't hear myself and I can't hear the music, so I can't match my pitch with them. A cappella, I'd be fine. I used to be a singer, both praise teams, and I used to be in barbershop courses and quartets and competed all over the place, and top 9 in the world in the chorus, 5 in quartet. I mean, I've done it all as far as that, but I know it's hopping on. I see it. But unfortunately, I can't match pitch because I can't hear well enough. Sorry, y'all. I got you, Ronnie. My feed just started. You may be on a different feed.
Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Steve Castro on behalf of the state. William J. for the state.
Defense.
James Owens for the Boone.
Can we change sides?
Kevin back on behalf of Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Are we prepared to bring back in our jury at this time, state?
Yes, Your Honor.
Defense.
No, sir.
Yes, sir.
I'll make another motion. Judge,
Of course you would.
This transcript, and I'd like to draw your attention to a few pages.
Which transcript are we referring to, sir?
The October 4th, 2024 deposition of Dr. Tanya Werner.
Okay. Yes, sir. I have it in front of me.
May I sit?
Yes, sir.
I'm referring to page 38 at the very bottom, line 21. Answer, I need to go through my notes and think about it and process it. But I had other depositions, as you were aware yesterday, so I had to prepare for those and go through that. So I had not had time to process through all of my notes prior to this deposition today. Page 39. Line 2, well, doctor, I'm not trying to inconvenience you. You know, the judge set for October 7th for jury selection. Line 5, she answered, okay. Question at 6, but I don't anticipate your testimony would be until later, you know. Maybe we could discontinue your deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and then you have other opinions that are not going to be covered. And at 13, Mr. J says, what is your position? And at 14, Mr. J, conducting discovery after the jury trial starts is completely unacceptable to me, so that's my position. If she needs to issue a supplemental report, or if there becomes a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once the jury is sworn and jeopardy attaches.
Line 23, Mr. Owens, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. The witness on line 4, page 40. But if that happens, I can bring that forward, and then you can add to your deposition at that point. If my opinions change after having reviewed further. Line 8, Mr. Owens. Mr. J. Line 9, Mr. J. I think you need to plow ahead. This is our time where the court reporter is prepared to give us a transcript by the end of the weekend. And if something needs to be amended, then she can A, issue a report, and then B, if you need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Line 23, page 40. Mr. Owens, I'm not suggesting that, Mr. J. I'm suggesting that we just said at the very beginning. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnoses or opinions. Then Mr. J goes, I think he gets confused about an issue relating to a diagnosis of an adjustment disorder or anxiety disorder. So we get down to the bottom of page 41, line 22, Mr. J. Okay, so on this topic, if something new comes up, then we can address it. But if we have other topics to depose her on, then I would suggest we go on. And then page 42, line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot and formulate any other opinions, just let the state attorney know and we'll address it. Line 7, the witness, absolutely. That was our understanding. I've been ambushed by a new opinion that I was not made aware of by any kind of report. I was not notified by Dr. Werner. I was not notified by the state attorney, William J. I first heard about the opinion when she testified to it, and I objected to it, relating to imminent threat, the ultimate issue of fact. I moved for a total dismissal of
He didn't even get the last part of that word out, and he's like,
of the
denied.
deposition, specifically that you made reference to, starts at page 21, line 21. The question preceding that is important. Question 14. So from my understanding, when you just said was, yeah, I agree with general anxiety disorder that she had been diagnosed with. Answer, no. I said it would be generalized anxiety disorder versus adjustment disorder, and that I hadn't had time to fully formulate that opinion out. This entire conversation pertains to those two issues, anxiety disorder and adjustment disorder. Has nothing to do with PTSD, nothing to do with battered spouse.
But Judge, we go on, and I see what she's doing, that she's saying, hey, I got jammed up. I had a deposition yesterday. I didn't really have time. Evaluation, deposition 2 days later, she had a deposition in between. So really think about my notes. So as a catch-all, I said on page 40, if you have other opinions or other diagnoses after she has more time to think and review the paperwork, then obviously that creates an issue. So yes, that was initially what she was talking about specifically, but I realized what she was saying was she was going to have to reflect on a lot of these opinions. So
that's respectfully, sir, that's not what it says. That's specifically in line with the anxiety disorder versus adjustment disorder. That was the entire topic that was being conversed with. Now, later in the deposition, there are references, as I believe that I identified previously. Give me a moment.
You guys, let me ask you, honestly, Because
page
y'all are my
59,
regulars and I love
line
you.
22, question is asked, okay, and do you intend on expressing any other opinions other than what we've spoken about here today? Line 25, no. I will answer whatever questions I'm, moving to page 60, line 1, asked.
Do y'all
Page
like
60,
the sound effects? Yes
line 11.
or no?
Well, let me just start with 2 because it gives
Honestly.
it more context. Question. Well, I'm asking now. I mean, you're the expert. I'm not. You're the one that's evaluated her. You're the one that's given her the test. I don't know the field like you do. You know the field. I understand you've said, hey, I want to think some more about, hey, I want to think about this some more. I want to review my notes some more to see if, but in terms of right now, without any further reflection, without any further answer, yes, sir, question, reading of the notes, any other opinions that you think you could express in any form or fashion with all this experience, almost 1,000 jury trial or 1,000 trials you've testified as an expert. Anything else that comes to mind that may be an opinion that you might express in Sarah Boone's case? Answer. Anything else that I'm asked with regard to her diagnosis come into play with regard to her case, I guess? Question. What other opinions do you believe you're qualified to express as it relates to Sarah Boone and the facts and circumstances relating to this case? Anything with regard to her diagnosis, I guess. 61. Of those 4 things we mentioned, line 2, correct.
And Judge, the 4 things were mentioned were related to the anxiety disorder, the narcissism, the battered spouse, the alcohol use disorder, which are in pages 58 and 59. But the overall thrust of that was any other opinions that were expressed. That was in good faith what we were doing. I would have, like I said before, I would have never taken her deposition. Once she said I hadn't finished my analysis and I may need additional information, just like he said the other day, Dr. Harper,
that one?
If you get those additional medical records, Mr. Owens, about Jorge Torres and give them to Dr. Harper, then I'm going to want to take her deposition again. The same rules apply. Why would I take her deposition when she hasn't finished?
You don't like what she has to say, so you're being
because there were concerns about being able to have all of this done prior to trial, and you had concerns about what she was going to testify to. And the court set a scheduling order as to when, how, where, and the deadlines for those depositions to be conducted.
That prosecutor should have let me know if he was going to ambush me at trial. I should have known beforehand about a new opinion that Dr. Warner was going to express, especially related to battered spouse.
Well, where's that one?
And whether or not there was an imminent threat at the time of this event.
And the courts addressed that. Court did exactly what was required by binding precedent by the 6th District Court of Appeal and held a Richardson hearing. Analyzed the 3 factors as required by Florida law with regard to those and gave you the opportunity as a cure. And with regard to your request to strike or dismiss the case due to prosecutorial conduct, the case law by the 3rd District Court of Appeal filed April 10, 2024, State of Florida versus Denninghoff, Denninghoff, and I can provide you a citation momentarily, states that dismissal is an extreme sanction to be used with caution and only when a lesser sanction wouldn't achieve the desired result. Specifically, dismissal of an information or indictment is an action of such magnitude that resort to such sanctions should only be had when no viable alternative exists. There were multiple viable alternatives, including but not limited to my request, an inquiry of whether or not you wanted that struck, and the instruction to strike that opinion, which you demurred and said, no, I want it for cross-examination. And I gave you the opportunity twice to depose her here in open court, which I oversaw with regard to any opinion that she had based on the proffer or any other opinion that she would be offering today. For those reasons, the court is not going to exercise its discretion and strike due to the extreme nature of striking a criminal charge and for the adequate remedy that has been provided to you. Is there anything else, sir, we need to address?
May I supplement the record?
Yes, sir.
Not end on page 40 or 41 or 42.
Don't mess it up. You're winning, dude.
Examination of this deponent for 68 pages. And then it was turned over to myself for cross-examination during the deposition. Beginning on page 75, I asked the deponent, what did the defendant say about the murder? What she said on page 78 was that, starting at line 13, and she said there was a suitcase and some clothes that had gotten out to donate, and they were trying to get that together. And it was on the floor in the living room. And that, as she was coming down the stairs, she saw him kind of slipping into the suitcase as a hiding place. As she said, I saw him in the suitcase and I zipped him up and we were laughing. She said then he said he couldn't breathe, and I remembered feeling I couldn't breathe when he was choking me or sodomizing. And I was angry and I shook the suitcase. I lost control of the suitcase and it flipped. And she goes on and
I don't want that
about
picture
what
in my
happened.
head.
Defense counsel was there. He heard this testimony that there was no imminent danger presented at the time that she began getting angry, shaking the suitcase, hitting him with a bat, so on and so forth. And he didn't ask her that question after she had specifically instructed him, if you need an opinion of mine, you've got to ask me the question. It's unfair to experts to be thrown with this catch-all provision of please tell me any opinion about this case that you may think is relevant. Well, what the doctor may think is relevant is different than perhaps what counsel thinks is relevant. So it's really an unfair criticism of the state and probably more likely self-reflective that this deposition, this opportunity to ask about this obvious issue did not occur. So
he had opportunity.
that is what I would like to supplement the record with. The deposition was substantially longer than page 41 or 42, where it's acting like it's concluding and is there anything else? The state would just submit, I understand very well what my ethical duties are. I do not have any ethical duty to provide him an unrecorded statement that is not inconsistent with prior testimony. This doctor did not give me any unrecorded statements inconsistent with her testimony. Thank you.
Thank you.
Judge, I'd like to add on page 79.
No!
Dr. Warner claims that Sarah said he put his two fingers out and I hit them with a bat. So there was rule of completeness. But for him to say that that's not standard operating procedure when you're taking a deposition of an expert.
Mr. Owens, I've ruled, sir. I understand. I understand your position. However, the questions that were specifically asked, which gave rise to this, specifically pertain to opinions of PTSD. I'm not going to rehash any and all of those things. The record speaks for itself. The court has ruled. Your motion for dismissal of the charges is denied. For the record, the citation that the court relied upon with regard to Denninghoff is located at 388 Southern 3rd, 10055, located at pinpoint 1057, Florida, 3rd District Court of Appeal, April 10th, 2024. With that, are we ready to bring back in our panel?
No, sir.
Okay.
Judge, I've got Earhart's Florida Evidence 2023 edition, volume 1, Charles W. Earhart.
I've already, let me tell you how you're going to rule on this, sir. I'm going to allow you, as I said up here at sidebar, to go into the facts that she relied upon and what it is that she utilized. I'm going to allow you, sir, as I said up here at the bench before the lunch hour, to go into those opinions that she didn't offer here today. And on rebuttal, Mr. J, I'm not going to allow you to stand up and say, may I voir dire, that wasn't one of your opinions today. You can address all of that and redirect. Is that clear?
Clear to state.
Judge, let me just review to see if, because I had several.
What you had inquired of me, Mr. Owens, up here was that you wanted to go into these other facts, medical records, text messages, statements. And you said, if I can't do it now because he's going to object, I'm going to call her and assert rebuttal. And the problem, as the state pointed out, is that you can't use her as a conduit to admissible evidence on direct examination. And that if you want to do it, you got to do it now. And your argument was it goes to her bias, it goes to her credibility, and that you're permitted wide discretion on cross-examination. I agree with you. I agreed with you before the lunch hour. My ruling hasn't changed. I'm going to absolutely allow you to go into those things.
I appreciate that, Judge. The other thing I wanted to readdress was
I'm taking care of it, Counselor. Give me a moment. Yes, sir.
Judge, I'm referring to Earhart's treatise, section 9.703, opinion on the ultimate issue. I'm on page 933. Testimony in the form of an opinion or inference otherwise admissible is not objectable because it includes an ultimate issue to be decided by the trier of fact. And in that section 703.1, it talks about that opinion testimony is not inadmissible solely because it includes an ultimate issue to be decided by the trier of fact. The provision is equal.
Honey boo boo.
The jury has the power to accept or reject the testimony.
We're not going to get to jury till tomorrow, and I'm not going to be here.
Bound by their conclusions. Merely because a witness expresses an opinion to an ultimate issue does not compel the jury to find the facts to be true. The jury will be given the opinion. The jury will give the opinion as much weight as it feels the opinion deserves. Then it goes on. The abolition of the rule against opinions on the ultimate issue does not mean that all other opinions are admissible. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury to determine what occurred. For example, a witness cannot express his or her opinion as to the guilt or innocence of a criminal defendant.
I would say at this point,
Page 940.
we're going to take a recess. Both the lead attorneys meet me in my
When a witness
chambers.
is asked to express an opinion that applies a legal standard to a set of facts, which Dr. Warner did, the opinion testimony is generally inadmissible. The danger is that the witness will apply a standard or definition which is different from that defined by the applicable law. The application of erroneous legal standard results in the opinion testimony being misleading and not helpful to the jury. For example, an expert cannot opine whether a nursing home was negligent in its care of the decedent.
It's exactly what we spoke about at counsel's table.
I know, Judge, but if you go on, it says
Oh my
may not
God.
be permitted that a
That
truck
judge has a
driver
patient
drove his gross,
of freaking
drove in a grossly
Job.
negligent manner, whether the sheriff's conduct was unconstitutional, whether certain waters are navigable, whether the defendant's action constituted misapplication or concealment of funds, or the legal obligations of the parties to a contract, whether the testimony of the expert is a permissible factual conclusion or the impermissible application of a legal standard or definition to a set of facts is sometimes a fine distinction involving a large measure of discretion with a trial judge.
That's on her.
For example, the admission of expert testimony that certain investments, it goes on.
Look how much, look at that. Think we've been shortchanged?
However, the witness expresses an opinion about the intent of the accused. The opinion, this is one of the important sections. However, if the witness expresses an opinion about the intent of the accused, which Dr. Warner did, the opinion has not been permitted. The distinction drawn by the courts as to when this type of opinion testimony is admissible are often not clear. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This expert testimony regarding substantive legal principles may not be helpful to the jury and may create confusion if an expert testifies in a manner that is different or even in conflict with the testimony of an opposing expert.
But the citations, respectfully, counselor.
But if I could finish.
Respectfully, counselor. The citations that you're referring to are not at issue. Fluellen, error to permit arresting officer to testify that a quantity of cocaine possessed by appellant indicated that he possessed with intent to sell, which is a specific element of the charge in that case. Gamble. Officer's expert testimony with the amount of drugs found in defendant's possession was inconsistent with personal use and therefore intended for sale was inadmissible. 644 Southern 2nd, 1376 for Gamble, and Fluellen, 703 Southern 2nd, 511. The Dinkin case that I read says this is acceptable. If a psychologist or psychiatrist can testify that someone is not mentally defective or was mentally defective, that's on all fours with based on what the defendant had said to this expert. She was not in imminent fear. Now, I don't remember exactly what was said, but it was along those lines, based as looking all those things, the totality of the circumstances of what, in my evaluation, on or about October 2, that the defendant had said to me as the expert, it's not imminent fear. That opinion is not inadmissible per the case law under Dinkins.
Judge, can I read a little bit more?
I think
you're just going to be
you
reading
guys
from the
need to
treatise,
take
I've
this
already
to
read it.
Chambers.
I just want to make mention, because it's talking about does not prevent a witness to testify about legal conclusions or express opinions on questions of substantive law. And I was about to finish this text, this section, when this testimony, and I'm on page 947, this testimony may also interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. As we know, we're going to do battle over the jury instruction on justifiable use of deadly and non-deadly force. The testimony from Dr. Warner, and I wrote it down. She said, based on what Sarah Boone told her, she was not facing imminent risk of harm. That invades the province and function of the trial judge to determine the applicable law and to instruct the jury otherwise, which we haven't even done yet. You haven't made findings of law about which instructions apply. That's what she did, Judge.
Your objection's been made for the record. The court previously ruled on this matter. I appreciate the additional argument, but the court's reliance on Dinkins remains. Just because 9703 speaks for itself. So your objection is overruled as to that issue. Anything else we need to address, Mr.
And
Owens,
if you continue, you're going to be in contempt of court.
State?
Nothing. Thank you, Judge.
Okay, let's bring back in our panel.
I'm keeping my mouth shut.
You may bring the jury.
That is crazy. And I bet that judge is so done. I would have had him back in chambers by now. I would have. And if you didn't catch it, I'm eating lunch.
Judge, should I push the letter now or what?
You can just stay where you are, counsel. Just wait for them to come in.
I did it for you. Y'all. That was an inhale of a lunch. Ate fast. Too fast.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Thank you. All could be seated. Members of the jury, welcome back. Juror number 2, back row. He's already ready. I see those hands are raised. You know what's coming. Y'all complied with the court's instructions, right? Thank you. Record reflect all hands have been raised. Mr. Owens, you may continue your cross-examination, sir.
And don't step out of line.
Dr. Warner, I don't want to rehash it, but just for the jury's sake.
Oh, God.
It'd be fair to say that the text messages that you were forwarded by the state attorney by the state attorney for you to review, you did not deem to be relevant to your evaluation.
Right, they demonstrate.
Amendment says yes or no question.
Yes.
Now, from what I understand, when the state attorney sent you the information, they did not send you any videotapes.
Correct.
So you have not reviewed any videotapes in this matter.
Correct.
The Suitcase videotapes, either one of those you have not reviewed.
I have not seen them. Correct.
Or any body cam videotapes you have not reviewed.
Does she need to?
They're described in the police report.
My question is, have you viewed any of the body cam videotapes relating to this incident?
I have not seen them. Correct.
Prior incidences between the two of them, have you reviewed any videotapes, body cam videotapes of any prior incidents?
I have not.
Have you reviewed the audio tapes related to some of the questioning of Sarah Boone?
I have not.
Have you reviewed the autopsy report?
It's described in the incident report, but I did not see the actual autopsy report.
She wanted
Now,
a clean
you're
slate.
aware that
her
we have
in front of her
called two experts, Dr. Michael Brannon and Dr. Julie Harper. Is that correct?
Yes.
And you're aware that they are forensic psychologists.
That's correct.
Oh, no,
and
you don't.
You are a forensic psychiatrist.
That's correct.
So they didn't go to
gonna
medical school and you did.
potty the dog.
And they don't understand medical issues, so to speak.
I don't have an understanding of what they understand medically.
Do you recall telling me that they don't understand medical issues, so to speak?
They haven't been to medical school, but I wouldn't understand their medical knowledge.
If you would look on page 22 of your deposition. Objection collateral.
Approach.
Sorry about that. I lost a
Objection's
cord.
overruled.
I had to get a cord. My mouse died.
Warner, have you had a chance to review your deposition on page 22, starting at line 7?
Yes.
Could you read down through line 11 your answer?
Yes, I'm talking about psychologists in general, not with regard specifically to your experts, which is what you were just asking me about.
Okay, but you would agree, your opinion is psychologists typically do therapy, but they don't prescribe medication or understand medical issues, so to speak.
Correct.
Overruled.
But I wasn't specifically talking about your experts, which you were just asking me about your experts
Okay.
specifically. And I said I didn't understand, I didn't know what their specific medical.
Right, that's what you said under oath, October 4th of this year.
Correct.
Sustained.
Now, is it fair to say that the majority of your work is in the field of competency to proceed and guardianship evaluations?
Actually, the majority of my work is in patient care. I work 7 days a week on the crisis stabilization unit, actually treating patients.
You work 7 days a week.
Yes, sir.
So as a forensic psychiatrist doing forensic work, the majority of your work in that area is in the field of competency to proceed and guardianship evaluations.
As a forensic psychiatrist, correct. As a psychiatrist, I work 7 days a week on the crisis stabilization unit.
And where is that unit?
It's located in Lake City, Florida.
So you work there 7 days a week.
Yes, sir.
And then on You also do this forensic psychiatrist work doing competencies to proceed and guardianship evaluations.
That's part of the what comes under the umbrella of my forensic work. Yes.
That's the majority of your forensic work.
Yes, that's the majority. That's the most common cases that we're asked to.
And then next in line would be sanity at the time of the crime.
Yes.
So you would make a determination and submit a report to the court as to whether or not a defendant, an accused, is legally sane or not at the time of the offense.
Yes, that's correct.
Is it fair to say that you also testify weekly as a treating physician through Baker Act Court?
Yes, that's correct. Every Thursday, we have Baker Act hearings with regards to our individuals who are being held in our crisis stabilization unit.
Is that in Gainesville or Lake City?
No, sir, that's in Lake City.
Now, Lake City from here is north of Gainesville?
Yes, sir. It's approximately 40 minutes north of Gainesville.
Now, I believe you said you've testified in battering
Sure, Donnie.
spouse
Ronnie.
situations in court approximately
Sorry,
5
Ronnie.
to 10 times?
Yes.
Is that correct?
Yes.
And you often refer to that as intimate violence cases?
Yes.
Now, my understanding that after you had a chance to evaluate my client, Sarah Boone, and I believe you evaluated her 2 days before the deposition, so it would have been October the 2nd of 2024.
Correct.
As to your diagnosis as it relates to her, do you believe that she suffers from a generalized anxiety disorder?
No, sir.
Now, you're aware that she was previously diagnosed prior to you evaluating her, she was previously diagnosed with a generalized anxiety disorder.
She told me that she had previously been diagnosed. I did not see any medical records with that diagnosis in it, but she told me that she had previously been diagnosed.
So,
Attempt to
hey,
secure any other records to us?
it's not her job. You need to provide them.
Did you diagnose her with an adjustment disorder?
I did diagnose her with an adjustment disorder.
Do you believe that if she was diagnosed with a generalized anxiety disorder, it's really not that, it should be an adjustment disorder?
A lot of the symptoms overlap for the two diagnoses, and we see that quite often, that the different diagnosticians or
He's blowing a lot of smoke.
physicians, come up with different diagnoses based on a conglomerate of symptoms. So it's not uncommon for the two diagnoses to overlap based on the
That's
symptoms.
true.
Do you agree back on October the 4th, 2024, when I took your deposition, that you could not make up your mind at that time whether she suffered from generalized anxiety disorder or
She had to go and
adjustment
review
disorder?
everything
I
and
had
do
not
her.
made a clinical decision at that time. I hadn't reviewed all of my documents at that time.
That's
When
right.
did you make a clinical decision that she suffered
It takes
from
time to
adjustment
get the
disorder
results. They
as
have to
opposed to
do all the
generalized anxiety
stuff.
disorder?
It was probably within the next week when I was reviewing all of the, going through all of the documents in her interview more thoroughly.
Dr. Warner, did you agree you did not notify me?
Judge, maybe approach.
Yes.
Good catch. Very good catch. Like it. Guys, Owens is doing his job. We may not like everything he's doing, but if this was you sitting in the seat next to him, would you want him to fight this hard for you? I would say yes, we would. An adjustment disorders are excessive reactions to stress that involve negative thoughts, strong emotions, and change in behavior. The reaction to stressful change or event is much more intense than would be typically expected. This can cause a lot of problems in getting along with others, ding, 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 as well as work or school. Symptoms depend on the type of adjustment disorder. Can be vary from person to person. Feeling sad, not enjoying things you used to, crying often, worrying, feeling anxious, nervous, jittery, stressed out, feeling irritable, having trouble sleeping, not eating enough, having difficulty concentrating, having difficulty with daily activities, withdrawing from family and friends and who support you socially, not doing important things as going to work and paying bills, and thinking about the ending of life or the act of those thoughts. Sounds like depression to me.
Objection is sustained.
Haha, he won.
Dr. Warner, you agree that when I took your deposition on October the 4th, you had questions, in all honesty, about whether or not you felt like Sarah Boone suffered from a generalized anxiety disorder versus an adjustment disorder.
I was leaning towards adjustment disorder secondary to her being in the correctional setting, and I think I said that in my deposition. I didn't know that I had enough information from her because I only had information from her. I didn't have anything in the medical records to support generalized anxiety disorder. So I wanted to review that.
I'm just learning it now as you testified here today.
Sustained.
Is this the first time you've let the parties know that this is your opinion?
That I believe that she has generalized anxiety disorder?
No.
Or that I believe that she has
Adjustment
adjustment disorder, yes.
Well, you haven't asked her.
Now,
we've been back
from
for a
your
while, but
evaluation,
we're just now
you
getting to
determined that she had
testimony.
a personality trait,
That's correct.
and you felt like that she had a grandiosity issue,
Yes, she has a narcissistic personality disorder trait.
a trait, one trait.
Correct.
Do you agree a lot of people have one trait?
Yes.
Okay. A lot of people have a grandiosity trait
That's correct.
that are not narcissists.
I never said that she was a narcissist.
Who do you really want to hurt me? Toxic? What? No, don't want to hurt you. We love you. This lady is like, dude, after this, I will never freaking testify again.
Is it your opinion that Sarah Boone
I
has
know.
alcohol use disorder?
Yes, that's correct.
And are you forming that opinion based on Sarah Boone's admission to you that she was an alcoholic?
I'm going to refer to my notes. She has a history of being diagnosed with that.
They can't diagnose certain things unless they have medical documentation to back it up.
So you formed the opinion that she suffered from alcohol use disorder based on the history that she presented to you at this evaluation?
It was based on the totality of the information that I was provided. So the medical records demonstrating that she had been diagnosed with it in the past. Her ex-husband
all of them.
Interview in the police report described her as an alcoholic, in her description of herself having a problem with alcohol.
Do you acquire a tolerance over time if you drink on the regular?
That's one of the criteria.
Do people also have a genetic tolerance for alcohol?
They may.
She is like so over this.
Now, as it relates to battered spouse syndrome,
The only thing that's keeping her
would
there
you
is the
agree
thousands she's
that
making.
that is a recognized syndrome in the psychiatric community?
Yes.
And you have heard no criticisms of that syndrome?
No.
And you would agree that's a subset of post-traumatic stress disorder?
Yes.
And you would agree that Lenore Walker
Doesn't mean she had it.
first developed the theory of post-traumatic stress syndrome?
Yes.
I think at the time of this deposition, you were not sure you knew Lenore Walker.
I don't recall that.
All right, look at page 54.
Approach.
Gosh almighty, dude. You wanted to end this trial by today. And only you is the reason that that ain't going to happen. At all. Jury, you can be angry. I'm trying to get, oh, there we go. Y'all, it can get uncomfortable sitting here for 10, 12 hours a day. Jury, you can blame him for this continuing. Yeah, blame him. Y'all. We will be here next week. They're not even going to get closings or anything in today. You've got a minimum of an hour for jury instructions. You've got a minimum of what, hour and a half, maybe 2 for closing arguments. And an alternate, well, by the time it goes to jury, the alternate's not a problem, but the alternate needs to leave by 5:30. They've got a hard stop. Oh, I did get.
Objection is sustained.
Dr. Warner, do you recognize Lenore E.A. Walker's book, The Battered Woman
Yeah.
Syndrome, as an authoritative treatise on battered spouse syndrome?
I do not, because I have not read everything. I haven't read it, and so I can't say that I agree with everything in it.
Yeah, I bet she thought she'd be back in her office by now.
Is it clear to you that Sarah Boone was involved in a violent relationship with George Torres?
Yes.
You agree that there was a violent cycle that occurred during that 3.5-year relationship that Sarah Boone had with
Between
George
both
Torres?
of them.
It's been described that way, yes.
Would you describe it that way?
It's been described that way to me, yes.
Do you have an opinion?
You don't want it.
Sustained.
Do you have an opinion that that was a violent cycle between Sarah Boone and George Torres?
It's been described that way, yes.
Do you agree that George Torres was the abuser and Sarah Boone was the victim in that?
It was a volatile relationship. In the police report, her ex-husband actually describes her as being the aggressor.
Boo boo. Boo. Drop.
What's been identified as Defense Exhibit I. Have you ever seen this photograph?
I have not.
You see the injuries on Sarah Boone?
I do.
All right, let's just admit it. That didn't happen.
Show you Defense Identification H. You see this photograph?
I do.
Have you ever seen it before?
Oh no.
You agree that's Sarah Boone?
I do.
Are you aware that George Torres?
Sustained.
You can't. He is so pissed off.
Let me show you Defense Identification G. Have you ever seen this photograph?
I have not.
Once again, what did he look like?
Did you ever read anything about George Torres using a curtain rod?
It was mutual.
As a weapon against Sarah Boone?
I don't recall that specifically.
Identification F. Have you ever seen this photograph?
No.
But what's the full story? You can't show a photograph and not show the flip side. Dude, he is so grasping for straws. Poor guy. I feel for him. I really do. He's trying to do the best job he can for her.
No.
He really is. He's a good lawyer. We may not like what he's doing sometime, but you know, if I ever in her shoes, I might hire him.
Have you ever seen this photograph?
No.
I think we'd all agree they were both abusive to each other. She just got the last laugh, so to speak. Toxic? I agree. I agree. And it wasn't, well, she did laugh. She literally did laugh.
Now, I believe at the time of the deposition,
Oh, God.
you had spent I think on October the 2nd of 2024, you had spent 2.5 hours evaluating Sarah Boone, and about half of that time was giving her a test.
The mental status examination takes approximately 5 minutes.
Okay. Did you go through her entire history of abuse over the 3.5-year period within the 2 hours and 20 minutes that you had?
No.
Now, I understand that you indicated you may take a couple more hours to go through your file and your notes and to come up with your conclusions. Did you do that?
Yes.
Have you spent any more time on the case other than that 2 hours?
No.
I re-reviewed the documents.
Have you made any other attempts to go see Sarah Boone anymore?
Proper. Sustained.
She's not required to. And you probably would not have allowed it. Let's be honest.
You agree that
Oh
your
my
opinions are
God.
subjective, not based on
Is he
authority?
tiny? Hispanic?
They're based on my
What does he look like?
education, training, and years of experience.
And you would agree they're your subjective opinion?
Correct.
Would you agree that Sarah Boone suffers from battered spouse syndrome?
I do.
Would you agree
What'd
that
you
battered
say?
women's experiences affect their perception of imminent danger?
Wait, what did you say?
Would you agree that victims of repeat violence may fear death in a situation others would not?
I gotta.
Training and years of experience.
And you would agree they're your subjective opinion?
Correct.
Would you agree that Sarah Boone suffers from battered spouse syndrome?
I do.
Okay.
Would you agree that battered women's experiences affect their perception of imminent danger?
They can.
Would you agree that victims of repeat violence may fear death in a situation others would not?
They may.
Because someone suffers from battered spouse syndrome, they have a heightened sensitivity to danger.
They may.
He did not like the answer to the question about George. And she said in the police report, she was the batterer. And she went,
You agree that people suffering from depression and anxiety are predisposed to getting into a relationship with a partner who may be violent.
They may. Each individual is different.
Are they more susceptible to getting in a relationship if they suffer from depression and anxiety with a violent, intimate partner?
They may be.
she's not giving him anything at all.
Do you agree that the DSM, I think you have it there with you,
Yes, sir.
directs that the clinician should consider post-traumatic stress disorder if there was exposure to extreme stress? Do you agree with that?
Yeah.
Did you do any testing to measure whether or not Sarah Boone had post-traumatic stress disorder?
No.
Is it your opinion that Sarah Boone suffers from post-traumatic stress disorder?
Again, she did not give me enough information to formulate an opinion with regards to that.
That's fair enough. It really is.
You agree that an intimate partner who commits acts of violence, physical violence against the victim that could cause extreme stress in that individual?
It may.
You agree if that is the cause, the violence is the cause of extreme stress, that a diagnosis of post-traumatic stress disorder should be considered?
If they meet the criteria. They have to meet the diagnostic criteria.
You agree that there is a sense of learned helplessness when someone suffers from battered spouse syndrome?
Yes.
Oh, she would not helpless.
Do you agree that these women, these battered women, have learned the probability of receiving a beating, and they recognize specific predictive cues emitting from the batterers?
Yes, but it's not just women.
I understand, but you would agree the vast majority of intimate partner violence, battered spouse syndrome victims are women?
Yes. Intimate partner violence, yes.
Excuse me?
Intimate partner violence, yes.
The vast majority, the lion's share, are women.
Yes.
And these battered women have learned the probability of receiving a beating by recognizing specific predictive cues emitted by the batterers.
Correct.
And many times, these predictive cues result in a high level of anxiety.
Yes.
And in that situation, the battered women may attempt to reduce through several different means, one of which is to avoid delaying the beating.
Yes, we talked about that with the cycle.
What is a basal instinct?
A basal instinct? I have no idea.
Primal fear?
Will you get on the mic, ma'am?
It's just being afraid.
Is that a natural instinct that animals have?
Yes.
Fight or flight instinct?
Yes.
You don't even think about it.
Correct.
But she didn't flee. Ever. She never fled.
Do you agree that victims of battered spouse or battered woman syndrome suffer from self-isolation, suicidal thoughts, and oftentimes substance abuse?
Each individual is different, so they may.
And they may show signs of physical injury and illness such as bruising and chronic fatigue.
Yes, those can be signs.
The syndrome, battered woman syndrome, is the psychological effects of living with an intimate partner violence. They may have intrusive memories, or they re-experience past traumatic events in their mind.
Post-traumatic stress.
They have high levels of anxiety, hypervigilant when something doesn't seem right. It leads to this fight or flight response that we spoke about. They have problems with sleep. They often go into denial.
They can.
Minimizing what is happening to them. Numbing their emotions.
Possible.
Disassociation. A battered woman may often develop a defense mechanism of being able to psychologically detach from their body during the traumatic experience.
Sustained.
Panic attacks, severe depression, very low self-esteem, poor body image, disassociation, learned helplessness. All these are symptoms of a battered woman syndrome.
Sustained.
You agree
Ask and
panic
answer.
attacks is one of the symptoms of battered woman syndrome.
Ask and answer.
What are the symptoms of a battered spouse syndrome?
They can be numerous symptoms, from anxiety symptoms, mood symptoms. They can have psychotic symptoms. It can be any vast majority of symptoms. Substance abuse symptoms, any vast majority.
Do you agree fear is a symptom?
Yes.
Somebody in a constant state of fear.
Maybe, yes.
In terms of the abusive partner, do you agree that they would hit the victim?
Some of them, yes.
Kick the victim?
They may.
Punch the victim?
They may.
Choke?
Abuse takes all different forms.
Choke?
They may.
Burn?
They may.
Destroy their belongings?
They may.
Use weapons to hurt them?
They may.
Threaten to hurt them, their children, or their pets?
They may.
Take their car keys?
They may.
Take their debit card?
Really?
Take their vehicle? Control where they go and who they see? Force them to have sex when they don't want to?
Yes, they may.
I just cleaned all my keyboards. What is that noise?
Dr. Warner.
Warner, not Warner.
I know you spent a short amount of time with her and you're saying you didn't get
He
some
said
of the
that.
answers as to whether or not.
Objection sustained.
If you'd have spent more time with Sarah Boone, could you have uncovered as to whether or not she suffered from battered spouse syndrome?
I agree that she met the criteria, or that she had battered spouse.
How about post-traumatic stress disorder?
It's possible.
Thank you.
Any
He had
redirect
no
examination?
medical.
You may proceed.
He had no medical basis for some of these diagnoses because they weren't in her medical
In
record.
your decades of experience, have you ever treated patients that suffer from trauma disorders?
Yes.
How frequently would you say you do that?
I have patients on my unit right now that I'm treating on a regular daily basis who have suffered from trauma.
How about patients that meet the criteria for battered spouse syndrome? How many would you say over the course of your career?
Probably 5 to 6 a month on my inpatient unit.
And that's a lot of months.
Yes.
How long have you been doing this?
Since 1998, when I began began my career at the University of Florida on faculty.
Now, on cross-examination, you were asked about some diagnoses, correct?
Yes.
Any of these things that you talked about, narcissistic personality disorder, adjustment disorder, anxiety, battered spouse syndrome, any stress or trauma-related disorder. If the state wanted to ask you those opinions, would you have been receptive to more materials before making any opinions about those topics?
Yes.
And is it your testimony today that you don't have enough information to necessarily make a complete and proper diagnosis on any of those things since you have not been provided those materials?
Correct.
Now, you've testified that she does meet the criteria for battered spouse syndrome.
Yes.
We don't disagree that.
But you would be receptive to any evidence that you were provided, right?
Correct.
Put the blame
Going
on
back
them.
to what you testified to on direct when the state asked you your opinion about this case. Everything that you just talked about with Mr. Owens, does that change your opinion about whether or not battered spouse syndrome is applicable to the facts as Ms. Boone relayed them to you about this incident?
No,
And why is that?
because again, she just.
Objection, Judge.
So he does not want the jury to hear that in the moment that she committed this crime, that she was not in fear or flight of her life, which is the baseline. Was she in fear or flight for her life? No. She was angry, but she was not afraid. Had she suffered abuse that day?
Objections overruled.
Absolutely not. Yes.
Based
Sorry.
on your conversation with Mr. Owens, you've indicated that your opinion did not change, and now would you answer why?
Yes. So
She's not happy.
My interview with her, the way that she described the incident to me, and that they were laughing and having a good time, it didn't play into relaying any kind of triggers or any kind of trauma.
And I'm showing
Had a
you
good day.
identification
It was a good day.
eye. Does this photograph inform you as to what happened?
No.
Does it inform you as to who was the aggressor?
No.
H for identification, same questions. Does it inform you as to what happened?
No.
Does it inform you as to who the aggressor was?
No.
Same questions for G.
No.
F,
What did he look like?
E,
No.
D,
No.
and A.
No.
If those specifics as to what happened and who was the aggressor is dependent upon the credibility of somebody, would you want to take into account all the things that can make a person credible or less than credible?
Yes, you would want to take that into account.
And you talked about alcohol use disorder. Would you take that into account if somebody is under the influence of alcohol or had been consuming alcohol when they relay a history as to things that happened?
Wow. You know, we really need to give kudos to this judge. He has run a phenomenal court considering everything this poor man's gone through. And like I heard last night on shooting the shite with Squeezy, the images of George or Jorge were brutal. We didn't see the worst of them. Looked like he'd been through a bar brawl and everybody had had their shot. He was black and blue from head to toe. So we didn't get to see his face and head, and we
Objections
wouldn't.
overruled.
Oh,
Would
they
you
lost that one.
consider somebody's alcohol use and level of intoxication in evaluating the credibility of them as a historian?
Yep.
And you were asked about whether or not you did any testing for post-traumatic stress disorder.
Correct.
And you didn't.
Correct.
You already indicated, however, you believe that Ms. Boone meets the criteria for battered spouse syndrome.
That's correct.
Again,
That may have been what she was
that
asked
doesn't
to
change
do.
your opinion that you gave when talking with me on direct examination.
Object, asked and answered.
Overruled.
Specifically about this question about the testing that you did not perform. Did this lack of testing have any change or effect on your opinion as to whether or not battered spouse syndrome applied to the facts of this case?
No.
You were questioned about insanity on cross-examination. You recall that?
Yes.
Would you agree that simply because somebody is mentally ill and meets the criteria for diagnosis such as schizophrenia, bipolar, any of those psychotic or mood disorders, that doesn't necessarily make a person legally insane?
Correct. The two are equal.
Likewise, even if somebody meets the criteria for battered spouse syndrome, does that mean every action they take against their intimate partner is justified?
Correct.
So even if you do have battered spouse syndrome, even if you are in an intimately violent relationship, that doesn't necessarily mean any action you take against your partner is justified.
That's correct.
No other questions?
Statements that will be released. Defense.
If we got a phone number, we can reach out to.
All right, ma'am, you're released, potentially subject to recall. Thank you.
How are you subject to recall when we're not supposed to be recalling anybody? We're already supposed to be in jury deliberation.
State, you can call your next witness.
Judge, at this time, the state would move D for identification and evidence.
Is this a video tape or audio?
Y'all. I forgot to put that back up.
Commissioner Butler?
No, he's offering it in evidence. Any objection?
No objection.
All right, what was pre-marked as P will be received into evidence without objection. It states 21.
Who you bringing up? I think we need a energy cleanse. What do you guys think? did an energy cleanse.
Any objections?
No objection.
What was pre-marked as V will be received into evidence without objection as states 22. Yes.
Oh, look at the smile on that judge. That was funny. It's like anything. Let's glad we're off of that subject. Her attorney is going to be hell on wheels if he loses this case. If he wins or gets a hung jury, that's going to boost his career something fierce. He's not a bad attorney. I'm not disagreeing with his vigorous representation. I'm not.
Members of the jury, it is 2:52 in the afternoon. The next part of the state's presentation are going to be some videos and other things that we read to you that may take a little bit of time based on the length of them. So we're going to go ahead and take our afternoon break at this point in time. Similar instruction I've given to you over the last couple of days. Please do not conduct any independent investigation or research if the person, places, things, or charge involved, and do not have any discussions with anyone or amongst yourselves about those things. And we'll bring in 5 after. Thank you.
Yeah. Reminds me of the drum line.
Y'all may be seated. Thank you. State, anything we need to talk about? Defense? All right, we'll be in recess till 5 after. Thank you.
He's like, get me out of here. He's going to go back there and go, no, I'm kidding. Okay, guys, I'm going to take a comfort break. Sorry. Okay, me back whether you like it or not. Sensei, lay down. Good job. Oh my gosh. What a day, y'all. What a day this has been. What a rare mood I'm in. Why, it's almost like being in love. Not like being in love. Some of this is really irritating me with her. I can't say Sarah Boone. She's just sitting there being all pretty and quiet. It's just the way this whole day has gone. Well, I would love for him to redirect. I know, right? Mine is too. I got it over there ready to rock and roll. I know, right, Gabby? Hi, Gabby. Hi, everybody. Boy, has it been a day. Oh my gosh, that was insane. Absolutely freaking insane. Status of your outfit? Toy. Yes, y'all, please leave your DNA. Subscribe. Let's see if we finally hit 2,300. I hit 2,300 and then it fell back down. I was one person shy of hitting 2,300 subscribers. If you've not subscribed, please subscribe. Doesn't cost you anything. And those who have, please like. It doesn't cost you anything. It really doesn't. I've gotten to where every time I watch a video, I like it. It's vitally important to us. Believe it or not, it affects us. Oh, and share to your friends and other people. If you know people who might like to see this, share it. We have a new sound button. I'll play it in a little bit. Okay, we're back already. Man, that was quick. I'm watching her intently. I want to see her reactions. Oh, cool, Gabby. Question to you guys. Yes, no answer. Did this spat that we experienced all day long with her attorney, if you were on the jury, would it affect you? Let me rephrase it. If you were on the jury and you were on her side, right now you're on the fence of not guilty. After hearing what you've heard today and saw what you saw today, would it change your verdict? Yes or no? Would it change your verdict? Good afternoon. You came in from some Zach shenanigans. That would have been nice, but he hadn't been doing any today. Maybe he will. Maybe he will. Welcome, welcome. If you've never been here, please hit subscribe. We are on a mission to get 3,100 by Halloween. It doesn't look like we're going to make it, but we would like to get over 2,300. He would have peed me off. I would think he was desperately trying to stop me from hearing something about her that I could not put her. Yep. Yep. Well, I'm just trying to see how would it sway you? Would it sway you more towards guilty? Seeing how the way her attorney was handling everything today? that expert didn't need to see all the videos. Her job is to look at Sarah herself. Videos are not always a good representation. Just like you said at the end with the photos, I thought that was brilliant, Jay, Mr. J, and I applaud you. That was brilliant. He held up the photos because on the cross, Owens held up the photos and got shot down. So on redirect, Mr. J held up the photos and said, "Can you tell who was the instigator?" Nope. Who was the aggressor? Excuse me. Who was the aggressor? Doesn't mean the aggressor gets the worst of the damage. And sometimes the aggressor does get the worst of the damage because you aggress the wrong person, you're going to get your butt stomped. And you may come out looking worse than the victim. How many bar fights does that happen in? You know? I think that was brilliant off the cuff thinking for him. Mr. J, you did good there, babe. I would start doubting the validity of the defense and the fact that she kept saying this battered spouse does not, even though she had it, was not applicable here because it was a good day. They were putting puzzles together. She got angry. She said she got angry. Nowhere has she said, I feared for my life before he got in that suitcase. And even this woman stated that it was 2 fingers in the suitcase was zipped up and it was 2 fingers. Or was it the one before this? The one before this. Someone said 2 fingers today. And I'm like, oh my gosh, hit the nail on the head. Because she is the only one now saying an entire hand was getting out. If his whole hand could get out, he could have probably ripped himself out of there. Because those zippers, but it's hard to be on the inside. If I was skinny and 20 again when I was a contortionist, and I literally was, I won't even begin to tell you all the places I got myself into. But I would attempt it. It was a state's witness, that's right, that said 2 fingers. But it was reiterated, 2 fingers was said today. And you're going to hear it on the videos, 2 fingers. You're going to see this. And I think there's going to be body cam that we've not seen yet. That's right. She told the state psych 2 fingers, not the whole hand. So I think once you start seeing all of these, but once again, the bottom line, was she in a position of defending herself in the way that it required her to end the life of somebody to save her own? Nope. It's the same thing. If I'm carrying my lead shooter and I have a license to do so, that does not give me the right to just go out and discharge it whenever, wherever I want, and then claim self-defense. It doesn't work that way at all. Yeah. Yeah. Sometimes you're stopping yourself from getting hurt. You can harm yourself.
CF 2603, State of Florida versus Sarah Boone. State.
William J. for the state. Dave Cashtory for the state.
Defense.
Jay Owens for Ms. Boone.
Kevin back.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. It's 3:05. We're ready to bring back in our jury, Mr. J.
Yes, Your Honor.
Defense. All right, let's go ahead and stand and bring back in our panel.
They bring the jury.
Oh, Sarah has a standard pin today. That's a first. I think hers ran out of ink. I saw them messing with it. Did Sarah attack another attorney? Did something physical happen between Sarah and another attorney? Somebody asked me that question and I forgot to ask y'all.
The jury is present.
All right, thank you. You may proceed.
I need to get that louder somehow.
You may bring.
I need to get that louder somehow. So, if, like I said,
Yes, Your Honor.
Defense, you recognize our jury? Yes, thank you. You all can be seated. Members of the jury, again, do you comply with the court's instructions during our break? Record reflect all hands have been raised. Thank you very much. State, you may proceed with the balance of your evidence presentation.
Permission to publish what has been entered into evidence as 22, previously V as in Victor for identification.
You may proceed.
who's on the stand? Is he just going to play the video and let them speak for themselves? If I was that judge during break, I would have had both of their butts back in my
22 has 5
office.
folders on it. It is a DVD. Going into the first folder, OCSO 18-067501.
Counselor, are these audio or video files?
This first one, Your Honor, is going to be a video file.
Okay, let's go dim the lights, please. Thank you.
And for record purposes, its file name ends with 0154-2.
You may proceed, sir.
Zach, thanks for trying to get a raid. I appreciate you. Okay, where's the sound? We're full of sound. Oh, let me do something else. Let me do this. I need to fix this.
And he's going through a whole bunch of shit. Pardon me for saying that.
No.
Pardon me for saying that, but like, oh man, he let loose on my ass tonight, and I'm not having it.
Okay.
Right. I got kicked in the face.
Okay.
Kicked in the face.
That you know if there's no guns,
No,
anything.
no. I know, baby. You guys are doing your job.
All right,
No.
stay right here.
Yeah, right here. Go get him. I swear to God, there's nothing you guys can be afraid of.
What's his name?
George.
George, all right.
There's nothing you guys can be afraid of. I swear to God, I'm done with that too. You beat the fuck out of me tonight. And I'm done with it. I have to go to work tomorrow.
What's up, George? You want to talk to us? What's up? Talk to you inside.
For the record, this is.
I want to see the entire interview with him. Body cam.
Are the videos in States 22 redacted videos?
You see my eyes?
I do see your eye. Okay, tell me
how it all went down from beginning to.
Yes, my love.
Okay.
Okay, so we were having a really good day, and we went across the street from Boone, and everything was feeling fine and dandy, and because I talked to another guy because he left, came in there, and I got so mad, because I asked for a cigarette from another guy because he took my license, my debit card, and everything, cigarettes, everything, took everything.
Okay.
So I asked someone for a cigarette, and it happened to be a guy. So he walked in and got super pissed because I asked for a cigarette from another guy. I came home. Mind you, my car is across the street still. Okay.
So you get home, you go inside.
And let loose.
Okay, elaborate. So you open the door. What happens from there?
I'm a whore.
He starts calling your name? Okay.
When I say ragdoll, you know what that is?
I know what a ragdoll is.
Oh man, I was ragdolled.
Okay, but I need you. Okay, I need you to elaborate. Like, you walk into the house. Did you start arguing? He started calling you names. He said he was.
No, I walked out. I walked in and I walked to the back. I just wanted to smoke a cigarette and just go to sleep. I just literally wanted to smoke a cigarette. I'm gonna go to sleep.
And then as you're making your way to the back, what happened?
I got caught on the stairwell.
You got caught on the stairwell. So he caught you on the stairwell. And what did he get in front of you? Started confronting you, telling you anything? What happened?
I don't think we've seen this one.
It was bad.
Okay. Elaborate, Miss Sarah. I need you to tell me exactly what happened so I can help you.
My heart is like, I don't want him to get in trouble, but fuck, I'm tired of being beaten up.
Okay. I understand. I'm trying to help you out, but
I know you are.
I need you to elaborate a little bit. So, in the stairwell,
dragged me down the stairs. I went upstairs, tried to get in the bed. I just want to go to sleep. I just want to go to sleep. I didn't make it to the bed. He caught me in the upstairs.
Like in the hallway?
Beating the fuck up. That's all I can say.
Okay, what do you mean? Like, I see your eye. What you said? He kicked you in the eye.
That's what I see it. That's what it is.
Were you on the floor when he kicked you?
Yes, ma'am.
Okay, how did you get to the floor? Did he push you? Did he pull you? How?
Normally what I do
I don't like this questioning because she's giving her thoughts to come up with answers that she doesn't have.
I went to the ground.
Okay. And then that's
I'm
when
so sorry.
No, that's fine. I don't mind. So you went down to the ground.
Yes, that's what I do.
Did he kick you with what? Do you recall which foot?
Right.
Right foot. Okay.
Heel.
His heel. Okay. And you say you've been together for.
Because I asked for a cigarette. Because he left my ass in my car across the street.
Okay. You say
Y'all
you've
look.
been together for about a year?
This is from Court
A year and a
TV.
half. Okay. Live together, obviously. Okay.
They made their trial.
I just recently went for a divorce. He's been there with me. He knows all those stories, blah, blah, blah. But
I know. I'm just trying to.
this sucks. And I could have worked tomorrow.
Do you want the fire department to come out and check your eye? No? Okay. Do you want to press charges? You can smoke your cigarette if you want.
Can I talk to you though?
You're talking to me by myself.
I don't want to be taken. Please put the finger up the police.
So you don't want to press charges? Okay. Do you want to fill out any paperwork? Do a statement? No? Okay. Smoke your cigarette, sit down, smoke your cigarette.
I don't want to be in trouble.
I know.
You guys have sleeping out your place now. Look at this shit. Looking for my shit all the time.
Did this happen today?
Yes.
Okay. All right. Yeah, I see it. It's ripped and I'm down there a little bit.
I'm sorry, hello, Britt.
Yesterday.
I'm sorry, y'all.
Smoke a cigarette? Do you think? No, it's fine. Do you have an ID with you? Is it in the house? Okay, we'll go find out.
I know my number if you want it.
Oh, that's perfect. Go for it.
C 500-791-77870-0.
870-0. Okay. First name is spelled S-A-R-A-H. Do you have a middle name?
Catherine. K-A-T-H-R-Y-N.
K-A-T-H-R-Y-N. R-Y-N. What's your last name?
C-O-O-N-E.
Date of birth?
10-10-7-7.
I get it. Make sure not to stay behind anymore. Do you have a telephone number?
407.
407?
716.
716?
8684.
8684? Email address?
SKP.
SKP underscore
1-800.
1-800
@yahoo.com.
@yahoo.com.
Sorry.
No, it's cool. I get it. I get it. Sit down, smoke your cigarette, try to relax a little bit. I'm gonna take pictures of you in a little bit. All right.
I want to see the body worn camera when they do with
No
him
problem.
and see what his side of the story is. I want that body worn camera.
Turning now to folder OCSO 19-054.
Can the parties approach just for a moment?
I want to see the camera when dealing with George. There is a video, and I love how they got court TV up on their screen. But there is a video out there where a police officer said,
All right, sir, you may continue.
I'm separating the two of you because one of you is going to end up dead.
The thing that will be published is a file that's an audio file, 911 call _R1.
911, what is the location of your emergency? 4748 France Court, apartment 3. 4748, what was the street name? I didn't hear you. 4748 France Court, apartment 3. Okay.
You can hear
Nothing
she's
that I
drunk.
recall, but I did. You can beat the fuck out of me. You said Frank Lane? That's what it comes up as always. Okay, and then what was the apartment? 3. Okay, and what happened then? He just beat the fuck out of me. Who is he? Jorge Torres. Is he still there? Yes. Okay, where's he at? Up in the bed. I'm outside. Okay. I did not like that. Okay. Do you need any medical attention? No. I just have a lump on my head and I just got to look up. That's all. Okay. What's your name? Sarah. With an H. Okay. And George, you black understand? He's Hispanic. What are you wearing today? Oh gosh. Just color shirt today, that's all I need. I don't even recognize because he just showed up. Okay. Do you have his date of birth? February 13th, 78 to 1378. And I swear,
I'm just calling you guys because he's not on the lead and he's not supposed to be here. But he's here.
But he lived there with you. You let him live there with you.
12 minutes ago.
Okay.
I'm done.
Yes, sir.
I can't do this anymore.
Okay. I just need a description of you so that I can identify you when they get there.
I'm white. I have 30 blonde hair and blue eyes.
What color is your pants you wearing?
Am I?
Yes.
Black.
Black shirt, black pants?
Pink shorts.
Pink shorts? And you're outside?
Please don't get me in trouble. There's no way that I can get in trouble for this.
No, just stay where you're safe. You said you're outside, right?
Yes.
Okay, does he have any weapons that you know of?
No.
Okay. And did he hurt you with anything, or was it only his hand?
Fist.
Just his fist? Okay. And you don't need any medical attention?
No, I always get over it, but this time I'm not getting over it.
Understood. Okay. Okay, we're gonna go ahead and send some help to you, okay? Anything you can, just give us a call back, okay?
Wait, can I sit out front though?
Yes, definitely sit out front, stay out front. That's right, that's good.
I'm gonna walk around the house.
Okay.
Okay, thank you.
Yes, bye-bye.
Goodbye.
Now publishing a video labeled 19-054917_BAT_DV.
Call? What's going on?
Then hello at Brit. Zach may like your legs. He has a thing for legs. I shouldn't have said that. I'm sorry. My bad.
What's going on? You call? Okay. Do you want to tell me what's going on? Oh. We'll be shut. Is she still in there?
I'm very pale for Cherokee Cree Indian. The Irish took over.
I don't want him here.
Me too, K-Swan.
Comes over and looks for me.
Do you want to press charges?
What charges do I press?
Well, what's your relationship now?
I guess boyfriend and girlfriend.
Okay, how long have you guys been dating for?
2.5 years.
And that's a current relationship?
Yeah.
No.
So this is an early one.
I can't deal with this shit.
Okay.
I'm sorry.
When's the last time he stayed the night at your house?
2 weeks ago.
2 weeks ago?
And he printed it out.
Okay, so why is he over here today?
Can't go with two and the other, is what he told me.
What's the other three?
I'm not allowed to leave it.
You're not.
13.
Tell me, well, look now.
Okay.
He's mad because I went out with my girlfriend.
Okay.
And she introduced me to another gentleman.
Mm-hmm.
He's not a gentleman. He's not a gentleman. And he got his.
Okay. So you came over today, you let him in because you're gonna talk, right?
Yes.
Okay, then what happened?
I'm really pissed. Really pissed.
Okay, so you guys start arguing and then
No,
what?
I didn't argue. I can't argue. I was just taking down his speaker.
Okay. So when you say taking down the meeting, like describe it for me, so I know. What did he do to you? Did he push you? Was he slapping you? Was he punching you?
All of the above.
Okay, you have to kind of explain to me what happened. Like, tell me like
Into
step
the
by
closet
step.
doors.
Okay, so he threw you into the closet doors? Okay, you're upstairs, he threw you into the closet doors. Did anything break when he threw you in there?
My head? No.
Okay, but you said you don't need the fire department?
No. I just have really bad luck. It'll go away because I'm used to it. It'll go away.
Okay, let me see. Where is it?
Right here.
You just put your hair back a little bit.
There's a lump right here. Like you can feel it.
Yep, I see it. Do you have any other injuries?
No. I just, because he's not on the lease anymore, I know that he can't, I got him off the lease to not come over here anymore. And I'm trying to get him out of here. And he's over here every day. And I have guys
Okay, so there's another exit to this apartment, so he could be gone.
There's the spot in my store, and the doing that. He's been a fire police, which I have done 4 times. You're the 4th one.
Okay.
He's gonna have to walk, but I have to go and he's upstairs now. Go get him.
Well, I'm going to, but I'm gonna have to try to get somebody else here. What's his name?
George.
George?
I'm sitting here.
Okay. And I have to ask this too, when's the last time you guys slept together?
Had sex
Mm-hmm.
3 weeks ago.
Okay. So, but you guys are kind of on again, off again, and you're saying as of right now you're off, but
I'm off.
okay, but within like the last 2 or 3 weeks you guys were dating.
I say no.
Okay. But at least there was some
I knew who he
expectation.
was.
There's an expectation and intimacy when he came over.
No.
But you said you
No. We were gonna try and figure it out.
Okay.
Oh.
But you want to press charges on us
What charges can I press?
right now? What he said he just hit you with hands and feet, pushed you.
I got a heel on my face.
Okay. You keep being upset with me, but you're not really giving me the information I need. I'm asking you to kind of walk me through what happened, okay? Because I don't know, I wasn't there.
I know.
Okay? Okay, so all you said, you guys were upstairs. Right. But that means lots of different things. So that's why I need to know what
This
you
is
did.
why I have all of this over here, is because he continuously talked to me, and he strangled me multiple times.
Today?
Yes.
Okay. Did you start to lose consciousness or anything while you were strangling you?
I couldn't breathe.
Did you feel yourself losing consciousness?
No, I didn't lose consciousness. I just couldn't breathe.
Okay. Well, for how long was he strangling you for?
Till I got him off of me.
Okay.
Look, can I tell you something before you call and whatever?
Mm-hmm.
I've been arrested before because I fought back. Look, I did fight back. I did fight back. So whatever he has or whatever it is, it's not me.
Did he hit you with any, like an object or anything?
No.
Okay. talking about today. Did you pick up a baseball bat and track? Okay. Tell me about that. How far away were you when he had the bat?
I was in the bedroom.
And where was he?
In the bedroom.
Okay. Was there anything in between you guys at the time?
My dog.
Just a dog, and how close was it to you? Couple feet, 3 feet?
3 feet.
Okay. And how was he holding the bat?
Threatening.
If you had my hearing aid, you could talk and text and dictate and drive at the same time.
So he had Yes. Yes. Okay. Did he say anything to you while you were holding the bat?
I dare you.
And what do you mean by that?
Because I technically left him 2 weeks ago, which is why he's not here now. And it's not because I have friends. I have friends. And my friends want me to get out of my gloomy, doomy bullshit. So they try to introduce me to nice.
My bingo card is full.
He is not.
Okay. So he's holding the baseball bat, he's in 3 feet, you guys are up in the bedroom, and he says, I dare you. Okay. And you were scared.
My bingo card's full. Look, here's why.
Okay. I'm gonna go.
Y'all, here's why. Looney Tunes! My bingo card's full.
Alright, if not, this is your place, right?
I have Looney Tune on it.
And we have.
I had taken off the lead.
Okay. Alright, hold on.
Sir, what is your name now?
O'Neal.
Bingo! I win. Nobody but me had that on there. Sorry. Nobody but me had that on there. You know those cops are tired of dealing with this, right?
Hey, George.
Is this where he's hiding in the bathroom? Because I haven't seen
Hey,
this.
George. Sheriff's Department, can you come on out? Hold on. Hey, George, I can hear you. Come on out. George, Sheriff's Office, come on out. What's going on, man? Come on here, talk. What's going on? Talk to me. What's going on today? Do you speak English? Yes. Okay, tell me what's going on. Why are you here right now? Because she called me. So tell me, you want to tell me what's going on? What? Did she really come? Where are these cuts on your neck?
I don't see it, toxic. Oh, in mine. I'm looking in the wrong place. My bad.
Did you want to talk to me about the cuts on your neck? Yeah, no, really. Okay, do me a favor, turn around. Put your hands down.
It's not happening for another hour. But yeah, we'll watch it.
What? Why am I getting cuffed up? Why am I getting cuffed up, sir?
Remind me of the time when we get close.
Current 424, one is diagnosed here.
I got it. I got it. I got it. Thank you, officer.
We'll talk about it in a sec, okay?
You're amazing.
Any weapons on you? No, not at all.
Is his neck red? His neck is, well, you can't tell that's tan line.
You been drinking today? Yeah. Okay. A lot or a little bit? Like, do you understand what's going on right now? Yeah. Okay. So I'm gonna go ahead and I'm gonna read these, okay? I'm just gonna need you to answer yes or no after each time I ask you a question, okay? You have the right to remain silent, do you understand that? Anything you say will be used in court as evidence against you, do you understand that? You are entitled to talk to an attorney now and have him present now and at any time during the questioning, do you understand that? Yeah. If you cannot afford an attorney, one will be appointed to you without cost, do you understand that? Yeah. Okay. Do you desire to consult with an attorney first or have one during this interview? Yes or no? Okay. If at any time hereafter you wish to remain silent and have an attorney present, all questioning will be stopped. You understand? Yeah. Okay. Has anyone at any time threatened, coerced, promised you anything in order to induce you to make a statement? Okay. Do you understand these rights as I read them to you? Yeah. Okay. Do you wish to talk to me at this time? Yes. Okay. So, tell me what happened today. What is going on? She said that you hit her and you choked her. What? No, sir. No, sir. Okay, she's got a lump on her head. How did she get the lump on her head? I don't know. She just take me in. I don't know. Officer, I don't know. Did you push her, hit her, anything like that? No, not at all. Okay, how did she get the lump on her head? I don't know. Okay, what brought you over here today? I was trying to get my ID and my social and my birth certificate. And she's not trying to give me that. Okay, but obviously you've been here for a little bit. I mean, your shirt's off, you've been drinking, so you didn't want to just come over here to get something. So, like, how long have you been here?
He's living there.
Okay. So, so a while, like an hour or 2 hours? Okay. How long have you guys been dating for? We've been together for 2 years. For 2 years? Okay. Are you guys still dating right now, or are you broken up? Okay. And I work right there at ASL. Okay, so you came over here today, so for a while ago, an hour or 2. What have you been doing since you've been here? Okay, so just spending time with her, and then all of a sudden she decided to come around and sign calling out. Why would she do that? You don't know? She's nice, dude. She's nice. Okay, that's fine. But I can hear her. But what you gotta understand, what you're telling me isn't really adding up. Because she gave me her side of the story. What she said? Okay, she's saying that you had it. That's all I need. Ma'am, I'm doing my job, okay? You just sit there and be quiet. I'll be over to talk to you when I can. Every time you start yelling, you're interfering. She's the one that she just snapped out of nowhere. She's mad because she took me out of the meeting of the lease. She took me out of the lease. And I told these guys of the lease. I can't cash my check. I can't cash my check. It's not burning. So please talk to her. Okay, so you came over and talked to her about cashing your check? Yes. Okay, yeah, you've been here for a couple hours. Okay, so what happened to make her run outside and call the police? Because I'm seeing cuts on you and I'm seeing bruises at her. But you're not telling me what happened. And you're the one sitting in the back of a cop car right now. I don't even know what happened. Did she hit you? All the time. Who hit who first? She does all the time. So she hit you first? All the time. But today. I'm talking about today. You don't know if she hit you today? Huh? Do you have an ID on you? She has it. She has it? Yeah. Okay.
I think this is the video where he'll
Can
come
you
back.
grab his ID for me?
I don't have it.
You said it's in the house.
No, I threw it in the bushes.
Where in the bushes? Because I need it.
Front, left, whatever, however. Oh my gosh, the front door is open.
Oh my gosh, all the youngins trying to support her.
Here, find a desk. I don't have his ID.
You said you threw it in the bushes. Where in the bushes did you throw it? Could you please go back over there?
So what's happening?
It's in the back of the cop car. You said he hit you, he beat you, you have a bump. Okay?
I don't have it. You can look up here.
Oh, I want them to play the part where he says, if I don't separate the two of you, somebody's going to end up dead. We watched it the other day.
Pardon, 054917
Bruh.
BAT_DV-2. For the record, it is about 47 minutes, 20 seconds long. State will publish 000 to 2 minutes and 19 minutes to 22 minutes. And all evidence will go back to the jury with a scrub computer.
Oh, this is the day of the incident, I think. Oh, yeah.
Where were you?
His brother and his ranting mother came over here, so it should be somewhere in here if they didn't find it. I don't have it.
From the same day
There's
it's
an
in
item it makes getting his information a lot easier if I don't have to keep asking him questions and I can just get it out there.
I'm not making any more go than I could, friends. I'm not. I've already looked through here.
Okay.
Jordy, get your stuff done over there. I'll get her started on the list. You want to sit down?
She also has my birth certificate.
Listen, she said that she threw in the bushes. I'm trying to find it.
It was in this call that was done, but I don't know if they'll show
You're
it.
getting you want to be meeting right now.
You told me I'm not going to get one. I love you. I don't know what it is that you're asking me for.
Okay, maybe he didn't get to it yet. That's why I'm looking to see it. Oh, yeah. It was the backside of this. If you get any more bruises that show up that you didn't see while we were here.
Can I show you all the other pictures that I have and I've documented?
He's going to jail for this, so the rest of that can't leave anything up. But if anything else shows up, you can go take that paper down to headquarters.
It's not going to do anything else because you're taking him down. Put him under the jail.
He's going.
Under the jail.
Okay. We're all set then.
What else do you, I could show you bloody fingers and bloody faces and black eyes and.
I know, it sounds like you guys need to probably not hang out with each other anymore.
Hello.
I know.
That's why I left him 3 weeks ago.
But this also isn't the first time, so, with both you guys, with the cops out here.
No.
Okay?
I've had to lie to you guys 3 times.
And you shouldn't have to do that, so let's make this maybe the last time.
Now I'm not lying.
And I appreciate that, okay? And keep going, okay?
They're gonna come and tell me.
Who's that?
Just like I told the other sheriff, they're gonna come and tell me.
Okay. If you.
I want you to know that. Look.
If you're in fear, are you talking about
Yes.
family?
Yes.
Okay. So
I want you to know, I am full blown. They're gonna come and tell me.
go down to the courthouse, okay, and get an injunction against them. Did you get the pamphlet for the victim's rights pamphlet? Okay, so you know that there's a place where you can
They're
go tonight?
going to come and tell me.
Okay, so you got the victim's rights pamphlet, you know there's a place you can go tonight then? It's in the
I
bed?
need him by tomorrow
I'm gonna
morning,
go
babe.
sleep over her house.
Perfect,
Neighbors.
okay. You have any more questions?
Can I get drunk?
This one. I'm working. I get in trouble for that. Okay, have a good day. Okay, that's good enough. I know. Okay, thank you. Okay.
I love it.
This one, okay. Have a good day, miss.
Look, and whatever the fuck he says,
Okay,
tell him
yes,
to
okay.
eat a dick. Hey.
But I love you, bro.
Okay,
Yep.
have a good day.
Talks it.
See you, man. Thank you. Okay, have a good day.
Tell him to thank you.
I wish they played that part
Video file axon_flex_2.
where he sat there and said,
It's the only one that starts.
I don't separate you. You're going to kill each other. You got to know these police officers got tired of this. I mean, seriously tired of this. Mm-hmm. When are y'all going to get to sound? I love this chair. It swivels. It's got a neck back like that and no arms, so I can almost sit sideways in it and tilt.
So, why don't you come on over and give me a written statement about what happened? I have it over here by my car. Sure, just stay right there.
Yep. I am.
Jordan, get your stuff done over there and I'll get her started on all this. You want to sit down in here? So you can write? Okay.
Mom! Don't leave.
Come on, let me call you here. Let's get this done.
I'm not getting arrested.
No, I'm getting a statement from you. You're not being arrested. So,
Okay, look, I'll come over and see you in like 5.
come on.
Thanks, love you. They know.
Let's get this done.
They know.
Okay. Now, would you come in here so we can do your statement, please? And stop this. Sit down at the table and let's get your statement filled out.
You didn't believe I would ever do it. How much took for it? Is that okay?
You wouldn't believe I would do it. Do what?
Never thought I would do it.
Did you have?
She's so drunk.
I'm not getting arrested.
No, you're not getting arrested. I've already told you that.
Yeah. It's on the couch. It's on the couch.
Need your ID, please.
It's on the couch.
No, ma'am. I just need your ID. Please.
Okay, look. I can write better on the couch.
I will give you the statement to write. I need your ID, please. I don't need to sit on the couch to fill this out. You can. I sit down all day, and I appreciate the offer.
Yes, it's comfy. I just come down, sorry. Thank you, God, he's gone. Oh, man.
Is that what's on the table?
Come over here and try and kill me. I want you to know that. They're gonna come over here and try and kill me.
Who's that?
His brothers and his mother and his father. They're gonna come over here and try and kill me.
Don't open the door for
It doesn't matter. They can all go up there and rant and bullshit and everything, and then they cause a commotion, and then I get complaints against me. Anyway, my name is Sarah.
Mm-hmm. Hi, Sarah. I'm showing this out just a minute.
What's your
He
name?
knows who you are.
Deputy Brown.
Jeff.
Okay.
Yeah, me too.
He will be. Do you have a phone number, ma'am?
407-716-8684. I'm not getting arrested.
Nope, you're not. Did you do something you should be arrested for?
No.
Okay.
For the last time I fought back. Or 20 days.
Do you have an email address, ma'am?
S-Sam, K-as-in-Kate, P-as-in-Paul, _1800 @yahoo.com. You can totally come sit down over here.
I sit down all day. I appreciate the offer, but when I get this done for you, it's a little more comfortable for me to stand and do this.
I can't tell you how amazing it is. Oh, wait, I didn't mean to say that. Sorry.
You can see her in the mirror walking around, y'all. Watch in this mirror right here. She's walking around.
Okay, come on in and sit down so you can get this filled out. And what I need you to do is you'll just print your name right where that X is, and then I need you to just write the story about what happened today.
Print.
Yep, please.
I got to tell you, officers put up with a lot of crap, y'all. I wouldn't. Every department has a one of her. Everyone. I wonder what the jury's thinking.
So is this a husband, boyfriend? Are you guys married?
No.
How long have you been together?
2.5 years.
Was he drinking or anything today?
Yes.
Both of you?
I have.
Okay.
Bless you.
Nothing wrong with that.
Here's my arrow thing, look, because I do artwork, look.
Okay, I need you to show us it. Very nice.
It's artwork.
Very nice.
I have a drink 17 years ago, and I do artwork.
No, nothing wrong with that.
Yeah, I'm with you there, Toxic.
And who called the police? Did you call the
I
police?
did.
Okay. Call 911?
Yes.
Very good. Has this happened before?
Oh, yeah.
The last one that came up, and they're like, oh yeah, we read your statement, so we know kind of who you are and what's going on.
So 3 times the police have been here? Was there ever, was it sheriff, were there reports written when they were here?
I'm not even sure about that, I didn't have to sign anything.
Okay.
I'm not really sure what else I'm saying.
If you're on a jury, how does this look like for you? How would you receive these videos?
Everything is happening.
Would it push you away from her side or towards your side? Mm-hmm.
You see my neighbors out there, because they know their children are allowed to come at the house and say, I'm really it.
What was your phone number again? 407?
716. 407 716. I'm not getting arrested.
Nope.
In the car still.
County charge $25. Could you give me 424 case number, please?
Publishing.
I wonder if the woman who's a juror that's going through DV, I wonder if she's recognizing some of the abusive behavior in Sarah.
Publishing audio file 911 call -first.
911, what is the location of the emergency? Well, I don't have an emergency here at my place, but my boyfriend was arrested, I think, last Thursday, and he has a no contact form, and he took it upon himself to come over to my house yesterday and took the bike that I bought for him, which is technically mine, and also my debit card. So, and okay, wait a minute, Sam, if he bought it, then it's a gift. He didn't. Okay, that's fine. I need my debit card though. Like, I have my 8-year-old son coming over here, and I came to buy groceries for him. Okay, then what's your debit card? My address is 4748 France, FRANTV, okay, 4. So what's your apartment number? 3? Your apartment number? 3? Okay, just to make sure I heard you right. Sure. Okay. Have you used anything else with the credit card? Yeah, he bought beer and cigarettes. Yeah. Alright. Sorry, ma'am, what's your name? Sarah, S-A-R-A-H.
Wait a minute. Did she give him the credit card to buy her cigarettes and he didn't give it back?
Yes, okay. And he's at his parents' house right now, so if you need the actual address over there or whatever it needs to be done. I'm sorry, Sarah, what did you say? He's actually at his parents' house right now, so I don't know. Okay, well, we're
I'll go and arrest him.
First, to make a report, okay? Gotcha. All right, I'm gonna get all this information in here, but considering it's up to you, I need to, send it every day, okay? All right, so when did this happen? Yesterday. The ex-boyfriend? Yeah, I mean, technically he's my boyfriend, but yeah, at this point he's my ex. All right, what's his name? George, Jorge. Something. Torres, Torres. Okay, by chance, do you know how old he is?
Are you ready for code
He's
red?
41. 21378. Okay. So Jonathan, please can recognize you. Are you like my first medic?
They live
What
together.
color shirt pants are you wearing? Right now I'm wearing a blue shirt with white sweatpants. And there's a green pineapple on my door because it covers up the three. Okay. Do you have any weapons?
Right side up or upside down?
No. I mean, I
One,
have a baseball
two.
bat, but that's just only when I'm here by myself or
Up and
me, my
down.
little 8-year-old.
Down, down. Both up. Those are all
And
signals.
does the pineapple covering the three? Yeah, the green pineapple covering up the three that says welcome. And I have a little bird flag out front. Okay. All right, Sarah, we're going to the next available WT, okay? No worries. All right. Thank you very much for your help. You're very welcome. Bye-bye. Okay, bye.
Publishing audio file 911 call -2nd.
It shows
911, what is the
her
location of your emergency? I don't necessarily have an emergency. It's 4748 France Court. 4748
Yeah, we know you, boo boo. We got it.
I'm sorry, what? 4748 and the name of the street. France Court.
We know you, boo boo.
And what's going on there? It's no contact thing. Okay. He's over here again. Okay. Is it French? Stop me penetrating.
I'm having a hard time hearing this.
Is it French court or French court?
French, FRENCZ.
What's the appointment number? 3. What's going on there?
She is dating a woman now. She has a girlfriend.
What's going on?
She does.
Oh my God, I don't my dog.
Her Jules, who met her.
Hold on a second, please. I'm sorry, hold on. Come on. No, we gotta go this way. I'm sorry, hold on one second. I'm so sorry to take your time. No, get out. Oh, ma'am, what's your name? Sarah. Okay. Get out of here. You hit my pantry. Hello.
Hear him calling in the from the
ma'am.
pantry.
You need a deputy? No. Excuse me? I'm sorry, what you asking me? Do you need a deputy? No, not necessarily. I'm trying to get my dog. I have a blind dog and a deaf dog. I'm trying to get them in outside. Okay, you're dialing 911. Yes. Okay, and you don't need a deputy? He's here again. Take it. That's mine in full voucher. You're eating in my pantry. And who's this person to you? Oh, ma'am.
Y'all.
Yes. Well, the front office, you're gonna send somebody. So, I'm okay.
No, we can't say that.
Regardless.
Word.
Regardless. I know how it works. I'm okay.
Look at all her notes. Oh my gosh, look at all her notes.
That's not yours.
all the questions.
Hello?
I'm still here.
Yes, ma'am. Thank you. Oh, thanks. Okay. Yeah, so
Wonder what the 911 operator thinks.
what do you want me to do?
Seriously.
Okay, you're just somebody you're over, so like, do what you gotta do.
All right, have a good day.
Publishing the one video in this file that starts with file name Axon.
So you're calling 911 and you're telling him he's not supposed to be there, but you don't want a sheriff. Deputy, why are you calling 911? What do you want us to do? And he's living there and they get in a fight. Then she calls and reports him. But in the meantime, he's living there. Y'all, I just. If you think men are bad, women are worse. Oh, yeah. I think she'll be worse with the woman. A regular uprighted pineapple means nothing when it's upside down. Oh, they just walked in.
What's up, bro?
Hey,
It is. So what happened? What's going on now? Did this just happen?
what?
No.
No.
I said earlier.
Oh, no, when I moved in, we dropped it.
So who called?
He ain't messing.
So what's happening?
They're asking you, not me.
Yeah, you speak to him. I'll speak to you later. Come here.
He's like, I'm out.
So you guess you called for a reason, right?
Only 24 hours.
Yeah.
Okay.
Yeah, but you realize he's here now, right?
Oh, this is so not going to bode well for her.
I had a drink. It was raining.
I didn't read it. You don't have my guy.
Okay, well.
Yeah, after he's here. Yeah, you can stay right here. You can stay right here. He doesn't know. He doesn't have to. After. We have to. We left earlier. We respected your wish earlier. Yeah, we respected your wish earlier, okay? But he's here. Okay. If you guys don't that's the only reason. Yeah, I have to. You can stay right here. You don't have to go. You don't have to go. You don't have to go. Oh, you can sit back. It's not raining. It's just sprinkling. It's okay.
Go in the corner if you want.
Yeah, it's all right.
Hey, but I'm literally begging you, no.
Yeah, but you know he's gonna have to. Stay.
Last week, we guys was, I guess, a physical or whatever, I don't know. I got taken out of
here without no shirt, no shoes or whatever. And then you went and saw the judge, right? Yes. And what did he say? The judge was like.
Was it a female or male?
Female.
Female? Okay. What, you don't know what she said?
He was bad.
Yes. My head hurts. Don't grab. That's a dog. No, this is a thin blue line.
Okay. And what was written on it?
Stop.
I did not get it.
We're not gonna do it yet.
At all. Did you get any form of paperwork? I got paperwork, but I didn't get. What was that paperwork? Paperwork was, X.
What does it say?
No.
With who? With who?
With her. But.
Is she in your bed? Lay down. You can lay down here with me. Come on, lay down.
The judge is on the matters, right?
Down.
Is it?
Is she? I believe so. She's above us.
Is she above her?
She's the judge. She's the law. Okay.
You guys don't want to talk me in.
Is my other guy here? Okay. So here's the deal, man. Your paperwork says that you can't have any contact whatsoever with her. Okay. And if you do, it's a new charge. Okay. So.
I like contact.
Have you been? Has she been drinking today? Have you been drinking? Okay. How long have you been here since?
I'm gonna be honest. You guys came here. She called me.
We know, because we went to your work of employment, and they told, and they told us that you just left. Yep, and we knew that she called you. We knew that. We knew she called.
Oh, it's just she called me and said,
Yep.
coming.
You're correct. Okay, so you know what's gonna happen, right?
Yes.
Okay. Stand up. Stand up, Roswell. You can take one last puff.
Please?
Yeah, one last. Go ahead. Yeah, just put it out real quick. Alright, wait, one more.
Wait, no, what?
Never make sure.
Come on, relax. Relax. Okay.
He doesn't seem to be at all aggressive. He may be a little tense. Is that the infamous TV? I want to see if something's in front of it as I move. If I can.
I didn't call.
I didn't say you called.
See, I told you.
But you did you call him earlier?
See, I told you.
Because he just told us. And we know the store told us.
I told you. Wait, is there anything that he do?
You're good. You can stay right there.
No, is there anything that he's not?
No, man, you know he has no contact order on a judge. He can't be here.
Okay.
Yeah, but
You need her for anything?
no, we don't. We have her information already.
Yeah,
So here's what's gonna happen.
we got our
You're gonna
information.
write that down,
Mhm.
and because it's almost 2:00 in the afternoon, you're gonna see a judge tomorrow morning. You're gonna see her today. It might be the same judge that gave you no contact order. Okay, that's it. From here on out, but until that case is resolved, you cannot come here. Okay, or have contact with her, even if she invites you. Okay. She called us earlier, and told us that you guys had a no contact order. Okay. She don't want anything. Charge nothing.
She's not allowed to go to him either.
Instead of Florida has to. Okay, so, all right, but just make sure he's got nothing on him. Hey, you have anything on you, right, bud? Okay. We'll make that cordial as can be. Okay, we promise, man, all right? What you say?
I love you, babe.
Love you, Mia. Love you. Go Eva. That's what she did last time. Today has been the most interesting day at trial, I believe, outside of her testimony. The mamas. I'll be seeing you again. Hey.
No. All right, man. Just give me your mom's your photos. It's not there. I don't know it. What's the charges? So the domestic battery charge that he got hit with last week or whatever it was, he was given a no contact order by the judge. Okay, whether she invites him or not, I know. He knows he can't be here. So he was here this morning, and she called us this morning. Okay, he's now back. And he knows by the means he can't get my time. No, he gets a phone call anytime. Yeah, he gets when he gets in. Well, if you have a piece of paper real quick, you can get it for me and we'll give it to him. You don't know your mother's phone? She has. If you can get it real quick, we'll give it to him. You're not getting it from somebody. Okay, make sure that.
Lay down.
Publishing from folder OCSO 19-078009. First item is a PDF of photographs.
Is that of George or just her? I want to see him. That's her. Those skanky feet. I'm kidding. Why are you showing these? You're not helping your case any. You're not helping your case any. Oh, there's his face. Okay, they're showing all of them. Look at his neck. Did you see his neck? Look at his neck right there. Look at his neck. Yeah. I would. The bruise on the neck. Is that on him?
Second item is the single video starting with Axon.
So here's where she gets arrested. For strangling him. And him fighting back. Sensei, is she in? Let me get the cat out of her bed. I'll be right back. Is she in your bed? Is she in your bed? Hey, kitty, kitty. Kitty, kitty. I know. What? Sensei?
Oh, I have been here.
Yeah, I
thought you looked familiar. Because the last time I was here, you guys had a fight at the bar. And or he came home from a bar. Someone came home from a bar. Hey, who's that? What? Hey, George?
Yeah, what's up with the blind light? Is she there? She's dead. Okay, can you just pick it up? No problem.
What's going on tonight?
You didn't think I'd call.
Okay, come on, George. Off couch.
What? No, they're not staying on there.
Okay. And then you think this is my time? No.
No, baby.
Sorry. Are you serious?
Yeah, I don't want to be punched in the neck.
Are you serious?
Told you I will not hesitate.
So she gets pissed off and calls the police. So she's using them as her finishing tool for him. Honey, come over. Let's honey huggy kissy kissy boo boo get in a fight. And she gets, no, there is nothing on the floor in front of that TV. So they did lay something down before they trashed it in the video. Good catch, y'all.
Punch me in the neck again.
Sarah, you serious?
Am I allowed to put my door to about?
Yeah, you can. I'll be right back with you. We're gonna go pause down here. Can you grab the paperwork?
Yeah.
We're gonna sit right there and punch up. Alright.
You sure you don't want me to watch him?
You can, come on. That'll work too.
Poor dog. Cat keeps kicking her out of her own bed.
Someone hit me and I'm the one that gets locked up.
Well, let's just get down to the bottom of it, okay?
Alright. George, I want to talk to you. I want to ask some questions. I have your hands up, so I've got to read you something real quick, okay? Do you understand?
That's right.
Alright. You have the right to remain silent. Anything you say will be used in a court as evidence against you. You are entitled to talk to an attorney now, have him present now, or at any time during questioning. If you cannot afford an attorney, one will be appointed for you without cost. Do you understand these rights as I've read them to you? Okay. At any point hereafter you wish to remain silent, have an attorney present, all questioning will stop. Do you understand that? So even if you want to talk to me at first and you change your mind, just let me know. Okay? All right. Has anyone at any time threatened, coerced, or promised you anything in order to induce you to make a statement? Have I promised you anything? Have I bribed you? Have I said, hey, if you tell me, give me a statement? Has any of that happened? No. Okay. Do you understand these rights as I've read them to you? All right. So,
yeah, he's crying.
What were you two fighting about tonight?
We weren't fighting at all.
Okay. What are you fighting? I'm going to take that in there so that. Huh?
I'll do it.
I'll take the statement and get the statement done.
Oh, with him?
Huh?
From him?
No, for her.
Okay.
That way you can fill this out while you're 10-12 with him.
Sarah.
I'll get her information from her.
Okay.
Okay, listen. Why is he so angry? What up? Okay, can you explain the bruises she has? Those don't come from nowhere. I want your version of what happened.
Cat hair. It's too much. If it's too much and it's triggering, please step away.
You did it all the time, but you like it. How does it usually happen to her? You know, you're going to defense, no. You just said it wasn't a defense. So if you get rid of it, you get it set up, you figure you can start. That's fine. Sarah? No, you said that.
Getting on 2220 of the unknown means an hour ago. Today, 6 complainant, 3028 Riverdale, 3028 Riverdale, an hour ago via text message to 323.
I couldn't figure out what was in his mouth. It's a paperclip.
Sarah, stop calling for it. Not welcome down there. I know, but I'm not going to change things. I know why. Because you have a total. You have a battery. And when I try to get the straight story, you don't want to give it to me. I'm saying this strictly. You got your chance. All right. I've tried. All right. And now that you're going in the back of the car, you want to give me a story. It doesn't work that way. I do nothing but play to you, trying to talk to you, trying to get straight answers, and you're beating around the bush. I'm not. Yes, ma'am. Do not start kicking and banging on things, okay?
Sarah, what's your phone number? What? What's your phone number? I don't know your phone number. Sarah, what's your phone number?
It's not him asking, it's us.
You said, hey, what? Thank you.
Verbal 711 and 10601 Narcoossi at Long Bar, complainant versus business, reference refund, out of 2017. Like the female, pretty sure we need a very non-CRB.
Can you guys not put on music, please? Okay. Please.
Fifth folder, OCSO 19-079759. First file is a PDF starting 48-2019.
What'd that say?
Second file is
Obey
an audio
what?
File 911 call publishing.
It's not technically an emergency, just, you guys have been there so many times before. I'm not there, but I'm just trying to go home.
What is the address?
4748 France Court.
What was the street name? Brant's Court?
France. F as in Frank, RANTZ as in zebra.
Oh, is it France?
I don't know if it's there or not. I'm sorry?
Ma'am, is it France Lane?
I'm guessing so. It's France Court, but it always comes up as France Lane.
Okay, what exactly is going on?
I would like to go home, but I can't go home because he's there.
Okay, do you have some sort of restraining order against him, or?
Okay, it is
He
false.
has a no contact.
Is there an apartment number?
3.
1 second.
I'm at my former husband's house right now because I can't go home. I don't even know if he's there or not. He was there earlier, but I can't go home.
Okay, so do you want us to do a standby with you?
What do you mean?
Like, escort you to the residence, or that, I'm not understanding what you would like.
If I could please, can you guys go over there and just see if he's there? I'm pretty sure he locked me out earlier, so I think he's probably there still. I'm not going over there with him then. I'm not.
Okay, does he live there?
No.
Okay, so how is he inside the residence then?
He has a key that he took.
Okay, so is he breaking into the apartment?
He's not breaking, he's already in the apartment. As far as I know, I don't know, like, if he's there or not. He knows where I had my
We'll
key.
be fine.
Okay, what we can do is we can meet you a block away from the residence and go with you to the residence.
I don't know.
This is not a part. This is not.
Please, if he's not already.
An escort.
So
Well,
I have my
a
8-year-old that I'm
babysitting
trying to
service.
watch out for so right now. So I'm not really sure what I'm supposed
This
to be
is
doing.
not your private security service
Okay,
view.
if you want to go home and you're not sure if he's there or not, we can meet you when you're about 5 minutes to a block away and go with you to make sure he's not there.
Okay, well.
He's not comfortable with this.
I'm about to get, to be honest with you, kicked out of my apartment because you guys get called so often, and like the brigade comes and this, that, and everything, and like the neighbors complain about everything. I'm trying to avoid that. I just want to go home.
Okay, regardless, the deputies are going to go to the apartment, whether it's with you, what I'm suggesting you do, or it's what you want to do. Just have them go to the apartment. So regardless, people are going to see that there's deputies going to that address.
Okay, so when I called you guys like a couple of days ago, and they didn't make like, not a ruckus, but like they made it like incognito, which is what I need, because I'm going to get kicked out of my place.
Okay, when we do a standby, ma'am, all we're going to do is accompany you to the address and the deputy to make sure that he is not there, and then they will leave. If that's all that's going on in this situation right now that you're calling for, it's not going to be like a big deal.
And what happens when he is there?
If he is there and you don't want him there, you can have trespass. They're going to make sure he can leave. I mean, if he does not live there, like you're saying, and he should not be in there, you can trespass him. You already have a no contact order with him. They will remove him.
Okay, well, there was an altercation earlier, and I'll be honest with you, there was an altercation earlier. So that's when he came in, the altercation happened. So that's when I left. I fled barefoot. Now I'm at my former husband's house.
Okay, would you like the officers to meet you where you're at right now?
I don't want to get arrested. I don't, because I fought for myself, and I have my 8-year-old, and I just want to go home and sleep in my own bed right now. But I did fight back. I'm not gonna lie. So,
Okay, well, I mean, if you're wanting us to meet with you or go to your house, I mean, I don't know what they're gonna do. If they're either gonna arrest anyone, arrest you, arrest him. That's all up to the deputy and what he concludes from the situation that's going on. So it's right now it's just up to what you want to do right now. If you want to do a standby, we'll accompany you to the residence. I mean,
yeah.
it's really just what you want to do.
I know. I think I have to take my time tomorrow. I just.
Or what I could do is I can have the deputy call you about the matter. If you want to speak to a deputy directly, and if you want to do that first before having us respond out there.
Yes, please.
Okay. What's your name?
Sarah.
Hold on a second, Sarah.
Thank you for your help. Actually, more ways than one.
And is a good phone number for you 407-716-8684?
Yes, ma'am.
Okay. I'm going to set up a call for a deputy to call you over the phone, so you can talk to them directly and see what they say about the situation. And when they call you, it'll be from a blocked or restricted number. So if you get a call like that, just make sure you answer. It's going to be the deputy, okay?
Yes, ma'am.
All right. If anything changes or you decide you just want us to come out and give us a call back, okay?
Yes. And what was your name?
My name's Rachel.
Rachel, thank you so much for your help, and I've got the phone right here on my lap.
Okay, perfect. Bye-bye.
Thank you. Bye.
Publishing the one video in the folder, starting with 1924, from 0 minutes to 20 minutes, 41:30 to the end.
Okay.
I'll take this even here, guys.
You have both of these? Tell me already.
Is there a back door or side door?
Yes.
No.
If you go 10-12, just let us know. Well, thought that was open for a second.
Yeah, look like it.
Locked. That's over.
they locked the back too.
Yeah, the back's locked.
Anyway, you wanna call your ex-husband? You have a phone?
It's locked, sorry.
There's a charger in that.
It's not in the house. It's not to say it's not in there, just because the doors are
What do you
locked.
guys think about them showing all the videos?
I don't understand. You think he's inside?
Yes.
Okay, well, we need a key so we can get inside, so he's inside. That's what.
And if your phone's gonna die, there's a charger in back on the back side of the porch.
Oh, yeah.
Come on, Cynthia, lay down. Lay down.
The keys in the house is not coming to the door, but I do have my spare key. I can't get in. If you could, there's no other way of getting in my house. Unfortunately, can you please bring me my spare key? Yes, please. The front door and back door. I have no way of getting in.
My ears can't handle those noises, y'all. Give me a headache.
I'm sorry?
You said that's your ex?
Last night, I don't straight. He'll be here in like 2 minutes.
Perfect, thank you so much.
No, thank you.
Is your, this your, three things here, your ex-boyfriend, is that correct?
My place.
Okay. No question. The boyfriend or ex-boyfriend?
I don't know what's going on.
Somebody
Yeah,
did?
that's pretty.
Yes.
Okay. Does he not have any weapons?
No. No.
He was arrested last week for bad TV.
Hey guys, I just want to take a picture right here. You can see that. Stop pushing my phone.
Saw he was arrested before, was that also like one time?
Last week.
Yeah, but. That's what I told you. And again, I was sleeping.
How much did you have to drink tonight?
Who we diagnosed?
How much did you have to drink tonight?
2 drinks, and that was what, 4 hours ago?
So what's the layout of the house? Is it both
That was
floors?
cold, y'all.
Is this part here? Or is that something, so these 2 windows right here?
What kind of vehicle does he drive?
This is when he was hiding in the shower, right?
He's a little bit goofy on the line.
It's about my dog. She's, I had a blind dog and a blind dog.
Oh, gotcha.
So I have a feeling it's probably tight.
Don't forget about the deaf and blind dogs.
She's the best one.
Does he have anywhere else to go? Or is this the only place he has?
It's his parents' house.
Where's that at?
80-30-15 Boulevard. It's on the street next to where the street is. You know where that is?
Oh, gotcha.
Guys, can I say something now?
Sure.
If both doors are locked, he has to be in there.
Why is that? You can't lock it from the outside?
No,
Doesn't he have a key here for here though?
unless he took my spare key, which I'm pretty sure he probably did. He has to be in there. Especially the back door.
Is the spare key, was the spare key in that house?
I headed outside because he locks me out all the time. So I'm gonna say that then. If those doors are locked, he has to be in there. Y'all can have this, y'all can open the door.
Hey, you're gonna stay outside so we can make sure nobody's inside.
After that, thank you so much.
hanging out here.
I am. I'm not going in there. There's no weapons.
George?
There's no weapons.
Ask for minute. Ask for minute.
That's Lucas.
Reference building, sir. I know. County 120, 124, Charlie. Thank you, sir. Can we get minimum traffic for a building search? Are you making announcement? Yep.
You guys don't have to do that.
Yeah, we have a way to do things. Just let us do our thing, okay?
Sheriff's office, you in there, come on out. Sheriff's office, you in there, come on out.
I got a dog.
George.
Hey, Bubba. Yeah. We have a ton of plants on the right side.
Just when you get that stairwell, just hook your toe right up, or don't go up, that's when you got up. George, please. If you're up there, let us know, because we're coming up anyway. Go ahead. Run, whenever you're comfortable.
Yeah. Okay. Open door right there.
I think that's a kid's bedroom.
Okay. Just get that way for me.
I got it.
What is wrong with Miss Paula Abdul? Janet Jackson?
Boy! Show your hands.
The singer of the song, The Love Boat, died today.
Put your hands behind your head.
The man who sang the song.
Hey, turn around, face away from me. Turn around. Walk back to me. Walk back, walk back.
He didn't have any fat on him, that's for dang sure.
Why didn't you tell us? Interrupted. Huh? Why not? Like you didn't hear us. There's a reason you're sitting in the bathroom. That's what?
And once my foot Charlie comes off, 10 mils, go back normal. Thank you.
Hey guys, can I?
Before we go, we're not doing anything right now. Sorry, we're not even taking out room. I'm gonna sit you down in the bed right here.
Okay.
Alright. Let me ask you a question.
Yeah.
What happened today? You got a line here?
Yeah.
You just gotta pull the thing?
Yeah.
What happened?
I don't even know what the heck happened.
There's a reason you're hiding the bathroom, so don't act like we're not up here for no reason.
No, I know that.
Okay,
I'm hiding in the bathroom because we had a discussion and as usual, and I am in the room.
Okay. What?
I am with what is it called? It's called
Victim.
No
contact order.
No. But we.
How long have you been here? How many days since you got released? When did you get released? Because you were arrested last week, right?
Yeah.
All right. When did you get out?
Let's say 3 days ago or something like
It
that.
was on the weekend.
Yeah.
Today's Wednesday, or was it Monday? Or was it this weekend or was it Monday?
The weekend.
Okay. After that, did you guys talk? Come back here? Yeah. This weekend, and everything was fine.
No, but she keeps getting them out, and that's what the jury needs to know.
I don't know what happened tonight.
George. 3 cops standing in front of you. You're hiding in the bathroom.
Yeah, I know that.
Okay. That's not for no reason. Right?
Wifey is nuts, and she always freaking starts stuff, and she.
So that's what I'm asking. I'm telling you what happened.
She puts it on me
Okay. She puts it on you.
all the time.
Well, you're not. None of that gives me any insight as to what happened tonight.
Nothing.
Both are very big. She's very big, you're very big. Any more than big.
What is she being big about?
I can't discuss what she's discussing until you discuss to me, right?
We just want to hear your side of things, but
everybody wants to hear my side all the time.
Zach, I did.
Because this isn't the first incident from the school.
No, I know
She's
that.
been arrested as well, hasn't she?
Yes.
Okay, so tell me what happened. You all drinking?
Yes.
Both of you?
Yes.
Okay. I can smell alcohol on her, so I know I already knew that, obviously. But,
we've been going through a lot. Right now, I work at Ace right here, across the street. We're going through a lot and they're about to shut down and whatnot.
At Ace?
Yes.
Okay. Just tell her next time.
Can I please have some water?
just wait. There's you can't drink that for right now? Oh, you can't come in here for right now. Okay, you're gonna have to wait. Give us a couple minutes.
She's serious about her water. I'm surprised she didn't have a bling bling.
Are you injured in any way? Did she injure you today? Did she hurt you? Maybe emotionally or whatever? Any physical injuries? No?
I'm the one. I'm always the one.
You're the only one saying that. You're not saying that.
I'm always the one.
But you're the only one saying that. Nobody here's saying that. But if you don't help me, how can I help you?
I don't think anybody believed him, and that's a shame.
That's my woman.
Okay. Sometimes that's what it is. Is that as much as you want to give me?
What's he saying?
George, I told you I can't say that. If you're not going to tell me what's happening, I'm not going to tell you what she told me, just so you know exactly what it is. I can't feed you information.
I get it.
Why don't you ever call us?
Why?
Why not?
Would you call you? Would you call?
Look, I've never been in that position, so I can't say.
That is your beefcake.
It ain't like that. My girlfriend's small, but she's crazy, so.
I am, what am I gonna say? I'm actually wrong right now.
You're in the wrong right now?
Yes.
No matter what way, you're saying you're in the wrong, no matter what way you cut it?
No way, shape, or form, you know that I am.
I can respect the responsibility, because most guys won't even take responsibility.
You're gonna take me in no matter what.
Well, that isn't necessarily true. I take girls in jail all the time, but that are easy, all the time.
No, you're gonna take me in because I, did the no contact.
Guys, when the
Yeah, I'm fucked.
What is it?
I am fucked.
What are you not supposed to do?
Oh man, you're the one that took me this time.
I think it's
guys, when the Menendez brothers announcement starts, we'll flip over there real quick. It's going to start soon.
That wasn't me. Just I don't work this side.
they're not. They're a little similar. They look a little.
Our hairstyle's the same.
Yeah. Yeah, it's not the same guy, I promise.
No, I promise you, I would remember you. It's not me. But what did no contact order tell you? What did the judge tell you?
Not, you don't hang out, you're in contact with her at all.
What about in relation to this place? Are you allowed to come back?
Oh, yeah, no, yeah.
Let me ask you this, do you just have no place to go?
No, I got a place to go. But
Your mom's place?
Yeah.
They still over there by the Twisty Tree?
yeah.
I do my homework.
But before you guys take me, can I get at least, shoes?
What kind of shoes you want? You want some comfy ones, some fly ones?
Like those, no fly ones.
These, I like these leather ones.
Get the blue ones, please.
This one right here?
Yes.
What shirt you want?
And that black one, but
This black shirt?
yes.
You want socks?
Yes, they're right there.
You got a wallet? Phone?
My phone's downstairs.
Gotcha. Have a wallet.
Not that shirt.
There's another black shirt that's comfy. Maybe it's this one. Is that the other one? They're both inside out, I don't know.
The Ace? Yeah.
You like the Ace one?
Yes.
Alright, we'll do that one.
Can I, please, sir?
Please what? What do you need?
So I can put them on?
Oh yeah, we'll handle that in a second. Let's get the shoes on.
Okay.
Where do you say the socks were?
Okay. Yes.
Is black or white?
White ones.
Okay, guys, I'm getting a bad headache, so I'm just going to take the lights off for a little bit.
3 years.
Can y'all see me okay?
That's what behind us?
That's bad when your monitors are that bright.
It don't really matter. I'll answer. Okay.
Just step up right here for me, please. I just gotta get in the tree. Oh, you're okay. Oh, what? Oh, okay. Okay. Yeah, no, it's okay. Just a quick question. He's asking about his phone. Do you know where that'd be?
No, I don't know what's going
Okay. You don't have it in your vehicle or anything?
I do not.
Okay.
I have it in front of myself. Wait. I need my car keys.
Okay. They're not on here. They're inside the house somewhere.
You seen them?
I haven't seen them, but they're in there somewhere. They're not on here because I had to search him before he got in the vehicle.
Is it too much to ask? You can ask him where they are, please.
Okay.
I only have one, sir.
Okay. You don't know where his phone is? Okay.
I'll take 800 Filipino subscribers.
He's asking about.
I'll take anybody.
Should we ask him right now?
He doesn't have nothing in pocket, so.
Okay.
Where is she?
She's up behind your vehicle.
Yeah, you want to just take that number?
Okay, yeah. Hold No, he didn't have anything in his pocket. We can take pictures real quick, if you don't mind. We're gonna take one overall.
No, they are.
Man, do you mind? Stay right there. Actually, a little more this way, so we don't get the police car in there.
You said what? You want me to shine a light on it? You close? No, actually. Okay.
He didn't have anything in his pockets.
I'm gonna go on this side. Why?
Yeah.
Yeah, no, absolutely.
They're gonna be coming this way, so if you want. Okay.
You want to sign now?
Yes.
Yep.
One dog's sleeping downstairs and one's in the
I'm
bedroom.
tempting you, Zach.
You have any other questions? I'm sure they're in there somewhere.
That's it for that exhibit. The state is at the pleasure of the court and the jury if we want to proceed.
Can the parties approach for a moment?
So does that mean they rest? I'm sorry, guys. I am having a headache. Oh, Toy, y'all are horrible. Y'all are having too much fun over there. Sorry if I got quiet. All of a sudden, I got a headache. I don't know why. Look at her hair, y'all. Where's your hairstylist, boo-boo? Look at all those notes. It was well, if they were to actually get to jury deliberation, that wouldn't have been a problem. So it's 5:04, so they're going to probably quit for the day. Which means while I'm gone
Members
tomorrow.
of the jury, thank you so much for your attention this afternoon. The state still has some additional evidence to place into evidence. It's about an hour or so. Now, I know I got a note this morning, we can't stay past 5:30. So the question I have for y'all is, are you okay with staying until 5:30? Or do you want to go ahead and call it an evening at this point in time? I leave it to you.
Ready to go home.
It's 5 o'clock. 5:03, exactly.
I say keep going. Does anyone reject? If Lauren can stay. I think we can stay.
5:30, correct, though? That's my understanding. Okay, thank you, sir. All right, state, you may continue.
Commission published 21, which was
This
B
is
for
why
identification.
all the arguments today
You may
early
proceed, sir.
were so impactful.
Are they audio or video?
It would be video, thank you.
Are these redacted, counselor?
No.
Okay, thank you. All right, members of the jury, I have an instruction just to read to you with regard to States 21 that you just saw. I'm sorry, States 22, forgive me. Members of the jury, you have viewed and listened to video and audio recordings. The court instructs you that the recordings have been edited to eliminate irrelevant portions that would not add to your understanding of this case. The fact that the recordings have been edited should not concern you in any way and must not impact the way you viewed, listened to, and consider this evidence. Thank you. State, you may proceed.
States 21's DVD and its main folder is labeled a folder of attachments, and then there's a file labeled extraction.
Somebody else has got to go.
Attachments.
The Menendez brothers are getting ready to go live.
First file being published is img_0665.mov. Date modified metadata indicates 12/3/2019, 2:05 p.m.
Whenever you leave the house, just let.
I'm going to stop here.
Began speaking, I want to also introduce some other people that are here with me, and I hope I'm pronouncing the names right because I've seen handwritten part of it. But I have Ana Maria Barat, Jose Menendez, Jose Menendez and niece Karen Vandermolen, and Kitty's niece. They're all here with us. Also with us here is Brock Lunsford. He's the assistant head deputy for the post-litigation conviction unit, and Nancy Cervier, who is the deputy district attorney in charge of the resentencing unit. Let me begin by telling you that this is a case where we've had many people in this office spend a great deal of time reviewing the case. I have to tell you unequivocally that we don't have a universal agreement. There are people in the office that strongly believe that the Menendez brothers should stay in prison the rest of their life, and they do not believe that they were molested. And there are people in the office that strongly believe that they should be released immediately and that they were in fact molested. I have to tell you that after a very careful review of all the arguments that were made for people on both sides of this equation, I came to a place where I believe that under the law, resentencing is appropriate, and I am going to recommend that to a court tomorrow. What that means in this particular case is that we're going to recommend to the court that the life without the possibility of parole be removed and that they would be sentenced for murder, which, because there are 2 murders involved, that will be 50 years to life. However, because of their age, under the law, since they were under 26 years of age at the time that these crimes occurred, they will be eligible for parole immediately. The teams that have worked on this, on the resentencing side of it, have spent literally probably hundreds of hours by now looking at this case. These cases were originally presented on the habeas side of it, which I'll explain in a moment what that is, last year, and then the request for a prosecutor-initiated resentencing occurred earlier this year. And there have been people in this office working in these cases from the very beginning, as well as many other cases that we have. The reason why I'm here today and why I came in front of all of you about 10 days ago is because there was a more recent documentary about the case that again brought a tremendous amount of public attention. And we know there have been other documentaries, so this is not the first, this is a more recent one. And frankly, our office got flooded with requests for information. And even though this case was already scheduled to be heard in late November, I decided to move this forward because, quite frankly, we did not have enough resources to handle all the requests. And one of the things that I thrive to do in this office is to be very transparent in everything that we do. In this case, we review the prison files. You have to understand that the way the process works, when you're talking about a resentencing under the law, it really focuses not necessarily on what the original crimes were, but it focuses on, has the person been rehabilitated, number one, and number two, can they be released safely into the community? Under that rubric, since I've been in office, we have resentenced over 300 people, including 28 for murder. Only 4 have reoffended. If that was a regular recidivism rate in this country, we would be the safest nation in the world, but we know that it's not. In fact, somewhere between 40 and 50% of the people that go to prison reoffend and get rearrested. And that's why we have so many problems. However, when you look at the case of the Menendez brothers, you see 2 very young people. One was 19 and the other was 21 when they committed this horrible acts. And I want to underline, they were horrible acts. There is no excuse for murder. And I will never imply that what we're doing here is to excuse that behavior. Because even if you get abused, the right path is to call the police, seek help. But I understand also how sometimes people get desperate. We often see women, for instance, that have been battered for years, and sometimes they will murder their abuser out of desperation. And I do believe that the brothers were subjected to a tremendous amount of dysfunction in the home and molestation. But they went to prison for life without the possibility of parole, which meant that certainly under the law at that time, they had no hopes of ever getting out. They could have done what many other people do, which is basically said, you know what, I'm here for the rest of my life, so I'm going to do whatever. I'm going to misbehave, I'm going to join gangs, I'm going to live the life of the prison. But they never did that. To the contrary, even though they didn't think that they would ever be let free, they engaged in a different journey. A journey of redemption and a journey of rehabilitation. And often the people that begin their journey of rehabilitation and redemption in prison is often very internal. And what they do, and one of our lawyers pointed out this today, is usually the path is people try to further their education, do things for self-improvement, which the brothers have done, by the way. But it's more unique or less usual, I guess, when people not only do that, but they also begin to engage in ways to make life for others better. And in this case, the brothers have been doing so for a very long time, creating groups to deal with how to address untreated trauma, creating groups to deal with other inmates that have physical disabilities and may be treated differently. Even in one case, Lyle negotiating for other inmates as to the conditions that they live under during prison. And all this was done by two young people, now they're not as young, that had no hopes of ever getting out of prison. They have been in prison for nearly 35 years.
Wow.
I believe that they have paid their debt to society, and the system provides a vehicle for their case to be reviewed by a parole board, and if the parole concurs with my assessment, and it will be their decision, they will be released accordingly. I must underline, however, this case will be filed in court tomorrow. The final decision will be made by the judge. Court has to agree with my conclusion that they deserve to be resentenced. It is very possible that there may be members of this office that will be present in court opposing the resentencing. And they have a right to do so. And we encourage those that disagree with us to speak, and the court is the appropriate place to do it. We certainly feel we're very sure not only that the brothers have rehabilitated and that they will be safe to be reintegrated in our society, but that they have paid their dues, not only for the crimes that they committed, but because of all the other things they have done to improve the life of so many others. So, again, we will be filing for resentencing tomorrow. We're seeking that they would be sentenced to life with the possibility of parole, as opposed to life without the possibility of parole, which is they currently have. That means that they would have 50 years to life because there were two murders. But because of the age upon which they were convicted, under 26, under current law, that means they're eligible for youthful parole. I think there is also important to have some introspection today, because I think that often for cultural reasons, we don't believe victims of sexual assault, whether they're women, whether they're men. We saw in our first trial, which, by the way, they were tried twice. The first trial hung, meaning the jury could not come to a conclusion. And in fact, about half of the jury wanted to convict them of manslaughter, which, if that were have been the case, they would have been off prison a long time ago. And then there was a second trial, and then they were convicted of murder with special circumstances, which led to the life without the possibility of parole. But it's salient to understand that our own implicit and sometimes explicit bias around sexual abuse and sexual assaults often leads us to severe injustices in our community. And I want to speak to those that are victims of sexual assault now, whether you're a man or a woman. Know that we're here for you. If you're a victim of sexual assault in this community, and by that we're talking about LA County, not just LA City, you can come for help. Whether you're prepared to prosecute or not, we will be here for you. We have services for you. And if you're prepared to move forward with the prosecution, we will evaluate it as we do any other case. And if we believe that the evidence is there to present a credible case in front of a jury that can be proven beyond a reasonable doubt,
he said if it
we would proceed
had
accordingly.
been
You do not have to suffer alone.
manslaughter,
You don't have to keep it to yourself.
because he's
And help is
referring
here
to the
unconditionally.
defense, like battered spouse defense.
I'm going to say a few words in
because of
Spanish
abuse.
because I know there's tremendous amount of interest from the Spanish media, and I know that there are going to be other speakers today, and then we're going to open it up for questions. Primero que nada, quiero dar las gracias a todos por estar aquí hoy.
Okay, I like his voice. Now, I'm going to get back to this trial because, well, we got to get to the end of it. We've heard the news that he's going to recommend resentencing, and there is a possibility that they could get out of jail in the near future. So let's go over here and get back to what we were watching. I'm going to back it up just a hair.
65.mov. Date modified metadata indicates 12/3/2019, 2:05 p.m.
Whenever you leave the house, just let me know where you're going.
And you're gonna let me leave.
Yes. Just let me know where you're going.
And I get to leave the house.
Yes.
Exit.
Just let me know where you're going so at least I know where you're at.
Anything else you'd like to add?
I love you.
So it's not yank me back in the house and sit the fuck down and shut the fuck up?
No.
Yank.
No. Just let me know where you're going so I know where you're at. So if you don't come back, there's no certain time. You don't have to come home at a certain time because I'm not. You're grown up. I just want to know that if it does surpass a certain time, that's like shit. Where's she at? I know where you told me you were going to be in. So that way I can go and.
So I'm allowed to have friends.
Yes, nobody said you can't have friends.
I need to go see Boone.
You can go see whoever. I just don't want you to go frolicking with male friends.
That's reasonable.
By yourself because you know what's happened already.
She cheated on him.
You understand what I'm saying?
So I get to go see Boone.
Do you get what I'm saying?
I get to go see Boone.
I don't care about Boo. You can go to see Boo. Do you understand what I'm saying, though?
She's the one cussing and throwing her butt around. He's talking semi-politely. That is not an... You guys, is that Is that an unreasonable request?
Text video is a long file name that starts with 2A494, and it's the only one that will show up with that search. Date modified indicates 12/29/19, 12:26 p.m.
Hi, fuck you.
I don't know what you talking about.
Let's just tell everybody you got crumpled on the bed.
Crumpled? Crumpled. The word you're using is crumpled. All right. So this is my. Jeez, you gotta put it all over my face, dude. I know you're filming me, but you gotta put it all. What the fuck is that? Stop.
Bum rushed.
Yeah, you're bum.
I bum rushed you.
Yeah, whatever. Anyways.
What was the choice?
So the choice was to beat your ass or get my ass beat or whatever.
No.
Huh?
Twas.
Huh?
Twas.
Twat?
Twas.
I like twat. I've been trying to get twat from this woman. I've been trying to.
I don't understand.
Pardon me.
I'm not understanding him.
I've been trying to get some of that right there. She found some other shit. I don't know what's going on.
What is she doing that he's photographing her?
She's trying to film me, filming her, and blah, blah, blah.
I'm cooler than you.
No, yeah, you are. You are cooler than me. You are cooler than me.
They said they didn't smoke in the house. What are they doing? Smoking in the house.
She is cooler than me. She is. Beyond cooler than me.
Oh, I want to get this on film tape. Did I take your cigarettes today?
No.
Did I take your cigarettes to the beach?
No.
Then who was blaming on?
You. I blame it on you. Sorry. I apologize. Can I walk
What did he?
around
What
this
was the
way
question?
and actually film it better? I don't want darkness because you're not dark. Ooh, there she goes. There she goes.
What was the question?
What are you filming? You filming me filming you?
Well,
You
he is
filming me
little,
filming you?
but not that little. That must have been a tight squeeze.
What's the latest thing you've done me wrong by?
Man, I watched porno. And wait. It stopped.
My husband.
Also, I was watching porno. She don't like that.
So you kill him over?
Shrugging my shoulders or anything like that. Like it's not no big deal.
After you begged and pled and cried.
Yeah.
We trust you.
I know. I'm not shrugging my.
Say it. Beg.
Yes.
Pled. Cried.
You begged.
I didn't. You did.
Well, whatever. I know. Okay. Yeah, I did.
Say it.
I begged and
pled
and
cried
for
me to trust you.
For you to trust me.
But again, I'm not sure. Did I watch porno again? Yes, I did. But okay.
But why is she
This is a video
filming
starting with 3BB
him
0C.
forcing him
Metadata
to
shows date modified
confess?
12/29, 12:36 p.m. of 2019.
I'm really struggling with this. This is worse than Amber Heard,
So you remember this?
or maybe
So you
equal.
remember this? Are you drunk right now? How much alcohol did you drink? You're slurring your words. You're sleeping up against the door right now.
Yeah, because I want to be next to you.
Did I not tell you to not bother me?
Yes, ma'am.
So what is it you come up and do? What time is it right now? It's 1:20 a.m.
She's pissed off because he woke her up.
I haven't bothered you since then. I just go to sleep.
But didn't I tell you before at 9:30 to not bother me at all?
Yes.
Because why?
You have to work tomorrow.
Nope. Because I've been up since 4 a.m. since yesterday when you fucked with me.
Yes, ma'am.
I pity him. He's
I
a
know
drunk.
how much vodka was in that bottle.
But she's.
And what's the bottle now?
Kind of to throw it out.
What does that mean?
One more drink.
The bottle's empty. I know how much vodka was in there. And then for two people to have a really good time.
He's pulling
And who
away
drank it?
from her.
I want it to be documented that I'm leaving you, which means that you're getting out. You're getting out. You're getting out.
Nobody's leaving nobody. Stop.
Tori, if you can't handle it, it's okay. You can leave.
And the reason why you were even downstairs and weak enough to get drunk was because you don't give a shit about me. You don't listen to what I say. Special things that I keep on my front page of my phone so I remember to tell you about it because of how special and fun it is. I always bother you. I always bore you. You don't listen to me. Yesterday was my first day of work, remember? And I ended up 90%
You know what? Maybe
hearing
he
about
drinks
your day
because
and
of her.
10% about mine.
You don't bother me or anything. Sometimes you just.
Exactly, Toy.
You overwhelm me. That's the problem. You overwhelm me.
By telling you about my first day of work?
No, dude, you just overwhelm me about every other thing smooth. Just, first day of work.
So I'm overwhelming you by telling you about the fourth highest paid baseball player. That's a client of ours.
I'm not starstruck.
I don't even know who the guy is.
I don't need.
So the reason why, so you fully admit now that you didn't care and you did brush me off in the car, midway sentence, because you're not into baseball.
No, I didn't. I'm just saying.
I want to go to sleep. Go downstairs. I'm leaving you, and I'm going to try and cancel plane tickets.
No.
Because I don't do special things for people like you that are doing this, like, to me, after I asked you at 1:21 in the morning. I wanted to be asleep. I wanted to stay asleep, which is why I got into bed at 8:30. I told you not to step foot in the bedroom. So what do? Nonetheless, you're drunk. The amount of alcohol, I know how much was alcohol. I know how much was in there. That's why you're I could smell you in the bed before you actually got me up.
Demasculating. He has totally demasculated that man.
You're just.
I think this is the most damning video right here.
Leave me alone.
Okay.
You're not gonna remember shit. Okay.
Yeah, okay. Well, I'm not doing nothing right now.
Get away from me. Get away from me.
Why don't you get away from him?
You do everything to me all the time. All the time. Heartache and pain is what you cause me. Heartache and pain.
Okay.
Keep going.
Look how skinny his legs are. Damn.
And I dare you. I dare you. I dare you. You get on your fucking little bike and go to fucking work tomorrow. Don't look at me. Don't come close to me. Don't touch me. Do you understand?
What do you mean?
As of this moment, and until I can get you out, get the fuck out of here. I dare you.
Okay.
Look at it.
But she oh, she's hitting him.
Like,
He did
get
come
away from
after
me.
her.
Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder. I will scream bloody murder. Get away from me.
Dude, nobody's doing anything.
I'm gonna fucking hurt you.
Nobody's doing anything. And you're filming it.
Let me go.
Nobody's doing anything.
I'm asking you, George, to get away from me. Please get away from me.
She antagonized the hell of him.
Yeah, I am. That was your function, dude. Malfunction. No, your malfunction is you, dude.
Okay, whatever you say.
She's antagonizing this. She could have gone in her room and shut the fucking door. Oh. Freaking door.
Holy shit, the whole hallway just reeks of you up here. First
I'm gonna
it's
have to
shit,
delete
now
that.
it's alcohol. Don't step foot in this bedroom. I can't even breathe. Like, it's disgusting. Like, it's disgusting.
Don't worry about it. I'll figure it out. Go be blessed.
Keep filming when it's looking like. Good night, Sarah. Love you.
I'm sorry I
I
should have
don't
said
like
that.
you.
I'm very frustrated with this.
I don't like you. I don't want to be with you.
We don't know if she was like this behind the camera that antagonized him. We don't know. She could have been like this. She could have, and he reacted. We don't know where her behavior behind the camera was. But look, he's not aggressing now. She is. Jeez. It's okay, baby girl. Nobody's in your bed. Why don't you go get in your
Next
bed?
video starts 456. That's the only file that starts with that.
I am so sorry, y'all. That was so unprofessional.
2019.
She's pushed me to that point.
And I'm not gonna have no Hindenburg situation, no Titanic situation, okay? So it's gonna be a good day. Yes, I'm missing my mustache right now. And later on, everything's gonna go off. Truth, facts. Truth and facts. All of this is gonna
Zach,
be messing
you
later
want to
on.
be
We'll take
married to
another
that?
video again
You
later
want
on
a
when it
piece of
happens.
that, Zach?
Love y'all.
I feel
We're
bad
watching
for
this
him.
video.
No.
He may be an alcoholic, but dang.
Not approved.
The FDA says it's approved.
Oh,
So it's
Tori,
gonna
is
be
that
a
for
day
the
all
C
day.
word?
Yes, it is. Even when
All day.
I shave all of this
All
off.
day.
Yes. Even when I shave all of this off.
All day.
It's gonna be an amazing day.
It's what time right now?
Shaboing
I would
boing.
say 9:30. 10 o'clock, maybe.
Shaboing boing. That's what we're doing later on.
She wants him to go to bed when she wants to go to bed. Then get your butt up and go to bed. Why does he have to be treated like a kid?
Stop filming now.
Not good enough.
It's gonna be a great day. Today's a great day to have a great day.
We had a good day. Mm-hmm. It was a good day.
Boom. Cut. Somebody come in with the. Can somebody come in with the? Can you not?
Can you not? So, the more I say bad words,
Next file is image
better for me.
093.mov. Metadata date modified 1/3/2020, 2:48 p.m.
It's Switch 13 and I asked him not to play music. Because I told him that I was gonna go to shit.
Next file is image img_0975.mov. Metadata shows date modified January 19th, 2020, 2:58 p.m.
Time. Sirens, 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 sirens. Sirens and sirens and sirens. And this cop car.
How about you get an umbrella and call me Camille underneath it?
Yeah, how about we forget about that? No, we won't.
I'll never be.
No. How about we keep going on? Okay, how about this? When beautiful Lucas is here, we don't listen to none of that. I don't want to hear sirens. It's just beep, 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 all that, whatever. I want to listen to that. It's every single day. Beeping and we hear enough of it out here in reality.
Are you gonna be nice tonight?
Yes. Yes. I promise you. I listen to.
Go for a walk.
By myself?
Yes.
No.
Go for a walk.
No, I'm just gonna chill out. If that's the case, I'll just chill out. So much like this.
Don't ever be a woman.
How can I be a woman?
Don't ever.
I can't. But I can somewhat understand.
Don't ever.
I can somewhat understand. Somewhat understand. I can somewhat understand, yes, where you're coming from. But when you have a child and it's like right now, this is too much. But we had a blast with them. Amazing.
Then you got out of sorts and pushed me, and you stole my phone and called Brent.
Why is it that I got out of sorts?
You pushed me.
I pushed you. I didn't push you. How do I get out of sorts all of a sudden? I don't want to hear it.
You drink too much and you're upset.
I drink too much.
Go get your fuck card shit.
What are you talking about?
Your retard paper. Don't hit women.
Have I hit you? No. So where are you going with this?
I'm turning this off.
Turn whatever it is that you have off. I get it. You can film me, take a picture of whatever you want.
You can tell you're automatically drunk.
I'm not doing
Do I ever get a button? No, I don't.
I'm not doing anything to you.
No, I
Sarah.
never do.
I'm not doing anything to you, Sarah.
That's my name. Don't wear it out.
Sarita. I'm not doing anything to you.
She says that there?
Yes.
It's not a yet. I will not.
Mr. J.
It is 5:28, and we have 3 minutes and 49 seconds of videos. If the jury is capable of staying.
I got a thumbs up from the jury. You may proceed, sir.
I'll be right back, y'all.
Next image or movie is img_1011.move. Metadata shows date modified 2/2/2020, 11:42 p.m.
I understand. This is what happens. I'm going upstairs to ask for where my car keys are. Because it takes me all the time. Where are my car keys? Where are my car keys? Where are my car keys?
Where are you at with that? What are you talking about?
No, they're not. You took them.
Sarah, I didn't see your car keys. Damn it.
Where are my car keys?
Where they at? All the time. What in the world are you talking about? They're in the. They're there with it.
No, they're not.
Sarah. They're at the.
No, they're not. You took them. And watch you walk away with them.
Why would I take your freaking car keys?
Oh, you're not gonna curse now?
What are you talking about?
You took my car keys.
I didn't take your car keys.
You did.
Movie starting with file name B51, long file name. Metadata shows 12/29/2019, 4:04 p.m. modified.
I'm gonna go to court and I'm gonna tell the judge, listen, my fiance has nothing to do with it. It's all my fault. We were both drinking and it got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. Never been in trouble in her life. She has a 7-year-old son that she loves and cherishes.
A blind box interior.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than where it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She especially.
Especially her. So please, if you can,
Dismiss
this case.
Close.
Drop it. She is not the type of person.
Is she telling him what to say?
She's a great person.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. I love you to death. And I hate that we're going through this.
Sonnet.
What?
And they could.
Good, I love you. God will prevail and will take us out of this situation.
I want to hear from Jules on this. These videos.
That'll be it for today, Judge.
All right.
Holy hell.
Members of the jury, it is 5:33 p.m. I thank you again for your time and your service in this matter. I'm going to give you another instruction before I discharge you for the evening. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we'll see you again tomorrow morning here at 9 a.m. and 12 Alpha. Thank you so much.
I feel more horrible for him than I ever did. This really shows the crap he had to deal with her. I as a jury could do nothing but convict at this point.
Thank you. Y'all can take a seat. Thank you.
Yes, in that one video, but we don't know
State,
if she
how
went
much
like this.
Additional presentation do we
hold it and go
anticipate
like
tomorrow,
that,
sir?
and he jumped.
Just reading from the 108-page PDF that was on that last exhibit. I haven't practiced reading it in front of the mirror, so I'm not too sure, but not too long.
Okay. 40? Okay. All right. And then you'll be resting at that point in time, correct?
Yes, sir.
All right. Defense, what, if any, positions do you have at this point in time?
I don't
I'm
think we'll put on a service level, but we'll think about it overnight.
Okay.
But I anticipate that.
Okay. I'll certainly let you stew on it this evening. I know it's been a long day for all of us. Where are we and how do we want to address the jury instructions? Because that is going to take some time.
I say, I was thinking we should have had the jury come in at 10. Try to take care of that ahead of time.
Well, the other alternative that I can suggest is I can be here at 8. I can get here at 8 and we could start working on jury instructions at that point in time, at least so we can move forward through some of it. And then we could try to just move forward from there. I'm here for y'all. You tell me what you want.
It's fine with starting charge conference at 8.
I mean, my worry is it's going to take us some time. And if we start at 9:40, and it's going to take some time to work our way through these jury instructions. I don't want them sitting back there for 2+ hours just hanging out. We can at least get ahead of that.
Could we let them know to come in later?
They're still here. I'm fine with that. State? They're gone. Okay.
What I'm hearing is maybe closing arguments start at 1.
Yeah, that's possible. That's possible if we can get through all the instructions.
And I won't be here.
Mr. Henderson?
Well, I will and I won't.
How about 8:30?
I'm up at 5:30. Makes no difference to me. All right. 8:30 it is. We'll see you all at 8:30 tomorrow morning, and we'll start to go through the instructions. Anything else, State, we need to address?
No.
State or defense? All right. Thank you all very much. We'll see you tomorrow morning at 8:30. We're off the record.
All right, guys. This is how tomorrow's going to go down. I'm going to have this up and running, and Miss Kevin will be monitoring for technical stuff. I will be popping in and out because I have a wedding. I have to be doing makeup at 11:45 my time, which is 12:45 their time. And then the wedding's at 3 my time, which is 4 their time. Oh yeah, this is going to be real fun. So, thank you. I'm a makeup artist. Been doing it for 30 years. I tonight have to get all my schoolwork done that's due this week because I won't have time to do it tomorrow. So I'm going to be doing all that tonight. And then tomorrow morning, once this goes live at 8, I am going to have to get my own makeup on and then pack up all my stuff and get it ready to go. So that said, I appreciate y'all's understanding. Zach and Ronnie will probably be the 2 main mods. I may have other mods on. I do not know. All of our mods will be on, I'm sure, at one point or another. So with that, yeah, I'll be in the chat. I'll be listening when I can. And then the wedding's at 3. And in between the makeup and all that, I'll be helping my sister because she was supposed to be the wedding coordinator. And now she's kind of struggling a little with that. So she is, but she's struggling. So anyway, so we're going to hang it up. We will catch up with the melody trial. I may watch some of that or have it on while I'm doing my homework and see where that went. No, definitely was not all his fault by far. I think more than anything, she pushed him to it. But anyway, y'all have an awesome day. And I will see y'all in the morning. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.